ಬಂತು. ಆನ್ ಆಗಿದ್ಯಾ? ಇಷ್ಟೊತ್ತರ್ಗೂ ಆನ್ ಆಗ್ತಿರ್ಲಿಲ್ಲ, ಅದಕ್ಕೆ ಕರೆದೆ ನಾನು ನಿಮ್ಗೆ.
Okay. ನೀವು ಸಾಯಂಕಾಲ
ಇವತ್ತಿನ ಫಿಲಪ್ ಕ್ಲಿಯರ್ ಆಗಬೇಕು ಜೀವನ ಮಾಡೋದು
ಸರ್ ಜಡ್ಜಿಗಳು ಬೇಡ ಸಿಸ್ಟಮ್ ಬಂದು ಡೆಲ್ಲಿನೂ ತೋರಿಸಿ ಹೈಕೋರ್ಟ್ ನೀವು ಹಾಕಿದ 3 ದಿನಕ್ಕೆ ಮ್ಯಾಟರ್ ಕೊಟ್ಟು ಬರದೇ ಇದೆ ನಮ್ಮ ಪ್ರೊಫೆಷನ್
ಇಲ್ಲ
7 ವರ್ಷ
ಮದುವೆ ಇಲ್ಲಿ
ತಗೊಂಡು ಹೋಗೋದೇ ಬೇಕಾಗಿಲ್ಲ ಆ್ಯಂಡ್ ನೀವು ಇದು ತೊಗೊಂಡು ಹೋಗ್ಬೇಕು ದುಡ್ಡು ಅವ್ರಿಗೊಂದು ಮನೆ ಅಲ್ಲೆಲ್ಲೂ ಹೋಯ್ತು ಪಟ್ಟಾಯ ನಮ್ಮ ಗಿರಿಗೆ ಹೋಗ್ಬೇಕು ಸುಮ್ಮನೆ ಸೀನಿಯರ್ ಸಿವಿಲ್ ಜಡ್ಜು ಸಿವಿಲ್ ಜಡ್ಜ್ ಕೊಟ್ಟು ಹೋಗ್ತಾರೆ ಪೀಸ್ ಆಫ್ ಪೇಪರ್ That's the beauty of talent. Copy online. Alternatively, with the course email.
digital signature
And you don't even have to wait. It will automatically. ಅಲ್ಲಿ 7 ವರ್ಷದ ಮುಂಚೆ ಆಗಿದೆ ಪೇಪರಲ್ಲಿ ಬೇಕಾ ಡೈರಿ
not take file also inside because for the screen or your case come the submission is there
ಸ್ಕ್ರೀನ್ ಅಲ್ಲ
non tab requirement is
18th ಇವತ್ತೇ ಸಿಗ್ತಾರೆ ನಿಮ್ ಟೈಮ್ ಬರಕ್ಕೆ. ವಾಟ್ ಇಸ್ ಕರ್ಗಾಗಿ ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ? ಟುಮಾರೋ initiated, so you have to file your objections. You can't come for that stage. Mr. Counsel, we'll have to start imposing costs on all these matters now. If you come unnecessarily to the High Court, we'll have to do that. Don't make this into a Tahsildar's court. You have to executive magistrate yarappa Tahsildar tanne. Ali hogi you have to file. I will take. You have put on notice. Who has ordered you to vacate? Yav Institute, Mr. City. NITK. Would it be authority? NITK would be authority. Any standing counsel? Please serve it on him tomorrow. 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 Yen urgency ಏನು? It's been refused. So what is the urgency in refusal, madam? Regular course. We have to issue notice, then only it can be taken up. It can't be, there's no interim order that we can pass. It will come in the regular course. Fresh matter thane, 3 days al baratte. Madam, every day we have been telling you pending matters, please don't mention. It will come in serious term. Kodi. What is the urgency? There's also already a work order issued. But you just made a submission that has been issued. Monday 3rd. See, everybody comes up with the pending matter. We can't distinguish which is urgent, which is not urgent like that. For that, we'll have to spend 1 hour. ಯಾರು ಮೇಂಟೈನ್ ಮಾಡಬೇಕು? So ಇವಾಗ ಏನು, what is the relief you are asking for? That will have to be heard, Kodi. It will be taken up when in serious term. Yes.
Connected matters are listed at 2:30 minutes today. This may also be connected minutes.
Sorry?
Connected matters are listed today minutes. This is regarding Kannada Sahitya Parishad. This one matter was disposed minutes. We filed recall and reopen.
Disposed matter you filed?
No minutes. It was dismissed for non-prosecution minutes, for non-compliance of office objections. Please minutes. We filed recall of the order minutes. The connected matters are listed today at 2:30.
You won't be able to take it up today, Monday 3rd.
Please minutes.
Matters of 16-17. The office need a clarification. We have sought for
16-17.
16-17. The office needs a clarification from your lordship, since your lordship is a senior judge among the other rosters. We have sought for washing of the notice issued by the forest officials and the FIR registered by the forest officials. Now the office has raised objections stating that it should be moved before 482 roster.
But 16-17 is not our roster.
The office needs a clarification to which court hall should be allotted the matter.
Why would the office need a clarification? Clear. Wherever it is to be listed, it will be listed.
ನಮ್ಮ ಮನೆ ಮುಂದೆ ಅನಾಥರೈಸ್ಡ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಫುಟ್ಪಾತ್ ಮೇಲೆ ನಮ್ಮ ಮನೆ ಆಪೋಸಿಟ್ ಅಲ್ಲೇ ತೇರು ಮನೆ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಅದು ಹೈಕೋರ್ಟ್ ಇದರಲ್ಲಿ WP 8190/24 ನಲ್ಲಿ ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್ ಡೈರೆಕ್ಟೆಡ್ ಅಸಿಸ್ಟ್ ಕಮಿಷನ್ ಟು ಅಂಡ್ ಕನ್ಸರ್ನ್ ಅಥಾರಿಟೀಸ್ ಟು ಇಂಪ್ಲಿಮೆಂಟ್ ದ ಆರ್ಡರ್ ಡೇಟೆಡ್ 7/9/2023 ಟು ರಿಮೂವ್ ದಿ ಸ್ಟ್ರಕ್ಚರ್. ಇಲ್ಲಿ ತನಕ ತೆಗ್ದಿಲ್ಲ, ಪೇವ್ಡ್ ಫುಟ್ಪಾತ್ ಮೇಲೆ ಕಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಹ್ಮ್.
ಓಡಾಡೋದಕ್ಕೆಲ್ಲ ಭಾರಿ ಕಷ್ಟ ಆಗ್ತಾ ಇದೆ.
ಏನ್ ಕ್ಲಾಸಿಫಿಕೇಶನ್ ಏನು?
GMRS ಇಲ್ಲೇ ಇದೆ ಸ್ವಾಮಿ,
ಎಲ್ಲಿ ಪ್ರಾಪರ್ಟಿ ಎಲ್ಲಿ?
ತರೀಕೆರೆ ಸ್ವಾಮಿ.
ತರೀಕೆರೆ ಕೊಡಿ ಅಂಡೆ.
ಅಲ್ಲಿ have to.
ಹಾ.
Two repetitions. In both the repetitions, we have the petitioner. I filed the memo earlier also.
Are the parties going to come?
Yes, ma'am.
When will they come?
We have to do.
Friday 2:30 ತಗೊಳ್ಳಿ ಅದು.
Friday 2:30.
ಎರಡು ಇಲ್ಲಿ ಬರಲ್ಲ, ಈ ಕೋರ್ಟ್ ಅಲ್ಲ. 24 ಇಂದ 24 onwards.
ಲೇಔಟ್ ಎವಿಕ್ಟ್ ಮಾಡಿ ಇವತ್ತಿಗಿದೆಯಾ? ಇವತ್ತು ಲಿಸ್ಟ್ ಆಗಿದೆಯಾ? ಅಲ್ಲಲ್ಲಪ್ಪ, ಲಿಸ್ಟ್ ಇದೆ ಅಲ್ಲ ನಿಮ್ಮ ಹತ್ರ. ಏನ್ ಮಂಜುನಾಥ್ ಹಿಂಗೆ ನೀವು ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ರೆ? ಕನೆಕ್ಟ್ ವಿತ್ ನಂಬರ್ ಕೊಟ್ಟಿದ್ದೀರಾ? ಕನೆಕ್ಟ್ ವಿತ್ ಸೋನ್ಸ್ ಇವತ್ತು ಲಿಸ್ಟ್ ಆಗಿದ್ರೆ ಇವತ್ತು 2:30 ತಗೊಂಡ್ಬಿಡಿ, ಇಲ್ಲಾಂದ್ರೆ whenever it is listed. Yes, madam.
Because of ineligible members, bar exam pass ಆಗಿರೋರು, enrolled ಆಗಿರೋರು bar exam pass ಆಗಿರೋರು, ಒಟ್ಟಾರೆ ಸೇರಿಸಿ ಭಾಗ ಮಾಡ್ತಾರೆ. ಆದರೂ ಅವರನ್ನು ಸೇರಿಸಿಬಿಟ್ಟು ಲಿಸ್ಟ್ ಮಾಡಿಬಿಟ್ಟು ಎಲೆಕ್ಷನ್ ಆಗೋಗಿ they are elected also. Because of that, not the eligible members are not ready to participate in the poll.
Election is completed.
Election completed.
ಮತ್ತೆ ನಾವೇನ್ ಮಾಡೋದು? ನಮ್ಮ ಮುಂದೆ ಬರತ್ತಾ ಚಾಲೆಂಜು? ಸೊಸೈಟಿ ಆಯ್ತು, ನೀವು ಮಾಡಿ ರಾಂಗ್ ಫೈಲ್ ಏನ್ ನಿಮ್ಗೆ ತಗೊಳ್ಳಿ, ಮಂಡೇ ತಗೊಳ್ಳಿ, ಓನ್ಲಿ ಫಾರ್ ಡಿಸ್ಮಿಸಲ್ ಅಷ್ಟೇ. ಎಸ್, for consideration of interim prayer. Notice is served. 22nd ತಗೊಳ್ಳಿ. But it will come. What is the urgency for those matters? If there's some demolition, all those things you can move. Yes. It will come.
Adjournments. List number 1, page number 8, serial number 60. Page number 9, serial number 61 to 65.
60. Yes. Have you informed the petitioner and respondent?
No, I told you. Before I told you. Before I told you.
If you're not informed, please don't mention.
60.
If we're not adjourning, if you're not informed, we won't adjourn it. Yes, yes.
Page number 9, serial number 61 to 65. Page number 10, serial number 66 to 69. Page number 11, serial number 70 to 75. Page number 12, serial number 76 to 81.
81 government.
A short rate may be given, my lord. In this matter, only thing is we have to, there's an appellate remedy. There's an appellate remedy. They raised the question, who's the appellate authority? I have the notification. I am told that advocate has some medical, so
Just give
I'm
him
not,
the
yes.
Notification and they'll look into it.
Yeah,
They'll make the
next time, any week.
medical emergency. So when will he be back? That's why we're asking when he'll be back. August end. Nitin can't be away for 1 month. It's not eye surgery. It's submitted that the arguing counsel has undergone an eye surgery. And as such, 4 weeks time is sought for. Released on 20 August end.
10th of
1.5 months.
ಇಲ್ಲ.
17th August is okay. 17th August. Interim order earlier granted is extended till next date.
Page number 15, serial number 82 to 86. Page number 16, serial number 87 to 92.
Serial number Any adjournment will be second week of August, madam. You want adjournment to second week of August? Then take it up today only. Yes.
Page number 17, serial number 93 to 97. Page number 18, serial number 98 to 104.
Mentioned after the.
Yes. Hmm? 72. Have you informed the petitioner? No.
Police.
Without informing, please don't mention.
La police. Seal number 72, GM police.
Yes, it is about that gold seizure.
Yes.
There was a lot of opposition last time by Suyo. So sorry, sorry, Purna Prasad.
Why would you?
Number 127 and
127.
131.
127 memo of withdrawal.
131.
131 memo of withdrawal. Liberty to? Is a tender matter. What is there to approach again once you withdraw? That would be a fresh cause of action, not on this. Yes. 107. Have you informed the respondents? So who has to comply with office objection? Have you informed the petitioner? I will alla inform ಮಾಡಿದೀರಾ ಮತ್ತೆ ಮೆನ್ಷನ್ ಮಾಡಬೇಡಿ ಪ್ಲೀಸ್ ಡೋಂಟ್ ಮೆನ್ಷನ್ ವಿತೌಟ್ ಇನ್ಫಾರ್ಮಿಂಗ್
My lords,
ಹಾ you are filing it today 128 learned counsel for respond number 9 submit that the report would be filed today relist on 17th at 2:30 p.m. 17th at 2:30 p.m.
my lords, list to serial number 5, my lords. It was mentioned that today senior will not be able to come for the matter, and it was requested for 16th, my lords. And it's confirmed by everyone, it would be posted on 16th, and it's posted today. If it could be
This is
posted
for
tomorrow.
Mr. Jaikumar Patil to make his reply.
Please, my lords, I've informed them. He also confirmed that it was said that it would be posted on 16th. If it's tomorrow, will be helpful, my lords.
List number 2, serial number 5, at the request of counsel for respond number 5, relist 16th at 2:30 p.m.
Much obliged, my lord.
List number 1, for being spoken to, serial number 1, Mohan Kumar D.
Mohan Kumar, this is a Gunda's matter. Gunda Act matter. It could not have come before us. We don't want to say anything more. It's your duty to keep us informed. It could not have come before us. That office also will direct them.
Net bench judgment.
It
very
has to go
clearly
only
said.
as a habeas corpus. Alone. We'll go by what council makes submission because we try to believe and trust.
No, his whole contention.
ಇದು ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ ನಮ್ಮ ಕೈಯಲ್ಲೂ ಮಿಸ್ಟೇಕ್ ಮಾಡಿಸಿದೆ A peril of the papers would indicate that the same relates to a proceedings under the Gunda Act. If that be so, it was the classification made is not proper. Registrar Judicial is direct look into the same and issue proper and necessary instructions such that the classification is made properly so as to list the matter before the appropriate court. Since the classification was made improperly and this court would not have jurisdiction to deal with the above matter, the order dated 23rd June 2026 stands recalled. Registry is directed to classify the matter in a proper manner and place it before the appropriate bench.
One issue, my lord, pursuant to this, your lordship's order, he's been released from the prison. This is even after confirmation of board and then government.
The order dated 23rd June 26 has been recalled. Respondents are at liberty to rearrest the petitioner.
Yes.
How much problem it happens? ನಿಮ್ಮ ಪೆಟಿಷನ್ ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ. And you also have to bring it to our notice.
Mistaken.
You even assuming Mohan doesn't know about it and he has not mentioned.
We should have been.
Only thereafter we get to know it. All of us have to discharge our respective obligations.
In fact,
So you can go ahead and rearrest.
let him, if he wants to surrender, my lord, your lordship may direct him to surrender.
In the event of the petitioner not surrendering, respondents are permitted to rearrest the petitioner. Surrendering by end of day 16th July.
Grateful.
Serial number 2, Jai Mohan.
Michael Matadi.
Typing mistake has happened because of my inadvertent. In the IA, your lordship, my land is in survey number 71, your lordship. Your lordship to look into the petition copy, main petition, your lordship. Paragraph 1. Kindly see the page number 5, your lordship. First paragraph.
Yes.
In the main petition. The petition above matter as well submits that they were allotted plots in the layout form by BDA. So in survey number 71, 1 acre, that is out of which 28.8 guntas for in this is what the survey number is my land. Even in the representation, you will may kindly see as per annexure F, your lordship, page 24. Otherwise 71 antane helide. First paragraph, page number 24.
1 acre, 37 guntas.
So illi what happened, your lordship, in the IA, corrected copies are furnished to the other side. I could not correct it in this IA. What has happened, wherever it is 71, 17th IA.
Allah, so therefore, my lord, even according to him, the error is in the IA, not in your lordship's order.
We'll have to. It happens, what to do. It's a genuine mistake. It's a what Mr. Mohan is pointing out is that, look, I've said it is 71.
My learned friend cannot say there's an error in the order.
He has not said it.
No, ultimately, your lordship has already observed that the issues, whether it's 70 or 71, it will be decided by the matter of trial. So para 4 and para 5, your lordship. Para 5 and 7 has to be corrected wherever 70 is there. In the IA, order on IA.
But IA number? IA number ಏನು, Mr. Mohan?
Para 5, your lordship.
IA number?
IA number 1 of, only 1 of 24.
1 of 25, direction. 627 direction. Yes.
At paragraph, your lordship may kindly see amendment, page number 5.
So everywhere it has become 70.
Survey number 71, where in 28 guntas, it's also 70 agogide. Similarly, again, to add in paragraph 8 amendment 71, but 70 is the second line. Only
So
these
now,
two.
why have you moved this matter?
My land is in IA nalli, paragraph 5, your lordship. Order on IA.
Order on IA, para 5.
Para 5, because para 1, para 4 I submitted survey number 71 document. Para 5, fourth line, your lordship. Survey number 70, as regards the acquisition has been made in favor of the railways. Proceedings have been so in respect of land in survey number. The petitioner having participated in said have above petition. The petitioner cannot claim any right in so far as 7 numbers is, there is no problem, your lord. So only question is para 7, your lord. A perusal of the amendment would indicate that the claim has been made in respect of survey number 28 guntas in survey number 70. Survey number 70 has been acquired. It is 71, your lord.
See, you have made the mistake in the application. Mr. Kamath has made a submission as per that. We have recorded that
Corrected.
submission. Even when you are submitting, we asked you
Assuming there's a-
thrice or four times if you remember it right.
Sir,
as to-
whatever your lordship, ultimately the merits of the matter will be decided only as para 7.
Whether it is in 70 or 71, whether there are any allotment made in favor of the petition or on matter requiring trial and hearing. How does it make any difference?
No, no, only this para 7 minor, what it says, your lordship, the documents which are relied upon by the learned counsel for the petition from and out of statement of objections filed by are relating to survey number 71.
Exactly.
But at the
that
top
is
of
why-
it, it is claim has been made as
That
a
is why
70.
we asked you 3 or 4 times. Are you
I have
sure
not
it is
made any
70?
claim on survey number 70. That's the thing.
And that is why we have left it open for 70 or 71, taking into consideration your interest. That will be decided.
No, only thing is, no, let the trial court decide whether it is falling under 70 or 71.
Correct.
As far as my land is, I'm clear, in the E also 71. My
Then you
claim
can't
is
just
71.
mention it for being spoken to.
Tomorrow, it should not happen without what the
You
question.
can't mention it only for being spoken to. You have to do something else. We can't tell you what you have to do.
No, kindly see, both these documents do not support, kindly see last, but para 7.
How the
last line.
IA still
No, no,
remains.
this word, both these documents do not support the content of learned counsel. for
Start
the-
advisory juice.
Also, sir, fall in survey number as regards have been.
Comes out very normally, but have to
Suppress
restrain.
it.
I'm leaving the court.
Yes.
Just,
No
only
advisory.
clarification is my land is in survey number 71.
Now you said what you
After-
want to say. The IA continues to remain as is,
Yes, sir.
where that mistake is there.
Yes, sir.
You have to do something about it.
Yes, sir. That is
That's
not,
how much we can tell you. Can't say more than that. ಏನ್ ಹೇಳಿ ಆಯ್ತು ಒಂದು ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ
para 5 ಅಲ್ಲಿ last line you lost. Para 5 or one thing is,
ಫೈಲ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ can't be more explicit than this now. Learned counsel for the matter has been moved for being spoken to. Submission of learned counsel for the petitioner is that by inadvertence, the survey number mentioned in IA number 1 of 25 survey number is wrongly being mentioned in IA number 1 of 25 as survey number 70 due to typographical error. It ought to be 71, which is what has been mentioned both in the writ petition as also in the representation submitted. He seeks for and is granted a week's time to file amendment application.
please.
Relist for being spoken to on 23rd July.
Oblige.
Fresh matters, serial number 3, Radha Krishna.
Mr. Radha Krishna. You take notice, Aditya, in this?
For respondent numbers 1 to 4, Your Lordship. Your Lordship, my instructions are that the work is already completed, so the matter has become infructuous as on date.
Oh, there's a 24 matter.
24
fresh
matter which has come today.
Compliance now made after 2 years.
8 times it has been listed, non-compliance.
None appears for the petitioner. Shri Aditya Singh accepts notice for respondent number 1 to 4. Notice to respondent number 5 is deferred for now. The submission of Shri Aditya Singh, learned counsel for respondent number 1 to 4 is that the work has been completed, rendering the above petition infructuous. None appears for the petitioner. If none were to appear for the petitioner on the next date of hearing, petition would be liable to be dismissed for non-prosecution, relist on 29th July under the caption dismissal.
Serial number
1 of
4,
24 is allowed.
For 498 proceedings, the quashing petition had been filed.
Huh?
The same is allowed, my lord.
Yes.
My prayer is that masking of my name in the e-portal and the respondent annexure C, my lord.
Washing has been allowed.
Yes, please, ma'am, before this. The same is compounded before this honorable court.
Lord AGA accepts notice for respondent number 1. ಇದರಲ್ಲಿ ರೈಟ್ ಟು ಬಿ ಫರ್ಗಾಟನ್ ಅಲ್ಲಿ ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾ ಇದಾರಮ್ಮ ಕೋರ್ಟ್ಗೆ?
Sharanjit Shetty.
But I'm for R2, my lord.
R2 you are appearing, Sharanjit?
I undertake for R3 as well, my lord.
R3 also. Sharanjit Shetty for R2 and 3. Google India.
Manu Kulkarni.
Manu Kulkarni for respond number 4. India Kanun.
Vedant Anand.
Hmm?
Vedant Anand.
Vedant so and so for respond number 5. Counsel for the petitioner serve 2 sets of the petition along with
Published.
on the said counsels. Yavat post agide adu? And 63 na 65 na. We'll give that date. There's a batch pattern.
Serial number 5. Venkatesh Sarbatti.
Non-acceptance. Non-acceptance, partial acceptance. Non-acceptance. And AGA accepts notice for respond number 1. Issue emergent notice to respond number 2 and 3. Returnable by 21st. Counsel for the petitioner is permitted to take out hand summons on respond number 2 and 3.
Serial number 6. Vijay Patil.
Yes.
Appearing for petitioner, my lord.
Yes,
I
sir.
have sought for mandamus to consider representation dated
What is your representation for?
for clearing the bills, my lord. Petitioner is the hospital, my lord. He has entered into MOU with respondent number 2, a trust formed by the government, my lord, to pass on certain benefits to the citizen.
There's a tender or anything, or there's an agreement?
Agreement, my lord. MOU, my lord.
MOU.
My lord. There is one more connected matter, similar matter
Respond
pending.
number 2, is there a standing counsel? Or will you accept notice?
I'll accept.
Now, DG accepts notice for respond number 1 and 2. Petitioner is before this court seeking for the following reliefs. The petitioner claims that the petitioner, being a hospital, had entered into a memorandum of understanding with respond number 2 with an intention to make available medical benefits to the citizens of the state by treating and diagnosing select ailments. In terms of the memorandum of understanding, the petitioner claims to have rendered several services and raised its invoices. However, despite which were not paid, hence the petitioner had submitted a representations on 24/6/23 at Annexure E. Where is E1? Sorry, 24/6/23 at Annexure E and 20. Both of them are the same date.
Same date, my lord.
Representation dated 24/6/23 at Annexure E series, which has also not been considered. It is in that background that the petitioner is before this court seeking for the opposite relief. Whenever any contractual arrangement is entered into by the state or it's the trust to how would it come? State or any organization promoted by the state, it is required for the said authority to act on the said memorandum of understanding and release the amounts which are due. In the present case, when the amounts were not released, representation was submitted at Annexure E series in the year 2023, which have also not been considered. These representations were required to be considered and necessary orders passed within a reasonable period of time, either accepting or rejecting the representation. Needless to say, if an order of rejection were to be passed, it ought to have been accompanied by reasons. None of that having been done, the petitioner is left with no option. As such, this court passes the following order. Writ petition allowed, a mandamus is issued directing respond number 1 and 2 to consider the representation of the petitioner at Annexure E series within a period of 30 days from the date of receipt of a copy of this order in terms of the memorandum of understanding entered into between the parties and any other contractual documents. It is made clear that this court has not expressed any opinion on the entitlement of the petitioner. The same would have to be decided, ascertained on the basis of the contractual documents.
Serial number 7. Yeah, Purna Prasad.
Yes, Purna Prasad.
Lord, here in this, complaint was given to the Commissioner of Police. Based on certain involvement by the police on the issuance of checks and other, issuance of checks and other documents.
You can pull it up. You don't need to bend.
Yes. I was taken to police station and I was made to give checks at midnight. And immediately I brought it to the notice of the Commissioner of Police, and till now, no action has been taken.
Is there a serious allegation made? And AG accepts notice for respond number 1 to he seeks for and is granted 10 days time to obtain instruction, file the affidavit of you have not made CCB a party.
I'm not made CCB as a matter because they didn't had any complaint per se to furnish. They have not given me the complaint, but I was taken by CCB in the midnight.
Of respond number 2 as regard the serious allegations which have been made, released on 4th August.
Serial number 8, Raja KP.
As per annexion A, Gadipar order was passed by the second respondent
Gadipar order.
for period of 12 months, my lord. Kindly see page number 19. Not given any opportunity to engage the council or 22/1/2026, they called for inquiry on the same day.
Same day they have passed.
Same day they have order passed.
We'll remand it and AG accepts notice for respond number 1 to 5. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that a show cause notice having been issued by the respondent number 2 to appear before respondent number 2 on 22/1/26. The order was also passed on 22/1/2026 without affording an opportunity to the petitioner to file a statement of objection and or to submit and or to make his oral submissions. The same is borne out by the records inasmuch as the notice has been issued calling upon the petitioner to appear on 22/1/26 and the order has also been passed on the very same day. In that view of the matter, it is clear that a clear ex facie that there is a violation of the principle of natural justice. Hence, this court passes the following order. Writ petition is allowed. Certiorari so-and-so is quashed. The petitioner is liberty to submit his reply, which reply shall be so submitted by 11:30 a.m. on 27 July 2026. The petitioner shall also appear before the second respondent at the said date and time. Respondent number 2 is directed to consider the objections filed, offered an opportunity of hearing to the petitioner, and thereafter pass necessary reasoned order.
Serial number 9, V. Shivkumar.
Here for petitioner,
Yes.
challenging the order dated 15/7/25 passed by the respondent number 2, my lord. Allow the appeal filed by the respondent number 5 to cancel the gift deed. The respondent
Prepare for respond number 5, my lord.
Respond number 5.
Yes, my lord.
Yes.
I filed a case.
The
Who are respond number 4? Who is respond number 4?
Let's the petitioner
Daughter.
and respond number 4, where the respond number 5 gifted the property. 4 is the daughter. 4 is the daughter, my lord.
So notice will have to go to
4.
And AG accepts notice for respond number 1 to 3. Shri Arvind then, who has filed caveat for respond number 5, accepts notice for respond number 5. Issue notice to respond number 4. Emergent notice returnable by
my lord, status quo may be granted, my lord.
just on by 12th August.
Till next.
The petitioner and respond number 5 are restrained from any manner dealing with alienating.
Let's one submission, my lords. My lords, he is aged about 88 years, my lords. And they have ordered, he is a cancer patient, my lords. He has thrown away from the house and my daughter is taking care of the respond number 5, my lords. And my lords, the deputy commissioner also ordered for a maintenance for 10,000 rupees, my lords.
I'm paying the
Till
monthly
today, they
maintenance.
have not paid, my lords, and they are not even looking after him, my lords. That is only grievance,
I'm
my lords.
paying that
If they are
every
looking
month,
after me, my
10,000
lords, I
or
have nothing,
10,000 every month, without fail, I'm paying them, my lord.
Where are the
nothing has been paid, my lord.
The
How have you paid it?
assistant commissioner passed the order, the
How
part,
have you paid it?
my lord,
Ing kottidira, how did you pay the money?
through online, my lord. I
Sure,
will, I will produce the documents on
When
next
will you
date.
produce it?
Next date of hearing, my lord, please.
Next date of hearing is today only at 2:30.
My lord, that's some difficult with the
There is no
petitioner is
interim
not.
order unless you are able to show that.
Please, my lord.
If you want next month, we'll give you next month without interim order.
Next week, my lord,
But
kindly.
you
Kindly
get
have it.
baratar. Counsel for the petitioner seeks for and is granted a week's time to place on record the details of the payment made by the petitioner to the fifth respondent. Relist on 30th July.
One set of copies, maybe.
Copies good.
Please.
Serial number 10.
Yes,
That's motor vehicle claim petition, Milad's limitation issue.
Limitation.
It's pending before the Supreme.
Then limitation disposed.
Much.
11.
Petitioner, my lords, petition seeking expeditious investigation, my lords. I was digitally arrested by unknown men, my lords, claiming to be CBI. Unknown men who claim to be CBI officials, my lords, and got transferred 48.5 lakhs on 3 different occasions, my lords. I give.
Did you transfer 48 lakhs?
Through NEFT, my lords, I was asked to go to bank, my lords, but was instructed not to speak to anybody. On 3 different occasions, I.
Why would you transfer such kind of money?
My lords, believing them to be true officials, my lords.
Why? So you were trying to bribe them?
No, my lords.
Then?
They informed me that I was involved in Naresh Goyal's scam, my lords. And for obtaining bail, my lords, they asked me to transfer. They have also sent the documents, my lords. It's in annexure. See, my lords.
Somebody comes and tells you to transfer money, will you transfer it? 48 lakhs.
I won't do, my lords, but he's a retired person, my lords. I'm seeking expeditious investigation.
That is why it is investigate petitioner also. And AG accepts notice for respondent 1 and 2. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the complaint filed by the petitioner on 26/3/26 is still pending investigation. And it's for that reason that the aforesaid relief have been sought for. The complaint having been filed only on 26/3/26, it would, and the allegation being made as they are relating to certain impersonators arresting the petitioner and on their instruction, the petitioner transferring a sum of rupees 48 lakhs, it would be required for the respondents to investigate the matter properly, taking into consideration all the aspects in that view of the matter. Though it's only 3 months, it's a little over 3 months from date of filing of the complaint. Considering that the aspect of false arrest, including digital arrest, is plaguing the entire country, it is required for the authorities to take immediate action and investigate the matter so that these kind of events do not occur in the future. As such, this court passes the following order. Writ petition is allowed, mandamus is issued, directing the respondents to expeditiously conclude investigation in crime number 22, complete and conclude investigation in crime number 22 or 26 and file the report before the concerned court.
A time limit may be
If
fixed.
possible, preferably within a period of 3 months from the date of receipt of a copy of this one.
Grateful, my lords.
12. Rakshita.
I appear for the petitioner, my lords.
Yes, madam.
It's matter for parole, my lords.
And AGA accepts notice for respondent, it seeks for and is granted a week's time, relist on 22nd.
Please, my lords. Much obliged.
13. Somesha HD.
Yes, for the petitioner, my lord.
You have not served the copy on the ASD's office.
No, we will serve it.
If you had served, they would have been here. Shri Aditya Singh is directed to accept notice. Aditya is here, Aditya and Reshma. Ms. Reshma. Shri Aditya Singh is directed to accept notice for respondent. Counsel for the petitioner furnished 2 sets of the petition along with annexures on the said counsel. Released on 30th July.
Much obliged.
14, S.C. Shivramu.
Yes.
For the petitioner, Your Lordship. This is sought for a writ of mandamus seeking direction to consider representation at annexure N8, my lord. Petitioner society, my lord, applied for issuance of authorization to run a fair price depot. After meeting the conditions of eligibility, the petitioner society was issued with an authorization. However, at the instance of unsuccessful applicants, my lord, the login credentials were not issued by the respondents, and the petitioner society was not allowed to distribute food.
You have been given an authorization in Narayanalli. You want to do it in your premises.
Chirnalli, which is very close to Narayanalli.
Why should we not cancel your authorization if you don't want to do it in the place that it has been given?
For the reason that the unsuccessful applicants, my lord,
What
have
is your
been
right to
creating-
seek for this, Mr. Counsel? You have been given authorization for a particular location. You have to do it there. Now you want us to issue a mandamus to consider your representation to shift it to another place.
In the first round of litigation, I filed a writ petition to consider my representation.
If you don't
For
want
local
Narayanalli, we'll
food.
cancel it.
Thereafter, my lord, I gave a representation.
Agilap, how can you do that? This authorization is for Narayanalli because it's required there.
My lord, so in the second round of litigation, the court, honorable court directed them to hand over the premises so that I could run my business. But yet again, the villagers or
So you don't have a
successful
premises in Narayanalli.
My lords,
You don't have any premises in Narayanalli.
at the premises, my lord, the agreement was also executed in my favor. But at the instance of the unsuccessful applicants of that village, the owner who had rented the premises to me, he made a complaint before the police and he got the rent agreement cancelled. And therefore, I did not have a premises to run the business.
We can't issue this mandamus. Your authorization is for a particular place. It has to be there. So no distribution is happening.
No, my lords, the login credentials was not issued.
Good.
Because even though authorization was issued in my favor.
You want to make any submission, Mr. Shivramu? Yes.
Sorry, but what has happened, Your Lordship? The Narayanalli village point has been granted, there is no dispute at all. The one milk producer society at Narayanalli village, Your Lordship, belonged to one particular community. They filed an application in the name of Milk Producers Cooperative Society. They did not become eligible, therefore their application came to be rejected. On the other hand, there were other applications, my lord. Among them, my lord, I was entitled to, I fulfill the conditions of eligibility as required under class 5 ABC and class 6, my lord. I was given an authorization. After the issuance of authorization, my lord, I wanted to run a PD point at Narayanalli where I was given. At that time, what they did is, they pressurized the landlord who rented the premises in my favor on the date of filing the application, my lord. After the grant of authorization, how did you execute a lease agreement when we did not get an authorization? Therefore, you cancelled the authorization. They gave a complaint to the police and got cancelled the lease agreement. Then I approached the Istanbul court. This is the actual position in the village. We are unable to, they are not providing the rent because I am an alien to that village. I filed an application. Of course, we comes within the one panchayat. But in that village, they have taken it as an ego issue and they have taken a decision. It is in that background we filed a writ petition. This honorable court interfered and directed the joint director to provide an Anganwadi center which is available in the very same village. Even that also was not provided. He could joint director.
We can't shift the authorization
No,
to
I am
another
not saying,
village.
you
are asking for that.
Even the villagers of other villages, they have also filed a writ petition. It is yet to come, Your Lordship.
Nim prayer nodi. One, mandamus to consider representation to carry on business at Chirnalli
Yes, Your Lord. That's
instead
correct,
of
Your Lord.
Narayanalli.
Yes.
And mandamus to respond number 2, cancel the cards of Naranaldi.
No.
What
these-
kind of a prayer
No,
is
no,
this?
reason is, my lord, I am receiving a commodity, my lord. I may not press this application, my lord, this matter. Why I have written that, my lord? Why I have written that, my lord? I am ready to run the show, my lord, at Narnalli village. When the publics, my lord, who are receiving the commodity at the subsidized rate.
If you want to run it in Naranaldi, you can continue to
No,
run
I
it.
will
Naranalli.
continue, my lord. There
Otherwise,
is no
no.
doubt. Even now, my lord, I am ready to continue. The whole difficulty, my lord, I was, the lease agreement got cancelled, your lord. Nobody is coming forward to execute the lease agreement, your lord.
So then you surrender it, somebody will do it. Petitioner is
No,
before,
author-
learned
the
AG access
authorization, my lord,
notice
was issued to me.
for respond
They
number
have to
1 to
issue fresh
4,
notification, your lord.
PDO,
Can I request, my lord, one more petition is there?
Gubbi Taluk, A. Nagarajappa for respond number 5.
One more petition is there. my lord.
Connect with
Tomorrow,
WP number so and so. ಅದೇನ ಡೇಟ್ ಇದೆಯಾ ಅದಕ್ಕೆ
472 of 2000.
ಬರ್ತ್ ಕೊಡಿ ಡೇಟ್ ಇದೆಯಾ ಎನಿ ಡೇಟ್ ಇಸ್ ದೇರ್ ಫಾರ್ ದಟ್
ಇಲ್ಲ, ಅದು ನಾಳೆ ಬರ್ತಾ ಇತ್ತು ಅದಕ್ಕೆ ಇವತ್ತೇ ಹೇಳಿ.
ನಾಳೆ ಇದೆಯಾ
ನಾಳೆ ಇದೆ.
we list
May
tomorrow.
kindly peruse page 60, my lord.
We'll dispose
There is
both
an
of them
objection
together.
from the Narnhalli Gramada. Those residents have raised an objection.
I will
They
satisfy
want
your
to
lordship,
run
my
in
lord.
Narnhalli, my lord. And there is an objection from that village also, my lord. Kindly see the record.
You will have to issue a fresh notification.
And your lordships may kindly see petitioners, they are Chirnhalli Milk Producers Cooperative Society Limited.
How many licenses do they have?
Lord, that will have to.
Oh, we don't have only one license.
Only one.
Only one.
Tell us tomorrow. Find out.
I myself have. In the village, my
We
lord.
are seeing in all these matters,
No, I
Mr. Rao.
understand you. This is the first society.
Societies have 3-4 authorization.
I understand. That is also there, your lordship. I am not saying that, I am not disputing that, my lord. All that I am submitting, your lordship. You issued a notification. This court directed me to provide a premises, Anganwadi
We
center.
are not here to assist you to get a premises.
Under the
It's
facts
up to you to get your
Under
premises.
the facts and circumstances, your lordship. Even the police came to the police along with the Tahsildar and the joint director came. They were.
That is what the problem is. You are creating more issues
No, we are not creating, your lordship. I am only to, I am there.
and you are involving the entire state machinery for this. Now you want to involve the judiciary also.
I am there to discharge my duty, but they are not allowing it for Rasul.
Then surrender
I
it.
cannot say anything, your lordship.
Then surrender it. If you can't do it,
You have to
surrender.
issue fresh notification, your lordship.
Since you have not done it, we'll direct them to take action against you to cancel it and then issue
I will try to satisfy your lordship tomorrow.
tomorrow.
Yes.
Mallikarjunaya case.
Yes, madam.
Hearing for the petitioner, ma'am. I'm challenging the order passed by the first respondent, ma'am. Forest officer.
16(4)(a) subclause 3.
Survey has
Conservative
been
forest.
carried out, madam.
After 17, my lord, there is no denotification, my lord. All these matters, they have challenged the order of conservative forest, my lord.
Survey ಆಗಿದೆಯಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ ಸರ್ವೆ ಆಗ್ಲಿಲ್ಲ.
And that time not having instructions.
Carry out a survey in the present market, and if it's forest land, it is forest land.
May I make one submission, my lord? Daily, my lord, we are getting matters where the order of CCF is challenged, my lord. My lord, specifically, there is a finding, my lord, that it is not denotified after section 17, my lord. There is no denotification. My lord, Nirvane Gowda, my lord, as per the apex court judgment, my lord,
Yes.
any grant,
In revenue records.
it's a
also
reserved
some-
forest, my lord.
Is it part of the reserved forest?
Please, my lord, that is the finding of the,
They are saying it is not.
no, my lord, there is a finding, my lord.
Finding is that finding is what is under challenge.
Then we'll have to file, I'll file objections, my lord, but
File it. But their contention is it's not part of the forest land, and for that purpose, it's only a survey which is required to be done.
Yes, madam.
it may be ordered.
If in the survey it is found that it is part of the forest land, they can't have any other difference.
Please, madam. So they will make survey, my lord. ಸರ್ವೆ ಮಾಡ್ಲಿಲ್ಲ ಸ್ವಾಮಿ ಸರ್ವೆ ಮಾಡ್ದೇನೆ
But survey ಅಲ್ಲಿ forest ಅಲ್ಲಿ ಬಂದ್ರೆ ಏನ್ ಮಾಡ್ತೀರಾ?
ಅಲ್ಲ ಸ್ವಾಮಿ ರೆವಿನ್ಯೂ ರೆಕಾರ್ಡ್ಸ್ ಶೋಸ್
Para
2
26.
acres
Revenue records ಎಲ್ಲ
ರೆವಿನ್ಯೂ ರೆಕಾರ್ಡ್ಸ್ ಎಲ್ಲಾನು ಇದೆ.
ಲೆಕ್ಕ ಇಲ್ಲಮ್ಮ. ಒಂದ್ಸತಿ ನೋಟಿಫಿಕೇಶನ್ ಆದ್ಮೇಲೆ ಮುಗೀತು.
ಸರ್ವೆ ಮಾಡ್ಲಿ ಸ್ವಾಮಿ ಅದೇ.
Para 26 may kindly be perused, my lord, page 25.
Yes.
The appellant produced the notification issued in 2015 and requested that the encroachment on forest land to the extent of 3 acres or less not led to eviction. However, the notification pertains does not apply to the districts of Bangalore Urban, Bangalore Rural or Bangalore South District, as they fall either under GBA or under BMRDA jurisdiction. Therefore, the appellant has not demonstrated how notification benefits them. Therefore, the question of extending the benefit of the notification to the appellant does not arise. This is notification 2015, my lord. In para 25 also they say, my lord, another aspect of the matter is that once a notification is issued under section 17, no one else can claim right over the forest land unless a notification under 30 of Mysore Forest Regulation is issued or under 28 of Forest Act is invoked to denotify the land, obtaining the necessary government permission. Based on the grant, my lord, they are claiming it, my lord.
When was the grant made?
Understood. The grant was 1969. Originally, the Munsamappa son of Narsimappa was granted.
1969.
1969, ma'am.
After the 64 Act came into force.
Sale deed was done in 1976, ma'am. The Munsamappa
Subsequent,
sold a property
purchaser.
to one Sabarabi. Sabarabi was sold a petitioner's father, my lord, in 1976.
Grant certificate is 3569. Baralalama. Then you are admitting that it is a forest land.
Oh, my.
Why is the survey required when you admit it's a forest land?
No, no, so this is the grant land in 2 acres in the RTC also showing in 2 acres in father of the
My
petitioner.
submission is that it's forest land. Revenue Department has granted it to your predecessor on 3569. ಸ್ವಲ್ಪ ಸರಿಯಾಗಿ ನೋಡ್ಕೊಳ್ಳಿ. After the 1964 Act comes into force, then there's no question of Revenue Department granting without central government permission of forest land. So 69 is, your claim is under the revenue grant. Though in petitionally it's not forest land antira, everywhere else you have said it is forest land and granted to you. So there's admission that is a forest land admin survey bekagilla.
I'll get instruction, my lord.
Note. And AGA accepts notice for respond number 1 to 4. Copy are received.
Please, ma'am.
Counsel for the petitioner seeks for and is granted 10 days time to obtain instruction, make a submission. Since as per the records it is seen that the grant was made by the Revenue Department after the Forest Act 1964 came into force. A grant was made on 3/5/1969 after the Karnataka Forest Act 1963 came into force. Released on 29th July. Yes, madam.
Chief, appearing for petition, Lords. Lords, I filed the instant petition seeking quashing of Annexure A, wherein the first respondent has approved the scheme of administration for the management of Dargah and Admin Shavli management dated 20/2/2026, Millard. Millard, my father was notified as Mutavali, Millard. As per Annexure C, there is a particulars of work. My father was a notified Mutavali. The same has been notified in the Gazette by the respondent number 1 at Annexure D, Millard. My father, Inam Saab, he died on 23/2/1989. Subsequent to his death, Millard, from the over 24 years, Millard, I am the one who is incoming Mutavali by way of custom. I am the one who is managing that the Dargah.
What documents have you produced for that?
Oh, Millard, there is a parallel proceedings going on, Millard.
Where?
With respect to that. Millard, for the first time, respondent number
What
1 and 2.
What documents have you produced to show that you
Appeal, Millard. There is appeal, there is a CRP pending. So
Page number really, madam.
I'll come to that, Millard. There is a CRP pending before this honorable court in CRP 78 of 2018 at Annexure R, page number 151, Millard.
151.
151.
You have filed the CRP.
I have filed a CRP. We had initially filed an appeal, Millard. There was earlier,
Appeal has been dismissed.
appeal is dismissed, my lord.
So there's
In
no
the
order
said
in your
appeal also, my
favor.
lord, in the said appeal, there was an interim order to not to hold any election or selection on 12/6/2015. Pursuant to dismissal of the said appeal, my lord, I have filed CRP at 78 of 2018, which is pending before this honorable court.
Yes, it is pending.
Now,
Sorry.
even though it is pending, despite the pendency
Your
of the said,
application which had been filed in 2015 was dismissed
it was dismissed, my lord.
on 19 December 2017 and the
Yes,
prayer that you had sought for was
At page number, my lord, 108.
State Board of Waqf.
P. Usman.
P. Usman for respond number 1 and 2. Issue notice to respond number 3, returnable by
My
12
lord, in the
August.
meanwhile, my lord, on the basis of the said
One of
scheme of
26.
administration that has been approved, my
Madam,
lord.
you have failed in the appeal which was filed before the tribunal.
But there is a
there is
CRP
no
pending
issue.
before this honorable
It's only
court.
pending.
And subsequently, my lord, I have given a representation also to consider my representation as a mutawali by way of custom, my lord.
We can't
The
grant
said
you interim order, madam.
My lord, at annexure R1 30 of
Madam,
April
we can't
2026.
grant you interim order. You have not succeeded in 2 matters. Please wait. You have been waiting from 2015.
My lord, my representation is not considered. Now what is happening? The urgency in the matter is they are now finalizing a list of members and they are trying
You want us to pass an order of rejection?
My
We'll
lord, they are
pass an
trying
order.
to remove me from the. My
And
lord,
counsel for the petitioner insists on an interim order to be passed. Considering that an appeal which had been filed by the petitioners
my lord,
in appeal number
no
1 of
observation, my lord, I
2015,
will.
we are telling you what it is. You want to give us reasons, we'll give you reasons.
My lord, if it will be frustrated if they appoint a final.
Yes, next.
17. Veeranda Jitigudi.
Mr. Tigidi? General parole. And AGA accepts notice for respond number 1 to 5 released on 22nd.
18. Ganapati Shastri.
The petitioner comes from Archaka family, my lord. But since the petitioner has hereditary right, my lord, he made an application to respond number 4 to allow him to perform puja in the Chamundeshwari temple.
How is this writ petition maintainable, Mr. Counsel?
My lord, kindly see annexure D, my lord. My lord, earlier I approached this honorable court and this honorable was pleased to annexure D the order. It is passed by the respond number 3. Lord, by this order, my lord, I am allowed to perform puja in the Chamundeshwari temple from Varmalakshmi festival to Varmalakshmi festival. But overlooking this, my lord, the respond number 3, Tahsildar passed the order giving the puja right to some other person.
So you have to challenge that order. And that challenge will be before the commissioner.
No. Commission, no, even deputy commissioner also passed the order permitting to puja right.
But now there is an order passed by the Tahsildar.
No, Tahsildar order is illegal. Deputy commissioner and assistant commissioner both have passed the order in my favor. But overlooking that, my lord, he has given puja right to some other person.
Now there is an order which you are not challenged in these proceedings.
No, I'm not challenging. I'm not.
That order stays.
No,
Tahsildar's order is there.
No, that he has given puja right from Varmalakshmi 2025 to 2026. Now it is closing. From next year, I am permitted to perform puja. I don't want to disturb that now the person performing puja.
The Shastri, there is an order of the Tahsildar which is affecting you.
No, this ends up to this Varmalakshmi festival. Kindly see my prayer, my lord.
And AGA accepts notice for respond number 1 to 4. Anyway, there is no interim prayer. He seeks for his grant 2 weeks time to obtain instruction, make a submission.
Because one year ago it will be infructuous.
We cannot explain more to you. There is an order of the Tahsildar which you are not challenged. By issuing them notice, they'll come and say the same thing. By that time, do something about it.
No, my lord, Tahsildar order will end on this 2026 Varmalakshmi. After that, subsequently, I am praying. Lord, kindly see my prayer, my lord. May I read my prayer?
Who is the authority to grant puja rights?
Well,
The High Court or the Commissioner?
No, Deputy Commissioner has given right.
So you'll have to go
No,
there.
he has passed the right, my lord. He has passed the order in my favor.
Yes, next.
19. Nilesh Krishna.
Yes.
My lords, appearing for petitioners. My lords, this is a matter relating to the LOC. Whereas,
May I please, Lordship?
Yes.
My Lordship, I am appearing on behalf of petition in this case, my Lords. My assisting counsel is before my Lord's Lordship.
Yes.
Lordship, by way of present petition, my Lords, we are seeking direction to the respondent number 2 and 3 to not to restrain us to travel back to our home, that is in Dubai, and also to disclose the reason for issuing of LOC against us, my Lords.
You want the reasons.
And
Madhu,
also, my Lordship, and also seeking questioning of LOC if any being issued against me, my Lordship.
It can't be an interim relief.
Please, Your Lordship.
Madhu and Rao accepts notice for respond number 1 to 3. 3. 1 and 2 so and so accepts notice. Madhu and Rao for respond number 3. You received copies? Counsel for the petitioner to furnish 2 sets of the petition along with annexures on said counsel who are granted 2 weeks time to obtain instruction make their submission released on 30th July.
May I make a mention, my Lords?
Yes.
Your Lordship, the wife of the petitioner is critically ill, Your Lordship. My Lord's request for shortest accommodation.
A week's time released on 23rd.
Much obliged, Your Lordship.
1 of 26 is allowed.
Serial number 20. Srinath JB.
Yes, madam.
Good morning, my lord. I am for the petitioner.
Effect correction. And AGA accepts notice
Petitioners,
for respond number 1 to 6.
1 to 6.
He seeks fund is granted 2 weeks time to
My lord,
obtain.
I don't accept notice to the respond number 2, 3.
Moraji Desai resident government alva.
Allah, the Christ, the Karnataka, they come under the Karnataka residential. Christ, there's a panel.
And AGA for respond number
Siddharth Babura
1,
appears for
4,
them.
5, 6. Who is the standing counsel for 2 and 3?
Siddharth Babura appears. Christ.
Siddharth Baburao is directed to accept notice for respond number 2 and 3. Counsel for the petition served 2 sets of the petition along with annexures on said counsel. Released on.
But this is not the correction, my lord. This is the case where the estranged mother, the single mother, says that I'm entitled to change the caste of the child to my caste because he will be born and brought up as per the custom of the mother if she is the one caregiver of a child. The similar case also had come up. My lord, the apex court has held that it can be allowed. That I will give this judgment also.
Show us the judgment.
I'll present it on exit of your notice.
sir, even have give a judgment, sir, regarding like as the mother, like father has passed away very early, the child has been brought up and by the family community of the
Give us the judgments.
Sir, the list is here.
Para number?
Paragraph 43, sir.
Para?
43.
46.
43.
43.
Yes. As this is an intercaste marriage, the matrimonial house, they have not taken the family as, they are not even considered them as a family, sir.
Correct. This the
Kumbara community comes under which
BC.
category?
BC.
BC. So
Backward.
you can accept.
This is
Petitioner is before this court seeking for the following reliefs. The petitioner's mother got married to the petitioner father on 4 July 2006. The said marriage being an intercaste love marriage, the petitioner was born on 9th August 2007. Unfortunately, the petitioner's parents separated since their respective families did not accept the intercaste marriage. The petitioner was admitted to Vasavi Vidyalaya Higher Primary School. His caste was recorded on the basis of the caste of his father as Vakaliga Gowda. The father unfortunately expired on 10/9/2012 when the petitioner was 5 years old. Thereafter, the petitioner has been brought up by the mother, who belongs to the Kumbara Shetty community, single-handedly as per the customs and traditions of the Kumbara Shetty community. It is on that basis that the petitioner intends to change the caste on all the official documents from Vakaliga Gowda to Kumbara Shetty, since it is as per the customs tradition of the said caste that the petitioner has been brought up. It is in that background that the petitioner is before this court seeking for the aforesaid relief. Learned counsel for the petitioner relies upon the decision of the Honorable Apex Court in Civil Appeal number 654 of 2012, more particularly para 43 thereof, which is reproduced hereunder for easy reference. Though the discussion in said decision was as regards a marriage between a forward caste with a scheduled caste person, the reasoning of the Honorable Apex Court is clear, inasmuch as if a person is being brought up as per the custom and tradition, it's clear that it is open to the child of such marriage to lead evidence to show that he or she was brought up by the mother who belonged to the scheduled caste, scheduled tribe, by virtue of which a certificate, the caste certificate, would have to be issued indicating that the person belonged to, that the child belonged to the scheduled caste, scheduled tribe category. In the present case, the facts are clear, inasmuch as the father belonged to the Vakaliga Gowda community, the mother belonged to Kumbara Shetty community. The marriage being an intercaste love marriage was not accepted by the families, and the father and mother separated. The father expired on 10/9/2012. Thereafter, the petitioner has been brought up by the mother single-handedly without any support from the father's family. Mother belonging to Kumbara Shetty family. In the considered opinion of this court, it would not be necessary for a detailed inquiry or evidence to be laid. The fact that the mother has single-handedly brought up the petitioner would be sufficient to comply with the directions and or the dicta laid down by the Honorable Apex Court in Ramesh Bhai Dabai Naika's case. In that view of the matter, this court passes the following order. Writ petition is allowed. A mandamus is issued directing the respondent to consider the application filed by the petitioner for correction of the caste of the petitioner from Wakaliga Gauda community to Kumbara Shetty community in all official records, which shall be show carried out within a period of
4 weeks.
30 days from the date of receipt of
Your
copy.
Lordship, I just add, my lord, that's OBC 2A. Kumbar Shetty is OBC 2A.
Whatever is the classification. Why we asked you that was whether you can accept notice.
I can accept notice or Jagdish.
Jagdish should have to accept notice.
Very
That's all.
Thank you, my lord.
21.
Right.
Yes.
This is that challenge to the Gig Workers Act, Lord. Challenge to the Gig Workers Act of the state government.
It will have to get tagged to the other matters.
It has to be tagged. An interim order already granted, Lord, in that case.
Connect with WP number?
Lord, 19746 of 26.
19746 of 26.
The same interim order may be granted. There's an interim order granted in that case. A very detailed order, Lord, after quite a significant hearing.
Lordship said accused in the earlier matter.
No, that was not on the basis of the
That was
subject
because
matter.
of the council who had appeared.
Interim.
The benefit of the interim order dated 3/7/26 passed in WP number, the list in the above matter is drawing the attention of this court in WP number 19746 of 2026. The coordinate bench of this court has passed an interim order dated 3/7/2026. The benefit of the said interim order would be equally applicable and available to the petitioner in the present matter. Connect the matter with WP number 19746 of 2026.
Bill number 22. Shankar Reddy.
Petitioner is dead. The complaint under what provision? It's a document which has been fabricated. So under what provision have we given the complaint? Is it a cognizable offense?
Fabrication.
191 of
191. BNS.
what do you? BNSS. 191. One 191 is writing. One 191 ಬರಲ್ಲ. ಅದು ಪ್ರೊವೊಕೇಶನ್ ಇಂಟೆಂಟ್ ಟು ಕಾಸ್ ಯಾವ IPC ನೋಡ್ತಾ ಇದ್ದೀರಾ BNS ನೋಡ್ತಾ ಇದ್ದೀರಾ? Page number?
Page number 76. Page number 76. All the sections.
Wrong provisions ಹಾಕಿದಿರಲ್ಲ.
ಅದೇ ಸರ್. ಆದ್ರೆ ಪೆಟಿಷನರ್ ಬದುಕಿದಂಗೆ ಅವ್ರು ತೀರ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಈವನ್ ದೇ ಪ್ರೊಡ್ಯೂಸ್ ಬಿಫೋರ್ ದಿ.
If it is cognizable, they have to register.
Yes.
Non-cognizable, you'll have to go to the Superintendent of Police, then file a PCR. What you were given 191?
On the basis of the complaint, they have to.
IPC ಕೊಡಿ.
They have to lodge the
Mistake
FIR.
ಮಾಡಿದ್ದೀರಾ?
ಯಾಕೆ ಬದುಕಿರೋರ್ನ ತೀರ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತ ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಕ್ರಿಯೇಟ್ ಮಾಡೋದು.
ಅದನ್ನ ಮೂರು ಸತಿ ರಿಪೀಟ್ ಮಾಡಿ ಏನು ಪ್ರಯೋಜನ ಇಲ್ಲ. You'll have to say which provision.
ಫಾರ್ಜರಿನೂ ಬರುತ್ತೆ ಸರ್. ಸೆಕ್ಷನ್ 316, 318, 319.
193 IPC
92
ಅದು
it attracts me.
193 non cognizable ಇದೆ.
192 also it attracts me, giving a fabricated false
193 is non cognizable. What you alleged is a non cognizable offense. .463 ಇದೆಲ್ಲ IPC ಕೊಟ್ಟಿದ್ದೀರಾ ನೀವು, BNS ಅಂತ ಬರ್ದಿದ್ದೀರಾ.
IPC ಬಾರ್ IPC ಅಂತಾನು ಕೋಟ್ ಮಾಡಿದ್ದಾರೆ.
463
463, 465, 467.
non cognizable.
And also 468, forgery for purpose of cheating. And IPC 471, using false document as
471
genuine.
is cognizable. Only one offense, 471 is cognizable. Rest of it is non
Using
cognizable.
false document as a genuine.
All the allegations you are making and this one is non cognizable. Go to the Supreme Police. Petitioner learned AG access notice for the respondent. 1 to 5. Notice to respond number 6 to 9 is dispensed with in view of the proposed order to be passed. Petitioner is before this court seeking for the following leaves. Alleging that the respondent 6 to 9 had falsely indicated that the petitioner had expired and created certain documents including a family tree. The petitioner had submitted a complaint on 14/1/26 at Annexure H and 29/1/26 at Annexure J. Being agreed by the respondents not registering an FIR and proceeding with investigation, the petitioner is before this court seeking for the opposite review. A perusal of the complaint at Annexure H would indicate that the complaint has been filed under section 191 to 193 of the IPC, 463, 465, 467, 191, 193, 463, 465, 467, 468, 420, and 34 of the IPC. All of these offences are non-cognizable offences. And as such, in view of the decision of the Honorable Apex Court in Lalita Kumari, there was no requirement for the respondents to have registered a FIR. If the petitioner is aggrieved by such non-registration, the petitioner could always approach the next higher authority, namely the Superintendent of Police or the Deputy Commissioner of Police. And if no action is taken by such superior authority, it would be available for the petitioner to approach the jurisdictional magistrate by filing a private complaint in terms of decision of the Honorable Apex Court and Priyanka Srivatsava. Reserving such liberty, the petition stands disposed. IPC ಗೂ ಅದೇ ಪ್ರಾವಿಷನ್ ಹಾಕಿದ್ದೀರಾ, BNS ಗೂ ಅದೇ ಪ್ರಾವಿಷನ್ ಹಾಕಿದ್ದೀರಾ.
23, K. Prasanna Shetty.
Petition is by the Lokayukta institution. Petition is by the Lokayukta, my lord. The respondent number 1 government, my lord, after inquiry, my lord, the recommendation was sent to the government.
And AGF for respondent number 1 issue emergent notice to respondent number 2 returnable by 21st July. The petitioner is also permitted to take out hand summons to respondent number 2.
24, MP Shrikant.
Yes, Shrikant.
Lord, the petitioner, my lords, the firm carried out, my lord, the work insofar as the respondent's initiative is concerned. My lord, the work was carried out. Alleging that, my lord, there is delay. My lord, this amount is withheld.
Neeravari Nigam yaru?
B.R. Prashant.
B.R. Prashant is directed to accept notice for respondent number 1 to 4. Counsel for the petitioner served 2 sets of the petition along with annexure on said counsel, released on 23rd July.
Maybe called along with 20164 of 26.
Connect with so and so. Write it down, please.
25, Viveka.
For the petitioner in the matter, Millets. I am the wife, Millets, of the respondent number 4. And I've been driven out of my house. I am the owner of the 12 houses, Millets, and for which I've furnished the necessary sale deed copies, Millets. Now, when I went to stay in my house, my lords, my son bites me and he threatens me to kill me, lords. And because of that, I have to take shelter at my friend's place. Now the problem here is that, my lords, I go ahead and file an FIR with the police, but there's no action taken on that, my lords. Now,
Attempt to murder is a cognizable offense.
Indeed, my lords, there's no action taken on that. FIR has been filed, my lords, but I've been driven out of my house. The
That is
remedy
not
that I'm
something
seeking,
that we can look into in this matter.
indeed, my lords,
You will
the
have to
remedy
go
that I'm seeking is let me take shelter in one house. There are
Not-
14 houses, my
Not in
lords.
a writ petition, Mr. Counsel.
My lords, the problem here is I have no other alternate remedy that is available to me, my lords.
Have remedies. We can't advise you what remedies.
Indeed, my lords,
Just for
I've
you to
approached the
advise.
civil court as well, my lords. But I don't have a shelter. All my belongings are in my
And
house.
do that in a writ petition. We can't do that in a writ petition. And don't try to abuse the process of the court.
No, my lords, not our intention, my
Don't
lords.
do that.
No such intention, my lords.
This one is as regard non-filing registration of the FIR. Yes, we'll direct that. That can be done. Your other remedies, don't try to mix up and don't try to make us commit a mistake.
No, my lords. No, my lords.
And AGA accepts notice for respond number 1 to 3. Notice to respond number 4 to 6 is dispensed with since they are not required to be heard in the matter. Their entire pleadings are all civil.
My lords,
You
but
have come only
unfortunately,
for that relief.
I
This is
have
the
no
incident.
house, my lords. I'm taking shelter at my friend's place, my lords.
Not in a writ petition.
I understand.
Where is your complaint?
My lords, complaint can be found at page number 99, my lords. 101 is the FIR that has been registered, my lords, but no action is being taken on that.
FIR is registered.
FIR is registered, my lords. No action is being taken on that. I'm driven out of my house, but I'm not getting the help of the police to stay at my own place.
The police cannot involve themselves in this.
The
You
respondent
come and
number-
file this saying police is not helping you to get the place. Sometime you'll come and say police is involving themselves in civil matters.
The problem
This
here is,
a
my lords,
civil
I'm
matter.
driven out of my house. Plus,
This
the
is a
respondent
civil-
number 4 is my ex-husband. We divorced in the year 2023 by way of a decree. Now he is not letting me stay in my own premises.
Can we consider that in a writ petition?
So it's a
Why are you
far-fetched
arguing
relief, my
things?
lords. I understand it's a far-fetched relief, my lords.
You should know what to argue.
But there's no other alternate remedy that I have, my lords.
You have enough and more remedies which you need to apply your mind to. Notice to respond number 4 to 6 is dispensed with in view of the proposed order to be passed. The petitioner is before this court seeking for the following reliefs. The contention of the counsel for the petitioner is that the petitioner has allegedly been thrown out of her house and the police is not giving protection to the petitioner to enter the house and stay in the said house. On 26/26, in furtherance of which crime number 200 of 26 has been registered by the Puttenalli Police Station, Jayanagara subdivision, making allegations against respondent number 4 to 6. It is for the official respondents to investigate the said matters and file the final report. A mandamus cannot be issued by this court to the police to help the petitioner, to provide security to the petitioner to enter into the property and enable her to live in that property. The same ex facie is a civil dispute, reserving liberty to the petitioner to approach appropriate forum and obtain appropriate orders. The petition stands disposed. This is actually an abuse of the process. Next.
26, N.R. Ravi Kumar.
Petitioner, my lord. I'm for the petitioner, my lord. This petitioner, my lord, here she has purchased the land, my lord, for the 1 acre, 10 guntas of land, agriculture land.
Yes.
And she has availed the loan from the third respondent. Now there is a permanent restriction to not to transfer the property for at any cost to any time. That is the restriction imposed by the third respondent, my lord. As for the annexure A, my lord, I have given the representation and they issued the endorsement stated that there is a restriction that is ಮೇಲೆ ಉಲ್ಲೇಖಿಸಿದಂತೆ ಸಂಬಂಧಿಸಿದಂತೆ 2001ನೇ ಸಾಲಿನಲ್ಲಿ ನಿಗಮದ ಭೂ ಒಡೆತನ ಯೋಜನೆ ಅಡಿ ಜಮೀನು ಖರೀದಿಸಿದ್ದು ತಾವು ಕೋರಿರುವಂತೆ ನಿಗಮದಿಂದ ನೀಡಿರುವ ಜಮೀನು ಆಧಾರದ ಸರ್ಕಾರದ ಆದೇಶದಂತೆ ರದ್ದುಪಡಿಸುವಂತಿಲ್ಲ, ಬೇರೆಯವರಿಗೆ ಮಾರಾಟ ಮಾಡುವುದು ಶಾಶ್ವತ ಪರಭಾರೆ ನಿಷೇಧ ಎಂಬ ಅಂಶವನ್ನು ತಮಗೆ ತಿಳಿಸಿದೆ. This is the endorsement. Now at the time of purchase, my lord, I have availed the loan from the third respondent and now the loan has been cleared.
Property has been,
it is not PTCL attract.
Not PTCL.
Not PTCL. From the, it will not attract the PTCL act also. Section 5 is also not attracted. Only they are restricted. As per the order, my lord, they should not transfer the property with any permanent restriction.
You have cleared the loan.
Yes, my lord.
Respondent number 2 and 3, my lord, it would be the answering authority. But then, my lord, the corporation extends financial assistance to the people belonging to the downtrodden at the subsidized rate of interest, and also certain amount of the principal amount also is subsidized.
Under what law do you impose this?
That, my lord, my learned friend would have had to challenge the circular or the order if at all that way, at the time of accepting the loan. No doubt that he has taken the loan on a subsidized price. If that is that restriction is there, my lord, then he has to challenge
Who
that.
appears for B.R. Ambedkar?
They have to take the Ambedkar Corporation.
SV Girikumar.
Girikumar.
Yes.
Lord AG accepts notice for respondent
R1.
number 1. Shri S.V. Girikumar is directed to accept notice for respondent number 2 and 3. Counsel for the petitioner served 2 sets of the petition along with annexures on the said counsels. Shri S.V. Girikumar is directed to obtain instruction, make a submission as to on what basis the condition for permanent bar of transfer has been imposed on the petitioner with respect to the property purchased by the petitioner from and out of the loan facilitated by respondent number 2.
If I'm not wrong, my lord, there is a provision to get an
Let them
NOC.
place it on record,
NOC,
that's
let
right.
them place it, not our.
Let them place it on record, then they can challenge it.
Yes, that is, I have produced the.
That's why we are putting it now so that Amel Matte Girikumar
Alla,
taking time.
I have produced the annexure H, my lord. That is the, that GO has been introduced in the year of 2012, wherein I have purchased the property in the year of 2002, my lord. That is after lapse of 12 years, the GO has been introduced, not.
Let us see what they say.
Please.
27, Manjunatha K.
For the petition in this case, my lord, we challenged the order of the Assistant Commissioner, my lord, under Senior Citizen Act, my lord. Really, respondent number 1 has gifted the property to the petitioner and his minor son in their 2020, my lord. 2020 li gift ಮಾಡ್ತಾರೆ, ಗಿಫ್ಟ್ ಮಾಡಿದಾಗಿಂದ ಅವಾಗ ಅದು ಖಾಲಿ ಸೈಟ್ ಇತ್ತು. ಆಮೇಲೆ ದೇ ಕಮರ್ಷಿಯಲ್ ಇದನ್ನ ಬಿಲ್ಡಿಂಗ್ ನ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಿ ಇನ್ ದ ಇಯರ್ 2021 ನಾವು ಮನೆ ಬಿಟ್ಟು ಈ ಇದರಲ್ಲಿ ಪಿಟಿಷನರ್ ಕೇಮ್ ಔಟ್ ಆಫ್ ದಿ ಹೌಸ್, ಮೈ ಲಾರ್ಡ್. 2021 ನಲ್ಲಿ ಗಿಫ್ಟೆಡ್ ಆದ್ಮೇಲೆ ಇವರು ಫ್ಯಾಮಿಲಿಲಿ ಏನೋ ಪ್ರಾಪರ್ಟಿ ವಿಷಯಕ್ಕೆ ಗಲಾಟೆ ಆಗುತ್ತೆ ಅಂತ ಪಿಟಿಷನರ್ ಕೇಮ್ out of the property in the 2021. Since from the date of gift deed, the father of the petitioner collecting the rent. I am produced the copy of the rent agreement.
ನೀವು ಪೊಸಿಷನ್ ಇಲ್ಲ.
ಪೊಸಿಷನ್ ಅಲ್ಲಿ ನಾನಿಲ್ಲ. ನಮ್ಮ ತಂದೆ ಗಿಫ್ಟ್ ಮಾಡಿದಾಗಿಂದ ಅವರೇ ಬಾಡಿಗೆ ತಗೋತಾವ್ರೆ, ಅವ್ರಿಗೆ ಬಿಟ್ಟಿದ್ದೀನಿ, ಬಿಡಿ ಅವರೇ ಇರ್ಲಿ ಅಂತ. ಆಲ್ ಆಫ್ ಅ ಸಡನ್ 2023 ನಮಗೆ ಅವ್ರ ಇದನ್ನ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಮುಂದೆ ಕೇಸ್ ಹಾಕೊಂಡಿದ್ದಾರೆ. ಕ್ಯಾನ್ಸಲ್ ಕೂಡ ಆಗಿಲ್ಲ. ಅದಕ್ಕೆ ಆರ್ಡರ್ ಆಗಿರೋದು ಈಗ 2026 ಅಲ್ಲಿ. ಬಿಫೋರ್ ಕ್ಯಾನ್ಸಲೇಷನ್ ಆಫ್ ದಿ ಗಿಫ್ಟೆಡ್ ಬೈ ದಿ AC, ಮೈ ಫಾದರ್ ಹಸ್ ಗಿಫ್ಟೆಡ್ ದ ಪ್ರಾಪರ್ಟಿ ಟು ಮೈ ಮದರ್. ಸೇಮ್ ಪ್ರಾಪರ್ಟಿನ ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ 1A ಅಂತಂದು ಮಾಡಿದ್ದು ನನಗೆ ಗಿಫ್ಟ್. ಮತ್ತೆ ಖಾತಾ ಎಲ್ಲ ಫ್ಯಾಬ್ರಿಕೇಟ್ ಮಾಡಿ 1B ಅಂತ ಮಾಡಿ ನಮ್ ತಾಯಿ ಗಿಫ್ಟ್ ಮಾಡಿ ಅದೇ ಪ್ರಾಪರ್ಟಿನ ಮತ್ತೆ ಇನ್ನೊಬ್ಬರಿಗೆ ಸೇಲ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಓನ್ಲಿ ಟು ಮೇಕ್ ಮಿ ಹರಾಸ್. ಅವನಿಗೆ ಗಿಫ್ಟ್ ಮಾಡಿದೀವಿ, ಅವ್ನ್ ತೊಂದರೆ ಕೊಡ್ಬೇಕು ಅಂತ ಡಾಕ್ಯುಮೆಂಟ್ ಎಲ್ಲ ಫ್ಯಾಬ್ರಿಕೇಟ್ ಮಾಡಿ.
ನೀವು ಇದು ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇರೋದು ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಆರ್ಡರ್.
ಎಸ್ ಮೈ ಲಾರ್ಡ್.
ಅದೆಲ್ಲ ಏನಿದೆಯೋ ನೀವು ಸಿವಿಲ್ ಕೋರ್ಟ್ಗೆ ಹೋಗ್ಬೇಕು.
ಅಲ್ಲ, ಐ ಅಗ್ರಿ ಮೈ ಲಾರ್ಡ್. ಇದ್ರಲ್ಲಿ ಅವರು ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಚೇಂಜ್ ಮಾಡಿದ್ದಾರೆ. ನಮ್ ಪ್ರಾಪರ್ಟಿ ವ್ಯತ್ಯಾಸ ಇದೆ ಅಂತ ಅವ್ರು ಅಂತಾರೆ. ಇವಾಗ ಇದರಲ್ಲಿ ಸೀನಿಯರ್ ಸಿಟಿಸನ್ ಆಕ್ಟ್ ಅಲ್ಲೂ ಕೂಡ ನಾವು ಅವ್ರನ್ನ ನೆಗ್ಲೆಕ್ಟ್ ಕೂಡ ಇದ್ ಮಾಡ್ತಿಲ್ಲ. ನಮ್ ಪ್ರಾಪರ್ಟಿಲಿ ಅವರು ಬಾಡಿಗೆ ಕೂಡ ಇಸ್ಕೊತಿದ್ದಾರೆ. ಒಂದು ಪ್ರಿಮೈಸ್ ಇಂದ 20,000 ಇಸ್ಕೊಳ್ತಿದ್ದಾರೆ. ಮತ್ತೆ ಫಸ್ಟ್ ಫ್ಲೋರ್ ಅಲ್ಲಿ 15,000 ಇಸ್ಕೊಳ್ತಾರೆ. ಬಾಡಿಗೆ ಅವರೇ ಇಸ್ಕೊತಿದ್ದಾರೆ. ಒಂದ್ ತಿಂಗ್ಳಿಗೆ 35,000 ಬಾಡಿಗೆ ಹೋಗ್ತಾ ಇದೆ. ನಾವ್ ಅವ್ರ ಜೊತೆನೂ ಇಲ್ಲ, ನಾವು ಅವ್ರಿಗೆ ತೊಂದರೆನೇ ಕೊಡ್ತಿಲ್ಲ.
ನಿಮ್ ಇವಾಗ ಇದು ಪ್ರಾಪರ್ಟಿ ಬೇಡಲ್ಲ ನಿಮ್ಗೆ?
ಪ್ರಾಪರ್ಟಿ ನಾವು ಬೇರೆ ನಾವು ಅದ್ರ ಬಗ್ಗೆ ಫೈಟ್ ಮಾಡ್ತಾ ಇದೀವಿ. ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೇಸ್ ಹಾಕೊಂಡಿದೀವಿ ಆಲ್ರೆಡಿ. ವಿ ಫೈಲ್ಡ್ ಅ ಕೇಸ್ ಬಿಫೋರ್ ಇನ್ ಸಿಟಿ ಕೋರ್ಟ್. ಬಟ್ ಇದರಲ್ಲಿ ಸೂಟ್ ಫಾರ್ ಕ್ಯಾನ್ಸಲೇಷನ್.
ಕ್ಯಾನ್ಸಲೇಷನ್ ಆಫ್
ಸೇಲ್ ಡೀಡ್.
ಥರ್ಡ್ ಪಾರ್ಟಿ ಸೇಲ್.
ಎಸ್ ಮೈ ಲಾರ್ಡ್. ಅದರಲ್ಲಿ ಫ್ಯಾಬ್ರಿಕೇಟ್ ಮಾಡಿ ನಮ್ ತಾಯಿಗೆ, ನಮ್ ತಂದೆನೆ ನಾನಿಗೆ ಮತ್ತೆ ನನ್ನ ಮಗನ್ಗೆ ಮಾಡಿದ್ದು ಗಿಫ್ಟ್ ಡೀಡ್ ನ ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ದಂಗೆನೆ ನಮ್ಮ ಇವ್ರಿಗೆ ಡಾಕ್ಯುಮೆಂಟ್ ಫ್ಯಾಬ್ರಿಕೇಟ್ ಮಾಡಿ ತಾಯಿಗೆ ಮಾಡಿ.
ಯು ವಾಂಟ್ ಟು ಕಂಟೆಸ್ಟ್ ದ ಮ್ಯಾಟರ್?
ಎಸ್ ಮೈ ವಿ ವಾಂಟ್ ಟು.
ಮನೆ ಬಿಟ್ಟು ಹೋಗಿದೀನಿ ಅಂತ ಹೇಳಿದ್ರೆ
ಮನೇಲಿ ವಾಸ್ತಾ ಇಲ್ಲ. ನಮ್ ತಂದೆ ಚೆನ್ನಾಗಿರೋದ್ರಿಂದ ಬಾಡಿಗೆ ಬಿಡ್ತಾ ಇದೀವಿ. ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿಲಿ ನಾವು ತೊಂದರೆನೇ ಕೊಡ್ತಿಲ್ಲ ಅವ್ರಿಗೆ. ಇಟ್ ಮೇ ಬಿ ಸ್ಟೇ ಮೇ ಬಿ ಗ್ರಾಂಟೆಡ್ ವಿತ್ ರೆಸ್ಪೆಕ್ಟ್ ಟು ದಿ ಆರ್ಡರ್ ಆಫ್ ದಿ AC ಮೈ ಲಾರ್ಡ್.
ಇಶ್ಯೂ ನೋಟಿಸ್ ಟು ರೆಸ್ಪಾಂಡೆಂಟ್.
ಇವಾಗ ಕ್ಯಾನ್ಸಲ್ ಆಗಿದೆ ಅಂದ್ರೆ ಮತ್ತೆ ನಮ್ ಪಿಟಿಷನ್ ಬಿಕಮ್ ಇನ್ಫೆಕ್ಚಿಯಸ್ ಆಗುತ್ತೆ ಮೈ ಲಾರ್ಡ್.
ಏನಾಗಿಲ್ಲ, ರಿಟರ್ನಬಲ್ ಬೈ.
ನಾವು ಆಲ್ರೆಡಿ ಗಿಫ್ಟ್ ಡೀಡ್ ಕ್ಯಾನ್ಸಲ್ ಆಗಿದೆ, ನಾವು ಪ್ರಾಪರ್ಟಿ ಸೇಲ್ ಮಾಡಿದೀವಿ ಅಂತಾರೆ.
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 ಎಕ್ಸ್ಪಾರ್ಟೇ ಮಾಡಕ್ ಆಗತ್ತೇನಪ್ಪ?
ಅಲ್ಲ, ದ ಆರ್ಡರ್ ಆಫ್ ದಿ AC ಮೈ ಲಾರ್ಡ್.
ಎಕ್ಸ್ಪಾರ್ಟೇ ಮಾಡಕ್ ಆಗತ್ತೆ.
ಮೇ ಬಿ
Respond number 1 is restrained from any manner alienating, dealing with, encumbering the subject property till the next day of hearing. Process fee and copies to be furnished by end of day 16 July, failing which the interim order will stand automatically.
Mature.
In this case, I'm appearing for petitioner. Last that this land will come under the Mujrai Ilaki Lordship. What has happened? That one Mr. Udraya had 4 sons. That the first son is Gangappa, second son is Mallashaya, third son is Shivanna, and last 4th son is Muttunjayappa. So they have made a partition deed on 1972. The typed copy of partition deed is here with produced as annexure here, that is page number 17, my lordship. Thereafter, the first son of the Rudraya, so the first son of the Rudraya, that is late Gangaya, that Tahsildar has granted a Inam land in favor of Gangappa, that is annexure B, my lordship, page 21. That in this premises, that one Kashi Vishveshwaraya temple has been formed, my lord. So then the Tahsildar has passed the order that he has appointed him as a Archaka right from the beginning. So he is appointed as a priest and performing the puja, my lordship. After the death of the Gangappa, then that one Chandrasekharaya has continued as a Archaka. Now, my lordship, that thereafter, all of a sudden, during the COVID period, the deputy commissioner, without issuance of notice to the petitioner, have passed the order and changed the priest, my lordship.
Is it a notified temple or private temple?
Mujrai Ilaki.
Mujrai
notified. But this property belongs to the Gangappa. It was granted under the Inam land, my lordship. Right from the beginning, that Gangappa continued as a Archaka and he was taking a salary from Mujrai Ilaki. So this is not the joint family property. It is independent property. Then after the death of Gangappa, then the petitioner has continued as a priest till now, my lordship. And during in 2019, kindly see annexure E, my lordship, without issuance of notice. Annexure E, page 31. The deputy commissioner has passed the order.
What is annexure B?
Annexure B, my lordship, that the land was granted by the
Tahsildar, my lordship, in favor of Gangappa, who is the father of the petitioner.
Under what act? Under which act was this grant made?
Under the Inam land.
ಇಲ್ಲಿ ಬರ್ದಿಲ್ಲಲ್ವಾ ಇದು? It's not to be seen.
ಈ ಕೆಳಗೆ ನಿರ್ದಿಷ್ಟಪಡಿಸಿದ ಭೂಮಿಗಳಿಗೆ ಸಂಬಂಧಿಸಿ ಈ ಅಧಿನಿಯಮದ 45ನೇ ಪ್ರಕರಣದ ಮೇರೆಗೆ ಸದರಿ ಭೂಮಿಯು ಅಧಿಭೋಗದಾರನಾಗಿ ತನ್ನನ್ನು ನೋಂದಣಿ ಮಾಡುವಂತೆ 48 ಆ ಪ್ರಕರಣದ ಮೇರೆಗೆ ಅವಿಧಿನ ಮಾಡಿ
45 and 48 and land reforms sir ಇದೆ.
Yes, yes.
Not under Inam's act.
Not under the Inam act. So
its occupancy certificate has been issued.
Yes.
Not a grant.
Not a grant. And this records reveals that it is independent property, my lordship.
Which property? What is the survey number?
Survey number, my lordship.
153 and 73. On which property is the temple located?
That survey number 73, my lordship.
It's a little surprising.
And then next, kindly come to the page number 22. The details of the property shown in the column number 2, my lordship. 22, my lordship. Gorina Bele in the middle, my lordship. In the column, they have mentioned that that's survey number 153 and 73, my lordship.
And you are challenging an order of 2020.
Challenging the order of annexure E, my lordship.
2020 order.
Yes, my lord, 2020 order.
And you are not made the beneficiary a party.
I am the
beneficiary of that order, annexure E, beneficiary arrow.
An annexure, what, kindly see the annexure E, page 31, my lordship. That while passing the order, deputy commissioner was not issued notice to the petitioner.
There is a beneficiary of the order.
Yes, sir.
Who is that beneficiary?
That Malleshaya.
You have not made him a party.
I not made him as a party.
And how can we consider this? That order is going to have a bearing on him.
My only contention is, while passing the order by the deputy commissioner, that notice was not issued to the petitioner.
So now you don't, without making that Malaysia a party, you want us to pass an order.
But later, my lordship, that pursuant to the order passed by the deputy commissioner, the Tahsildar have issued a intimation letter to the petitioner.
Are you going to make them a party or not?
I will make them.
If you don't make it, we'll have to dismiss
I'll make now itself.
And AG accepts notice for respondent number 1 to 5. Counsel for the petition seeks one is granted a week's time to implead the affected parties. Relist on 23rd July.
My only not for sale till next date of hearing.
No way. 2020 order, you want to stay in 26?
Subsequently, I have challenged the very same order before the commissioner that
That is why we are issuing notice. There seems to be a lot of things which have happened.
Till next date of hearing, I sought for stay. That because that intimation letter was issued by the
Sorry, Rudresh, not after 6 years.
29, Rakshita.
Parola.
Feroz.
And AGA for respond 22nd.
Serial number 30. TP Vivekananda.
Okay, for petitioner. The matter pertaining to GMPDS. The petitioner is seeking transfer of authorization on compassionate ground.
Compassionate ground.
Please, annexure F, page 24, the portion of the order.
Why was it refused?
It is refused on the ground that at the time of the deceased is more than 65 years. And the applicant.
Father was 65 years.
5 years and petitioner is not completed the years.
And AG accepts notice for respondent 1 to 3. Petitioner is before this court seeking for the following leaves.
My lord, one submission. The 10th standard has been upheld by the coordinate bench, my lord, because he has not produced any document that he has cleared the SLC. 65 years, the relaxation has been questioned.
Standard has been upheld. Kodi.
You have referred that in the judgment only. In this judgment.
Can you see the page number 25, my lord? I have produced the order. Subsequently, this coordinate bench has passed an order and quashed the very similar endorsement.
Yes, that is what we are under the impression. But there is another order which was not brought to our notice earlier.
My lord, this writ petition is the order given under the 1992 Act, my lord, not under the PDS 16. This 2016 amendment and subsequent amendment does not have a retrospective effect.
Kindly see page number 30, para 7. It is clearly stated, subsequently amended clause 13 in May 2016, 17 and 21 introduced restrictions on the transfer of authorization and compassionate loan. The amended provision prohibits such transfer if authorized dealer was over the age 65 at the time of that, or if the transfer
Without reference to 10 standard.
Please, my lord.
Where is it in your favor?
My lord, that's a one-time measure in this, but in para 27, my lord, in page 70, because this is granted under
para 30 will apply to all.
No, my lord, it says that only for the writ petitioners, my lord.
Now this
as a
also
one-time measure
for this writ
My
petition.
apologies. Because he has granted under the PDS 16. Kindly refer in page 13, my lord.
To formulate a proper policy, we are
Yes, ma'am.
telling you don't do that. The petitioner's father was granted an authorization under the Karnataka Essential Commodities (PDS) Control Order 1992 for distribution of essential commodities and food articles at Ina Minchenahalli, Kasba Obli, Chikbadapur Taluk and district, which has been renewed from time to time. The last renewal being on 18/11/2022 is in force till 11/10/2027. Unfortunately, the father of the petitioner expired on 24/3/2026, leaving behind his wife and 4 children. The wife and the 2 daughters, as also another son, have no objection for the transfer of authorization in favor of the petitioner herein. And in that background, the petitioner had submitted an application on 27/5/26 for transfer of authorization on compassionate basis. The said application came to be rejected on 2 grounds. Firstly, that the authorization holder was more than 65 years of age as on his death. And secondly, that the petitioner had not produced any document indicated that he has passed SSLC/10 standard. It is challenging the same. The petitioner is before this court seeking the opposite relief. Learned counsel for the petitioner submit that this court, as in a Ketinov decision, held that it is the age of the transferee which is required to be taken into consideration and not the age of the deceased authorization holder which is required to be considered. And on that basis, he submit that in case of a compassionate transfer of authorization, the age of the transferee, if taken into consideration, a transferee, that is the petitioner taken into consideration, is less than 65 years. Insofar as education qualification of SSLC/10 standard, his submission is also that in a Ketinov decision, this court has categorically held that the qualification of passing SLC would be applicable only to a fresh authorization, not to a transfer on compassionate basis. That AGA, by relying on the decision dated 23rd December 2021 in WP number 13559 of 2020, more particularly para 27 thereof, which is reproduced here under for his reference, submits that this court has upheld, a coordinate bench of this court has upheld the power of the state to levy a educational qualification, and having thus upheld the petitioner not qualifying, not having placed anything on record indicating that he has passed SSLC/10 standard, the rejection made by a respondent is proper and correct. Heard so and so, perused papers. Though the AGA has relied on the decision in Manmohan Kumar and others, para 27 of the decision in Manmohan Kumar and others, what would be of relevance is para 30 and 31 of the very same decision, which are reproduced here under for your reference. A reading of the above said para 30 and 31 would categorically indicate that though the coordinate bench upheld the power of the authority state to impose any condition, the coordinate bench took into account the decisions rendered by this court in several matters where benefit had been extended to persons who had not passed SSLC examination, and was of the considered opinion that even if the power to levy such a impose such a condition were to be upheld, it ought not to result in two sets of applicants, namely one successful on the strength of several orders in various writ petitions, others deprived of consideration of the application. And it's on that basis that the coordinate bench came to a conclusion and directed the respondents to consider the application of transfer on compassionate basis without reference to the restriction of age and pass and 10 standard, so as to provide parity with various orders passed by this court in several writ petitions. Thus, it would not be available now for the state to rely upon para 27 of the said decision, when para 30 and 31 speak otherwise. In that view of the matter, this court passes the following order. Writ petition is allowed, a mandamus is issued, respondents at certiorari is issued, the endorsement at annexure F so-and-so is quashed, a mandamus is issued directing respondent number 2 and 3 to transfer the authorization to run the fair price shop at Inamichinanalli, Kasba Obli, Chikbadapur Taluk in favor of the petitioner within a period of 30 days of the receipt of a copy of this order, subject to the petitioner complying with all formalities, including providing of indemnification and or documentation from the other family members, indicating that they have no objection for such transfer to be made in the name of the petitioner.
31, Ashokati.
Mallards, some for petitioner, Mallards, the tender notification in annexure D in page number 55 is challenged, Mallards.
25.
55, Mallards, on two
Yes.
grounds, Mallards. Mallards, see, EMD amount.
Page number?
Page number 60, 55, Mallards.
55.
55, Mallards.
Yes.
This notification is issued for supply of dietary food, Mallards.
EMD clause page number 8.
Page number, Mallards.
61.
58, Mallards.
58.
58, Mallards. Serial number 9, Mallards.
Yes, EMD 2.5%.
2 point, Mallards. It should be 2%, Mallards, as per the standard document issued by the government, Mallards.
Yearly they where is that?
Page number, Mallards. In page number 29, Mallards.
29.
29. On right side column, Mallards, B, Mallards, rupees 20 lakh and above up to rupees 1 crore, Mallards.
Clause serial number?
Serial number B, Mallards, in page number 29, B, from the top right side, Mallards, in the box, Mallards. Rupees 20 lakh.
Up to 20 lakhs, 2.5%.
Up to 20,
rupees 20 lakhs and above up to 1 crore, 2%.
B is applicable to this case, Mallards.
What is the tender amount?
Mallards.
66 lakh.
66 lakh, Mallards.
And that is above 20 lakhs within 1 crore, 2% is element.
This,
My Lord, my instructions are that, my Lord, they have followed the circular issued by the government, my Lord.
This is a government order of.
Okay, my Lord. May I place it before me?
This is a government order which you show us every time that we are doing it as per this.
Lord, circular is issued subsequently.
How can circular override a government order? Circular issued by Ayuktaru Arogya Mathusons. He can't override a government order.
And, my Lord, my instructions are it is still under evaluation process, my Lord.
It may be, but EMD has to pay for the purpose of it. Last date is over.
Last date is over, Mallards. And apart from that, there is one more ground, Mallards. They have sought for audit report, balance sheet.
So now you are given EMD of 2.5%.
Please, my Lord.
You have participated. Nothing.
Mallards, but practically it is impossible, Mallards. This
For
balance
future
sheet-
matters. For
Please.
future matters. But here you are given a EMD of 2.5%. What is the other contention?
Mallards, page number 61, Mallards, para 14, Mallards. Point number 14.
14.
Please, Mallards.
Yes.
Para page number. Mallards, audit report and balance sheet is sought for the 3 years, Mallards. For 25-26, Mallards, the last date is 8/6 is the last date, Mallards. Within 2 months, it is practically impossible to prepare audit report, Mallards. Without this, I have participated, Mallards.
Where the pre-qualification Yes, madam, 25, 26. They have time to file their,
March 20.
March 31st is the last date. Income tax payment is July 30th. How many people pay before that date? No, that has not come about even for individuals. In the individual, corporate entity.
If my lords may kindly
Partnership.
peruse the circular, ಕಳೆದ 3 ವರ್ಷ they say, my lord.
But you have you have
Previous 3 years, it will come to 25, 26 also, my lord.
correct, but previous 3 years would have been 22, 23, 23, 24, 24, 25.
Please, my lord.
So you'll consider 22, 23 of the petitioner.
Please, my lord.
Please.
You uploaded that.
For 25, 26, I have not uploaded, my lords.
22, 23 you uploaded.
Please, my lord.
Petitioner and AGA is before this court. Learned AGA accepts notice for respondent 1, 2, 3. Petitioner is before this court seeking for the following leaves. Respondent number 2 had issued a tender when was the date of the tender?
18, 5, 26.
Page 56, my lords.
On 18/5/2026. Through the KPB portal for supply of prepared meals and high quality bread for the year 26-27. The estimated annual value was stated to be rupees 26,50,000. The petitioner is before this court contending that two of the clauses in the said tender notification are arbitrary and not sustainable. Firstly, the clause relating to EMD, fixed at 2.5%, is contrary to the circular dated 12/3 and dated 2008, 14/10/2008, in terms of whereof it is only for tenders valued up to 20 lakhs that a EMD of 2.5% could be imposed, and any contract, any tender above 20 lakhs up to 1 crore, the EMD which could be collected is 2%. This being a government order which had been issued, is binding on all the departments, including the health department. And as such, the submission made is that the respondent number 2 and 3 could not have increased the EMD to 2.5%. However, an inquiry as to whether the petitioner has participated and provided the EMD of 2.5%, the counsel for the petitioner submit that the petitioner has participated, and for this tender, he has submitted a EMD of 2.5%. But if this aspect were to be repeated by the authorities, it would be difficult for petitioner and similarly situated persons to participate in those tenders on account of the arbitrary increase of the EMD by 0.5% of the tender value. Secondly, his submission is that in terms of, for the purpose of pre-qualification, financial pre-qualification, the tender prescribes that the balance sheets and audited statement for 3 years from 2023-24, 2024-25, and 2025-26 are called upon to be produced by the respondents. Insofar as the year 25-26 is concerned, the petitioner's audit is still not completed, and as such, the petitioner would not be in a position to present the same. His submission is that the requirement being for 3 years audited statement to be placed on record, the petitioner is willing to place on record the audited statement for 2022-23, which could be considered by the respondent for the purposes of financial evaluation of the petitioner. Learned AGA on instructions would submit that a circular has been issued by the Commissioner, Health Department, wherein there is the Commissioner has indicated that for all circular dated 21/1/2020, that for all contracts, the EMD is to be fixed at 2.5%. Insofar as the evaluation is concerned, she submits that evaluation is still going on, and if the petitioner has the audited statement for 25/26, the same would be considered. If not, the audited statement for the year 20, audited statement, if produced for the year 22/23, would be considered for the purpose of evaluation. Heard so-and-so produced papers. Insofar as the first contention of the learned counsel for the petitioner is concerned, the same is meritorious, inasmuch as the government order of the year 19 of dated 14/10/2008 is applicable to all contract tender documentation by all departments in the state of Karnataka. And it is in fact that government order which is produced before this court in most matters by the state to contend that the conditions of the tender are as per the government order. If that be so, it was for the respondent number 2 and 3 to comply with the government order dated 14/10/2008 and not issue a circular increasing the EMD without the slabs being fixed to 2.5% for all tender documentation. In the present case, the consideration of the said matter, though academic, inasmuch as the petitioner having already submitted a EMD of 2.5%, it would be for respondent number 2 and 3 to, in future, comply with the government order dated 14/10/2008 so that these kind of situations do not arise. The ambit and purport of reducing the EMD to 2% for higher contracts is to enable larger number of participation. By increasing the EMD, the participation would get reduced to such extent. As regard the second condition of learned counsel for the petitioner relating to the audited statements, again the same is meritorious inasmuch as the last date for submission of audited accounts either to the income tax department or your firm or to the registrar of firms is not proprietress, not a firm, or a income tax department is not completed inasmuch as petitioner is a proprietary concern, and as such the income tax returns of such proprietrix would have to be filed before 30th of July 2026. In the present matter, the tender having been invited on 18/5/26, the last date of submission being, what is the last date?
8/6. 8/6.
8/6/2026 is much before the last date of submission of the income tax returns. Of course, it would always be available for an assessee to submit returns on a date prior to the last date, but it would not be permissible for the respondent to indirectly call upon the participants to complete their assessment before the last date of submission of the tender documents. In that view of the matter, wherever the tenderers have submitted their audited statements for the year 25/26, that could be taken into consideration. Insofar as the petitioner is concerned, since the audited statements are not available, respondents are directed to consider the audited statement for the year 22/23 for the purpose of for the financial evaluation. Petitioner to furnish a hard copy of the same to the respondent number 3 by end of day 16th July 2026.
Great, ma'am.
With the above observation, the petition stands disposed.
So far as EMD is concerned, they have taken out the previous year expenditure and based on that they have.
EMD. And government order
But
is there.
please, please,
If you change the government order, that is different.
please,
Government order will be applicable to all departments.
Please.
Then each department will start changing.
please,
Can't do that.
oblige.
I-1 of 26 is allowed.
Serial number 32. K. Prasanna Shetty.
Yes, Prasanna.
32, my lord, the government has rejected the 12-3 report.
Rejected. And AGA for respond number 1, issue emergent notice to respond number 2, returnable by 21st July. Council for the petitioner is permitted to take out and summons on respond number 2.
33.
Yes, Siddharth.
For the petitioner's lordship, we have sought for certain information on the RTI Act, page number 23, lordship may kindly see. Only one information is provided. The petitioner is under secretary for the State Election Commission. There were drivers who were deputed from BMTC. However, they have been recalled. Therefore, we had sought certain information as to how many drivers are there, why there is being recalled as of now, because it is these drivers are required from the BMTC for functioning.
K. Rajshekhar
Yes, K. Raj.
is directed to accept notice for respond number 1, BMTC.
HR Renuka.
HR Renuka for respond number 2 and 3. Council for the petition furnish 2 sets of the petition along with annexures on the said councils released on 6th August.
Obliged, lordship.
34. Satya Amen.
My lords, for petitioner, there are connected matters, my lords. Maybe kindly posted on
Recreation
17th.
Club. And AGA accepts notice for respond number 1 to 4. The benefit of the order dated so and so in WP number so and so is extended to the petitioner. Connect with so and so and relist on
17-8.
17-8. Give that number.
35.
Mr. Mohan Krishna.
Stay in connected matters. Stay in connected matters.
Where is he?
Well, one batch has been heard and reserved by a coordinate bench. One
Coordinate
batch of
bench.
the similar petitions
Uh,
challenging the renewable energy policy has been heard and reserved by a coordinate bench.
when was it reserved?
24th of June, my lord.
24th of June.
And last week, my lord, petition 20414 was heard by your lordship and an interim order.
Uh,
That was directed to be listed on 17th of August.
Your lordships, I appear for the petitioner.
yes.
Your lordships had ordered. Your lordships had granted interim order.
Yes. In which matter? What is the writ petition number? Got stuck. Yaudappa.
20414 of 2026.
And AGA for respond number 1. Credel yaru?
I'm so sorry, Manoj. I was not promoted into here. This is the same matter that came up last week, Manoj.
Who is the standing counsel for Credel?
Was Mr. Samarth Kashyap was appearing in the
Samar
batch.
Kashyap for respond number 2. So and so for respond number 3. Connect with WP number so and so. The interim order dated so and so granted and so would be the benefit of so and so is extended to the petitioner. When is that listed?
18/8, my lord.
18/8.
August.
We list on 18/8.
Grateful.
Give the number.
15113 of 2020.
15113.
Of 2022, lordship.
No, not
That's
the
the
coordinate bench. What came up before us the last week?
I'll just give that number. I'll just give that number. Pass on that number to the
20
414 of 2026.
414 of 26.
36.
Raghuram. Yes,
The
madam.
petitioner, my lords, have filed the present petition seeking a direction, my lords, against defendant number respondents, my lord, to consider my representations, my lord, at annexure A to C, my lords, to allow me to conduct the annual URS, my lords, and also to hand over the keys of the dargah.
Who has the
I am-
keys?
Yes, my lords.
Who has the keys? Keys are with
These are with the respondent, my lords.
the district
Yeah.
Waqf officer.
Yes,
District
my
Waqf
lords.
Shri Piyush Swan is directed to accept notice for respond number 1 and 2. And AGA accepts notice for respond number 3. Counsel for the petitioner to furnish 2 sets of the petition along with annexures on the said council. When is the URIS?
Urus is on 5th of August, my lords, 5th to 8th.
Relist on 23rd July.
Much ob.
37, K.N. Subbareddy.
Your lordships, appearing for the petitioners.
Hmm.
It's the Human Rights Commission, your lordship. In the light of the same, previously your lordships have already granted a stay order. That matter has to be connected in this.
Which one?
The
Give us the order.
inspector had already,
Give us the order.
these are the, in this petition, these are the other police authorities who have been arrayed in the same order, your lordship.
And AGA for respond number 1, 3, the Human Rights Commission. Respond number 1. Sri Gopal Krishna Sudhi is directed to accept notice for respond number 2 to 4. Issue notice to respond number 5, returnable by emergent notice returnable by 5/8/26. Same order, para 4. Connect with source.
Gopal
Please,
Krishna
Judge.
Sudhi. Gopal Krishna Sudhi.
Gopal
Sudhi.
Krishna?
Sudhi, S-O-O-D-I. Gopal
SOODI.
Krishna Sudhi.
SOODI.
Grateful.
Aditya S.K.
Parole and AGA 22nd.
39, Girish R.
Parole 22nd.
40, Girish R.
And AGA for respondent. Benefit of
40 is a recreation club.
39.
benefit of the order dated so and so is extended. Relist on 18/8. 17/8. 40.
41,
Petitioner, my lord, it is covered by judgment.
Club merchants antide.
Club matter, recreation club.
AGA for respond. Benefit of so and so order 17/8.
42,
42.
According to the petitioner, it is a petition seeking a direction to remove the lien placed on my account.
Lien.
Yes, my lord. The problem I'm facing, my lord,
Within
is
the state, outside the state.
it is outside the state.
So there's a help desk which has been established.
My lord, what the problem is that the FIR has not been registered. It is only a complaint on the NCRP portal.
That is what you don't know everything. They'll get the details.
My lord, I am not privy to the details.
That is
Because,
why the help desk has been set up. Please go there. They'll give you the details. Once you get the details, then we'll consider what is to be done.
all right,
Take all your papers. Show it to the help desk. There are 3 people from the cyber command who will be there
yes, my lord.
on Thursday, 16, tomorrow.
Yes, my lord.
So you go there.
This may be adjourned then, my lord, because there are 4 petitions that we filed.
Which are those 4 petitions?
It is 2 are listed today, 42 and 44.
Uh,
The other 2 have not been listed yet.
But, my lord,
Take those papers.
For today,
get the papers and
yes, my lord.
Those also. It doesn't matter if there's an order or not. Whoever goes there, there'll be help there.
I'll go there, my lord, but this may be simpliciter adjourned at my request than today.
Wait till
Yes,
you
my lord.
hear the order.
Yes, my lord.
Union of India Aramadರಲ್ಲಿ ಅಲ್ಲ ಇದು ಫ್ರೀಸಿಂಗ್ ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ
Aditya Singh.
ಆದಿತ್ಯ ಶಾಂತಿ ಭೂಷಣ್
Aditya.
Aditya Singh. Shri Aditya Singh is directed to accept notice for respond number 1 and 2. HDFC,
Francis Xavier.
Francis Xavier for 3. Notice to respond number 4 is deferred for now. The petitioner is granted liberty to approach the help desk to be set up by the cyber command at the order 16th, along with all the documents. Serve 2 sets in on Mr. Xavier, so he can also carry the documents. Relist on other date ಕೊಟ್ಟಿದ್ದೀವಿ.
13th August.
Hmm?
13th August.
13th August.
Shanti Bhushan.
ಶಾಂತಿ ಭೂಷಣ್. ಶಾಂತಿ ಭೂಷಣ್ ಮಾಡಿ ಆದಿತ್ಯ ಸಿಂಗ್.
43. Pawan DK.
Refer for petitioner, madam.
Yes, Pawan.
I'm challenging the order passed by the Assistant Commissioner under madam.
Senior citizen.
Please, madam.
petition of the daughter-in-law. This case, my lord, little distinction. The daughter-in-law, there's a DV also pending.
In the DV
And your husband is alive.
Please,
Yes.
madam. He is
You have-
respondent number 3.
You have dispute with the husband.
Please, madam. During the pendency of the domestic violence proceedings, magistrate has passed the residence protection order. Even though despite of the order, my lord, the assistant commissioner has not considered that order, and by overlapping the same, my lord, that the ordered for eviction. The order, my lord, annexed.
Page number, where is the DV court order?
My lord, annexure.
Annexure?
Annexure.
Page number.
Please.
ಬೇಗ ಹೇಳಬೇಕು.
Annexure B, my lord, page number 24.
24.
Please, my lord. Typed copy is, my lord, page number 26. When there is a, my lord, serious threat of dispossession, my lord, I have filed an application under section 19. Subsequent to that application, order came to be passed.
Till
By
disposal of IO.
Only till disposal of, my lord, the interim application. Even against that order, my lord,
What
they have
is
preferred
disposal of IO?
interlocutory
Respondent
application.
shall not move, come to petitioner himself. What? Till disposal, respondent shall not make.
Also, my lord, against that order, they have preferred criminal appeal. That is pending for
Your typed copy is very bad. Can't understand anything out of it.
Let me read that portion. Till disposal of IO.
The handwriting is as good as my handwriting. Call to shall not dispose the petitioner till orders on IA
Please, madam.
and shall not visit the place of residence of the petitioner. Now this is in 2024.
Please.
What happened after that?
After that, my lord, they have preferred the petition before the, my lord, assistant commissioner under.
What happened in the DV matter?
DV is pending, my lord. That is pending for arguments of the respondents.
Till disposal of IA.
Only disposal of IA.
IA
They have
is
to
still
address
not
the-
disposed after 2 years.
My lord, they are not addressing the arguments.
Who is not addressing?
The husband and the in-laws, my lord.
So
Respondent
that
number
IA
4.
is still pending.
Please, my lord.
But they've taken it up in appeal. They've taken up that in an appeal.
That full bench decision of the apex court, my lord, very clear, my lord. When there is a conflict between two acts, it has to be harmoniously construed, my lord.
Can't pass an order against another order.
True, madam. True.
When you're put on notice
Yes, madam.
that there's an order like this passed by DV court, can they pass an order contrary to the DV court's order?
No, madam, they cannot.
And AG accepts notice for respond number 1, issue notice to respond number 2 and 3, returnable by 13th August. The CJM Rural Court Bangalore in criminal miscellaneous number 228 of 2024 filed under section 12 of the Domestic Violence Act had restrained the respondent therein from dispossessing the respondents 2 and 3 from dispossessing the petitioner till orders are passed on the interlocutory obligation by imposing cost of rupees 500 since the respondent did not address arguments. The submission of the learned counsel for the petitioner is that they said interlocutory application is still pending consideration and no final orders are
Against
passed.
that order, criminal appeal is pending before the appellate court.
No final orders are passed on IA. No final orders are passed on the interlocutory application. And as said, the interim order continues to be in operation. Though an appeal has been filed,
Filed by the respondent number 2.
respond number 2 and 3 in number in
That's 22 of 2026.
22 of 2026. There's no interlocutory, there's no stay of the order
no stay,
dated
madam.
2/6/24. And on that basis, the learned counsel for the petitioner submit that the order dated 2/6/24 ought to have been taken into consideration by the assistant commissioner. Though both the DV Act and the Senior Citizen Act are beneficial enactments, any order, if passed under any of a prior order passed under any of the above enactments would be required to be taken into consideration while passing a subsequent order. Ex facie, the order passed by the tribunal is subsequent to the order dated 2624, which continues to be in force.
28/2024. 28/2024.
28 are
Please.
6 and 2824. Adella change my 2824. Hence, the operation and execution of the order dated 12/6/24 and miscellaneous 12/6/26 and miscellaneous number 115 of 2025 passed by respondent number 1, Assistant Commissioner at Annexure F, is stayed till the next date of hearing. Process fee and copies to be furnished by end of day 16th July, failing which the interim order will stand automatically vacated.
44,
Same order maybe.
44 command, cyber command. Yaru? Bank, which is the bank? It's not the same order then. IDFC is who?
Suresh V,
Suresh B for respond number 3. Notice to respond number 4 and 5 is deferred for now.
45, Prithvish LK,
I1 and I2 are allowed. Yes, Prithvish?
Your lordships have considered these similar matters, but I'll just, because all the interim orders are in the facts, therefore I just want to place the facts. Like petitioner, my lords, has worked as RRT Shirastadar in the relevant place for 8 months from August 23 to March 24. Page 25 is my posting order, my lords.
Where is our earlier order?
Your lordship's order is at page 48, 50 and 54. Your lordships, my lord, saw the facts in each case, the rule, and then granted.
Yes.
Therefore, my lord, I just don't want to rely upon
correct,
it. Insofar, yes.
That was to charge of the Shirastha. Yes.
Let's, insofar as this petitioner is concerned, I have worked for 8 months, my lord.
From when?
From August 23 to March 24. I was transferred out in March 24.
And when was the 4D done?
My lord, it was, insofar as my tenure, it pertains to Khata, my lords. I have taken a specific contention, para 5.2, page 15. The Tahsildar would approve the mutation and send it down to me, my lords. Once it is sent down, my lords, I would write, the letter is written, my lords, page 36 to KIDB, page 36, my lords. Yes. Please let us know whether this land is acquired. KIDB writes back saying it is not at all acquired. It is within the industrial zone. That's all. Page 36.
Not acquired, but in the industrial zone.
Yes, it is because it's.
What is this endorsement?
Now, can I just show the impugned order, my lords? In the impugned communication, they say land is given to KIDB by the government free. Uchitavagi kodalagide. Therefore, page 40.
Because this is government land.
Let's,
this is claimed to be government land.
They say, but they say we have given it for free to KIDB. Allegation today is land is acquired by KIDB, but you have entered the Khata in name of private persons. And therefore, my lords, everybody who has worked in that office, my lords, is arrayed as one of the accused, and FIR is directed to be registered without noticing the role played by each one of us, my lords. My lords, insofar as I am concerned, I worked for 8 months. KIDB said this land is not acquired. Therefore, my lords, I passed down the file. What was approved by the Tahsildar? My specific case before your lordships is once it is approved by Tahsildar, I have no power, my lords, to go back on the approval and say that your approval is wrong. I only have to just send it down. But for verification purposes, Annexure C is the letter, my lords. KIDB says it is not acquired.
Yes.
And to satisfy your lordships, my lords.
This endorsement is, they should have clearly stated it was a government land and handed over by the government, therefore not required to be acquired and ಹೇಳಬೇಕಾಗಿತ್ತು. Then they would have been put on notice. Is not acquired is freedom to do whatever.
Final objection.
Now DG accepts notice for respond number 1 to 3. a perusal of the papers indicates that the petitioner was the Shiristadar, took charge as the Shiristadar on
August of 23, my lords.
August 23 and worked there until
March 24.
March 24, 14/3/24, during which time the Tahsildar had issued necessary directions for issuance of Khata, and it's only those directions which, and those directions were only directions which were implemented by the petitioner. Submission of learned counsel for the petitioner is also that the petitioner verified from the KADB authorities as regards whether there is any acquisition by the KADB when it is on behalf of the KADB, when it was informed that there is no acquisition on behalf of KADB, and after the verification, the Khata was issued. In that view of the matter, at present, it cannot be said that the petitioner is responsible for the allegations which have been made. Proceeding insofar as petitioner is concerned, he stayed till the next date of hearing. It is however made clear that the proceeding insofar as other delinquents shall continue. Delinquent officers shall continue. Connect with WP number 18842 of 26 and relist on any date has been fixed.
My lord, in that matter, no date is fixed. 29/7 in the one matter, my lord.
29/7/26.
Please. Deeply applied.
46. CH Virupachaya.
Appearing for petitioner, my lordship. My lordship, in this petition, my lordship, we are challenging the order passed by the respondent, my lordship, at annexure H, my lordship, page number 64, my lordship. In that, my lordship, upon complaint given by the respondent number 2 to the State Commission of my lordship, the order has been passed, my lordship, to in operative portion is at my lordship 70, page number 70, my lordship.
70.
Yes, my lordship. My lordship, for the same situation, my lordship, the OS has been filed, my lordship, for easementary rights, my lordship. That is pending consideration, my lordship, before civil court, my lordship. Upon that, my lords, they have filed a complaint before first respondent authority to.
Khata has been cancelled.
Yes, my lordship. In that, my lordship.
Telecast Commission, AC Manjunath for respond number 1 and AGA for respond number 3. PDO Magdi Taluk.
I was 6 and 7, my lord. 3 also, I don't know. It is Zilla Panchayat.
PDO Magdi Taluk
MS Devraju.
for 4. Executive Officer Magdi Taluk.
Same MS
Devraj.
Can I make a
AGA
submission?
for 6, 7. Devraj for 8. So basically, AGA for 3, 6 and 7.
No, 3 la. 3 is also Zilla Panchayat.
Oh, Zilla Panchayat. Deputy Secretary.
Only 6 and 7.
Zilla Panchayat to Devraj.
Yes, sir.
Can I make on submission? My lordship, respondent number 3 to 8 are not necessary, but he may dispense.
Let us have them also. Devraj for respond number 3, 4, 5 and 8. AGA for 6 and 7. Considering that the first respondent has passed an order cancelling a Khata in respect of a property which is subject matter of a civil suit in OS number 641 of 2022.
Yes, my lordship.
The operation of the order dated 4/6/26 and case number 288 of 2022 passed by the first respondent commission at annexure H is stayed till the next date of hearing. Process fee and copies to be furnished by end of day 16th July, failing which the interim order will stand automatically vacated.
Obliged.
47. Mohana Chandra.
Kindly pass over the matter.
Pass over.
Right.
48.
And for the petitioner Gold Company in the matter, your lordships. Last occasion, similar matter, this court has stayed, your lordship, at annexure G, page number 28, your lordships. Here, the respondent number 3 was Hosadurga police station, your lordships. Now, It is Kote police station, same Chitradurga, your lordships.
You have to cooperate with the investigation.
Your lordships, I'm cooperating with the investigation,
Then
but
your relief is virtually not to cooperate.
no, your lordships.
You're asking for.
No, your lordships. They come
To interfere in day-to-day activities, not coming to your place.
exactly. Your lordship, they served me the notice, your lordships, on 9th. According to that, I've submitted all the lectures and everything. They themselves came for the investigation, your lordships. While going back from my office, they say me that we already know there is no connection or anything. Even accused has admitted that he has never sold any gold to my company, your lordship. Then they say you just do the recovery as per the satisfaction of IO. Then we will not be issuing any notice, your lordships. Earlier, it was same Hosadurga police station with the same accused. Now it is come up to the Kote police station, your lordship, within the jurisdiction of.
Same.
Yes, your lordship, same accused. And the FIR is nowhere connected. It is for the cheating, your lordship. It is not even for the theft. The FIR is also
6 and 318.
FIR is at annexure F, your lordships.
318. How will it come as theft? Hmm. ಎಲ್ಲಿದೆಯಪ್ಪ ಟು ದಿ ಪೆಟಿಷನರ್ ಅಂತ ಎಲ್ಲಿದೆ? Yes. Yes, ಈ ದಿನ ಸದ್ರಿ ಆರೋಪಿ ಎಲ್ಲಿದೆ? Where is it that
Even last occasion, the same accused was the party to the FIR, your lordships. Even then, there was no records.
Pakistan Gold ಕಂಪನಿಯಲ್ಲಿ ಮಾರಿರುವಾಗಿ ತನಿಖೆಯಿಂದ ತಿಳಿದು ಬಂದಿದೆ. They have sold it to you is what there's an investigation.
Your lordships, even our records doesn't show any transaction with respect to this.
That's subject to trial.
Location, the same accused has come to our place, your lordships. Even then, he has denied. Even now, they only the investigation officer only openly says us give the recovery as per our satisfaction. There is one lady SI, your lordships, who has also served me a notice on Saturday.
Madam, we are not
Sunday.
impressed with all your allegations. There are many more allegations against all the
Yes,
gold
your lordships,
companies.
because the same accused and everything.
Because of these gold companies, that lot of gold theft is happening in the country.
No, your lordships.
Please don't make allegations just like that against the police officers.
The notice. Have come and seen all the records, your lordships.
Please cooperate with the investigation.
Your lordship will cooperate with the investigation, your lordship.
And
That
AGA
is,
accepts notice for respondent 1 to 3. Petitioner is before this court seeking for the following leaves. The contention of the petitioner is that the grievance of the petitioner is that the police notices have been issued by the respondent police to the petitioner seeking details of the gold articles, ornaments sold by unknown persons to the petitioner. And it is contended that prior to respondent number 3 investigating the matter, earlier investigation had been made under crime number 323 of 26 by the Hosadurga police station. And therefore, it is contended that there are two investigations which are happening simultaneously. Learned AGA, by referring to Annexure E, submit that during the investigation it has been ascertained that the gold which is subject matter of the proceeding in crime number 142 of 26, registered by the Kote police station, Chitradurga, had been sold to the petitioner, and in furtherance thereof that the investigation is going on. This court has dealt with the issues pertaining to investigation in respect of theft of gold, as also sale and pledge of gold, which is subject matter of criminal proceedings in IIFL by its order dated 4th February 26 and WP number 31057 of 25, and has held that it is for the petitioner therein to cooperate with the investigation as per participate in the investigation. And if the police authorities were to call upon the petitioner to produce the gold, subject matter of the criminal investigation, it is required for the gold to be produced. The rest of the aspects as regards the ownership or otherwise would have to be dealt with by the criminal court seized of the matter.
Yes, sir.
The said decision would be equally applicable to the present matter. And as such, the above petition stands dismissed, directing the respondents to comply with the directions issued in IIFL Finance Limited.
Your Lordship,
Produce
the
the
FIR is also registered on 29/6, Your Lordship, and they say transaction has happened in last year, October, Your Lordships.
Yes, madam. A lot of people don't know if the gold is stolen. They give the FIR
That's for the
later.
cheating, Your Lordships.
They realize it later that it's gone. There are people who are near and dear, take it out.
No, Your
and
Lordship,
then
the
do it.
FIR is itself for the cheating, and now they are come for the theft recovery, Your Lordships.
Yes, next.
Much.
Yes, madam.
Appearing for petitioner, my lord. Petitioner is a purchaser of a flat, my lord, and there was an agreement between the petitioner and respondent. As per Annexure C, page number 31, there is an arbitration clause, my lord. As per the arbitration clause, we have sent a notice, my lord,
Why
as
is
per
this
Annexure
listed
A.
before us? Appointment of an arbitrator.
Yes, my lord.
Yeah, come on. Special order, right?
GMRES.
How is it GMRES? Eleven six antidella. A perusal of the prayers indicate that appointment of arbitrator has been sought for under Section 11 of the Arbitration Conciliation Act 1996. Registry to verify the classification and post the matter before the appropriate roster bench.
Serial number 50. Mohan Kumar D.
Appearing for petitioner, my lords.
Yes.
Let's I'm seeking police protection. Let's purchase the property in the year 2015, my lords. It is at Annexure B, my lords. My lords, later I have applied for a survey, my lords.
Have you filed any suit?
My lords, I have not filed a suit, my lords. I have yet to file. My lords, here the thing is, my lords, the respondent number.
Police cannot intervene in your civil dispute.
My lords, yes, my lords, but because here, my lords, the respondent number 6 taking 10 to 15 gundas, my lords, I have videographs also.
File a suit, get an
I have
injunction
also
order.
approached the police 112 call ಮಾಡಿದೆ 112 ಬಂದು my lords, they are troubling, my lords. That's why I am seeking for life, my lords, protection.
That is when you go to fence, Alva.
Yes, my lords.
You get an interim order, then go to fence. Don't do that until then.
Yes,
And AGA accepts notice for respond number 1 to 5. Notice to respond number 6 is dispensed with in view of the proposed order to be passed. Petitioner is before this court seeking for the following leaves. The contention of the petitioner is that whenever the petitioner goes to our alleged property to fence the land, respond number 6 interferes with the said activities and the threat to the life and liberty of the petitioner. If that be so, on that basis, the petitioner having approached the respondent police have not granted police protection to enable the petitioner to carry out the fencing activity. If that be so, it is for the petitioner to approach the necessary civil court seeking for appropriate remedies, appropriate reliefs, including police protection. And it's only if such police protection is ordered by a civil court that the police would be required to grant such protection. Without any order by the trial court, the question of granting police protection and thereby involving the police in a civil dispute is not permissible. For the above reasons, the petition stands dismissed, reserving the above liberty.
51, Samir Sharma.
Yes.
Lords, the petitioner, being a practicing advocate, had purchased some lands in Kanakpura. It's a very long time back he had purchased. Probably the real estate prices should have shot up there. So the landowners in conspiracy with the two other persons, they open fire in a firearm. They open fire. They shoot this person. The petitioner is shot. But then he sustains injuries and then he goes and gives a complaint. The complaint is registered only under 307. That is 109 of the BNS as of now. Arms Act is also not invoked. From there, they started their lacustrial activity or the attitude with which this investigation is to be handled. Because the persons against whom the accused, the persons against whom the complaint is made, that is the accused, they're all local persons there, having some. Not for the court to regulate, but the requirement, is that here they have to proceed to the spot, collect the necessary evidence, because forensic evidence is very important in this case. They don't even register it under the Arms Act. They don't seize the blood-stained clothes. And there is constant follow-up with this officer saying that, why are you not recording my statement? I go to the police station. They do not even come to the police station to get the MLC Millards recorded and to get the reports. Nothing is done. There's a complete lackadaisical approach on the part of this police officer, Millards.
Things are seized and sent to the FSL, madam. Waiting for the FSL report. Take away instructions and
And AGA accepts notice for respond number 1 to 5. Respond number 3 is directed to file an affidavit as regard the status of the investigation and the action taken. So there are serious allegations which have been made in the petition that the jurisdictional police authorities are colluding with the accused and the investigation is not being conducted in a proper manner. Released on 17 July at 2:30 p.m.
Please. Friends, the CCTV footages, Millards, of the police station may also be directed to be secured because after all these things happened, they called the accused. The accused came to the police station. They let them off. Only A1 is retained.
What is the shooting in Bangalore like this?
That too by using
Pillow
Millards.
shooting, Alapa, gun shooting. Gun shooting, Marty, if this is the way that you're going to handle it, irrespective of whether the petitioner is an advocate or not, that's a different issue. But even then, and Arms Act has not been invoked is a very serious issue. That clearly ex facie indicates 17.
Please, Millards.
Serial number 52, MS Raghavendra Prasad.
Mr. Raghavendra Prasad.
I appear for the petitioner in this case, my lord.
I appear for the respondent number 11 and 12, my lord.
My lords, this is a matter under the Senior Citizens Act.
Respondent 3 is the assistant commissioner.
Yes, my lord.
Yes.
Accepts notice for respondent number 3 also.
My
Registry
lord,
director.
everybody is served. They have
No,
accepted
respondent number 3
notice.
note is not ordered, is a note put up by the registry, that is why.
I accept notice.
So now you are for the petitioner. Who is
Yes,
for
my lord.
Rishak Banwara for R12.
11 and 12, my lords.
You are appearing for 11 and 12.
Yes, my lord. It is my colleague's name reflecting over there, my lord. Please just fill in.
Rajesh Rao for 5 and 11. Rishak Banwara for respond number 12 is what is printed here. Who are you appearing for?
My lords, 11 and 12, my lord.
What about 5? ಯಾರ್ಯಾರು ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿದಾರಮ್ಮ?
R5, Rajesh Rao K, R5 and 11.
Rajesh Rao K is also filed for R5 and 11.
Lords, there was an order by this honorable court that he was not discharged. The parties wanted to discharge Mr. Rajesh Rao, but since no acknowledgement was filed, he was not permitted to go out from this case. But
what is the date of the order?
Lords, it's 20th February 2026.
20th February, yes. Memo of retirement filed by stand rejected. So 11 and 12 ಇನ್ನೊಂದು ವಕಾಲತ್ತಿದೆಯಾ?
For R12, only for R12. Rishyat Banavara.
Rishak, you only filed for R12, not for 11.
My lords, I'll have it rectified, my lords. I'll have it rectified. There is some issue with the office as well because my colleague had also filed a wakalat from the same office. So there is an issue with that. I'll have it rectified, my lords.
So sort it out before the next date. Land Council for respondent number 12 submit that you would also be appearing for respondent 11 by filing wakalatnama. Registry is directed to verify the appearance of the council as also the service of notices on the respective respondents and submit a report by next date. Pre-list on 6th August.
Lords, interim order may be kindly extended.
Granted is extended till next day.
Grateful.
Serial number 53.
I'm for the petition in this case, my lord. My lord, in this case, I have challenged the settlement agreement which is being signed in the mediation center. And my lord, last date, the lordship has ordered me to for maintainability. With respect to my lord, when I did the research, all the Supreme Court says that, all the Honorable Supreme Court says that we need to move an application before the trial court to recall the same. So I may be permitted to withdraw the petition and may be permitted to file a necessary application before the trial court itself.
Petitioner is before this court seeking for the following leaves. Learned counsel for the petitioner seeks permission to withdraw the above petition with liberty to move the trial court, which was seized of criminal misdemeanor number 141 of 2022. Reserving such liberty, petition stands disposed.
Liberty to move an application.
Reserving approach zone to reserving liberty.
Much obliged.
Serial number 54.
Yes.
Petitioner is a NGO. Had made an application as provided opportunity by the BBMP to engage in the work of the segregation of the waste, dry waste manner. That application has been, even though the regional MLA has been recommended, judicial Vijayanagara Ward 57, 9th respondent has not considered it. Under that circumstance, having that information issued by this from persons made an application for getting the information. Why my application has been not considered by the 9th respondent?
What is the application that you filed?
Annexure C, page 25. The work of the segregation of dry waste, if is provided to the NGO, what is the source received from the NGO, from the authority, will spend on the
Guttige Kelsek, you can't give a letter. You have to apply for a tender when they issue a notification.
That process has not been taken by the authority.
So you can't.
Therefore, whether the work has been allotted through process of tender or directly, made an application to get the information.
This is for information.
In which procedure has been adopted to the engage the allot the work. It was information given by the 9th respondent, kindly similar annexure D2 code. Allige yari kottidare our same day on 17/3 page 32 in the end ಯದಲ್ಲಿ 17/3/26 ಗಿರಿಜಾನ್ ಅವರಿಗೆ ಲೆಟರ್ ಅಥಾರಿಟಿ ಇಂದ ಕಳಿಸಿದ್ದಾರೆ. ಗಿರಿಜಾ ಅವರು ಸೇಮ್ ಡೇ ರಿಸೀವ್ ಮಾಡಿದ್ದಾರೆ, ಸೇಮ್ ಡೇ ರಿಪ್ಲೈ ಕೊಟ್ಟಿದ್ದಾರೆ. ಈ ರೀತಿ all the authority 9th respondent overall taken the work from the 9th respondent this very same day. This document has given to the 9th respondent, same has been given to us. This document itself shows the fraud and involvement by the personal interest of the 9th respondent. Therefore, My lord, that is true, my lord. Procedure has not been adopted by the ninth respondent to allot the work. At the same time, the illegality is taken by the ninth respondent for non-considering my representation also.
What is your representation, Mr. Counsel?
Representation, my lord, as a recommendation
Take
made by
necessary
the
action against ninth respondent for illegality done during the reference of Annexure D and D.
D.
What is Annexure D?
Annexure D is, my lord, information given by the against my application. I sought some information why my representation was not considered. What is the reason to know?
You have an appellate remedy in that. How can you ask for action to be taken here?
My lord, my grievance is only non-consideration of Annexure C. Therefore, I am not.
You asked for certain information.
When information I received from the ninth respondent, then I came to know that some illegality for non-consideration my representation submitted in Annexure C. My grievance is only if consider my
Under
Annexure
the
C.
RTA Act, there's a hierarchy that you have to follow.
Please.
Follow that hierarchy.
But
Only after the KIC, then you can come here, not directly to the High Court.
My lord, that is true, my lord, but my grievance is mainly not giving the providing the opportunity to work as per my representative Annexure C. I'm not intended to contest the challenge the illegality, but my grievance is only the consideration my representation.
There are two aspects that you sought
Please,
for.
two
Some
aspects is
information you asked for, and you asked for work to be given.
Please.
For work to be given, we already told you, it's only if a notification is issued, you can participate in the tender.
Information has been provided by the authority. Based on that information, they have not denied giving the information. They have provided me.
Allappa, first, to give you work.
Yes.
To give you work, unless they issue a tender, unless you participate, you cannot be considered.
Please.
The information, if this not been given or wrong information is given, you have
My grievance is only non-consideration of Annexure C.
for to give you work.
Direction of this honorable court to take necessary action against the ninth respondent because ninth respondent is doing the illegality.
By not giving you the work.
Please.
How can that be illegality?
That Annexure D and D is what they have provided that
accepts
itself is they
notice
are demonstrating.
For respondent number 1 and 2, 1, 2, 4. Three and 5. Shri Pawan Kumar is directed to accept notice for respondent number 7, 8 and 9. Petitioner is before this court seeking for the following leaves. The grievance of the petitioner, as sought to be made out during the course of argument, is that the representation submitted by the petitioner on 1/12/23 at Annexure C for providing solid waste segregation work to the petitioner NGO has not been considered, and further that respondent number 9 has not allotted any work to the petitioner. A petitioner cannot claim for allotment of any work by way of a representation to a statutory authority. If works are to be awarded by the statutory authority, the same would have to be done in terms of by following the due procedure under the Karnataka Public KT. It is always available for the petitioner to participate in such tenders, and if successful, the work would be awarded. No work can be awarded on the basis of a letter representation.
And they have not invited any application through procedure of the
Then
tender.
there's no work.
That they have given work to the
merely because there is
Annexure
no-
D, the Annexure D, they are giving provided work. They are given a work in as per the information provided to me. 4 ಜನ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಆಮೇಲೆ ಲಾರಿ ಅವರು ಕಾಂಟ್ಯಾಕ್ಟ್ ಅಲ್ಲಿ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅಂತೆಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅದೆಲ್ಲ ಟೆಂಡರ್
They have allotted that work they have without following procedure of the tender as lordship said. That is my agreement. If it is
Today
open
only
the tender process.
Monday there are 14 tender matters which are being taken up. All tenders, all zone wise it's been done. A letter representation cannot be a source of securing work. from a statutory organization. No grounds being made out, petition stands dismissed.
My lords, may I mention one matter, my lords?
Yes.
Serial number 111 in list 1.
Uh,
My lords, it's a tender matter, my lords, where there is an interim order. We had filed a vacating stay. Road
Whenever it
works are
reaches-
stalled, my lords. I request at least tomorrow at the preliminary, my lords, because vacating stay application is there long pending. There's a road works, my lords, which is completely stalled. Some urgency, my lords.
Mr. Rajshekar, sorry, Siri Rajshekar. Where is Sarvanan?
Yeah. At least I request 2:30 tomorrow, my lords.
Not tomorrow, madam.
Day after Monday. Some, at least a time is given, my lords.
Every
because
day there are more than 150 matters next
only
week.
public work, my lords, money, sir.
Everything is 111. IA 3 of 26 will be considered along with the main released on 23rd July at 2:30 p.m.
Great.
Lordship 600,
Serial number 100.
Yes.
For the respondent bank, the week's accommodation is certain information has to be presented.
100.
100.
Have you informed the petitioner?
Yes, my lord. Yes,
100
here.
at the request of counsel for the respondent released on 23rd July.
Serial number 18. Obliged, my lord.
80?
My lord. I am permitted to withdraw the.
80.
18. 18. 18.
18.
18. Not 18. Permitted to withdraw the liberty to approach the permanent authority.
18. Idarudalla. Petitioner is before this court seeking for the following leaves. Memo has been filed which reads as under accepting said memo. Petition dismissed as withdrawn, reserving liberty to the petitioner to approach the appropriate authority.
serial number 66, I'm filing rejoinder, my lord.
Yes.
A copy has been given to the other side. One,
Counsel for the
one
petitioner
copy,
has filed-
one page missing, my
is
lord.
taken on record. Counsel for respondent number 2 seeks for and is granted 10 days time to go through the same and make a submission. Released on 30th July. Interim order earlier granted is extended to the next date of hearing.
ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ ಅದು ಕಾಪಿ ಕೋರ್ಟ್ಗೂ ಕೊಡ್ತೀನಿ ನಾನು ಅಂದೆ
ಅಲ್ಲಿ ಮತ್ತೆ ಹಿಂಗ್ ಕೊಡಬೇಡಿ.
ಒಂದ್ ಪೇಜ್ ಮಿಸ್ ಆಗಿದೆ ಅಷ್ಟೇ.
ಯಾವ್ದಿದೆಯೋ ಫೈಲ್ ಸರಿಯಾಗಿ ಮಾಡಿ.
ಆಯ್ತು.
ಅದೇ ಹೇಳ್ತಾರೆ ಶಿವರಾಮ್ ಅವ್ರು, ಇಲ್ಲಿ ಮತ್ತೆ ಇಲ್ಲಿ ವಾಪಸ್ ಕೊಡಲ್ಲ ನಾವು.
ಬೇಜಾರಲ್ಲ, ಎಲ್ಲ ತಪ್ಪು ಮಾಡ್ತಾರೆ ಹ್ಯೂಮನ್ ಬೀಯಿಂಗ್ಸ್, ಕಮಿಟ್ಮೆಂಟ್
ಆಗತ್ತೆ ಬಿಡಿ.
ಅದಕ್ಕೆ ಅವ್ರು ರೇಗ್ತಾ ಇದಾರೆ ನನ್ನ ಮೇಲೆ, ನಾನು ಏನ್ ಮಾಡ್ಲಿ?
ಅವ್ರು ನೆಕ್ಸ್ಟ್ ಟೈಮ್ 2 ಪೇಜ್ ಮಿಸ್ಸಿಂಗ್ ಆದಾಗ ನೀವು ಹೇಳಿ ಅವ್ರಿಗೆ. 74.
Senior counsel Sanjay Ghosh has been engaged in this matter, your lordship. Today he is unable to fly down from Delhi since the Supreme Court has just reopened. He is requesting a date.
74 is a police matter.
True, your lordship.
Yes.
For the petitioner, senior counsel Sanjay Ghosh has been engaged in the matter.
Aitappa, we don't want to know the name of the senior counsel. What is it that you want?
August 4th, if it is accommodated, he shall be here.
74, the request of counsel for the petitioner, 4th August.
That's your lordship.
Lordship, date matter is not listed, your lordship.
What do you have?
It had been given, your lordship. The urgency is, I pledged my gold. Lordship, one submission.
We can't hear any matter without the file before us.
Lordship, the amount as transaction for the dormant account, your lordship. 1619 become 1916. And lordship has directed to send the notice. Notice has been sent. It has been came as an unserved, your lordship.
Number 110. Your Lordship, kindly recall. On 10th, it was argued by me and senior.
Adjournment.
Adjournment alla, that should be taken up early in Yakandre.
Whenever it reaches, it will be taken up in Syria. That's how much we can say.
Immediately after.
One, whatever reaches will be taken up. Same thing as what we told Mr. Ashwatthappa will apply to you.
Allah, immediately after the second list,
We are raising today at 4:45. 4:40 till 4:45, whatever is taken up is taken up. Today we are not sitting late.
No, I have no worry. By the time it reaches, my lord, very well.
Where shuru madakbidi, Mr.
Forward bench matters. Serial number 1.
Please, my lords. My lords, in this I am for the petitioner, my lords. The present petitioner has accused number 3 and 5, my lords. The offence punishable under section 31 and 36 of Legal Metrology Act.
None appears for the petitioner.
My lords, in this I am for the petitioner, my lords. My lords, I am for petitioner in this case.
Good. Yes, Jafar, who will appear in this?
Please, Lords, I am appearing on behalf of respondent.
Yes, Praveen, ready?
Sorry, Lords, I need some time, Lords. Because, Lords, I have written a letter to the official, Lords, he has not come.
By when will you get instructions?
By next week, Lords.
The request of the learned AGA released on 27th July at 2:30 p.m.
Please,
by 27th, get instructions.
Please.
Serial number 2. Dayanand Embandi.
Here for respond number 3, my lords.
Yes, Praveen.
Lordships had directed.
My friend is appearing.
Yes.
Previously, affidavit was filed on situation note.
Yes.
Lordships, previously, affidavit was filed, my lord. Thereafter, my lord,
Somebody is connected by so. Really.
25/6/26, my lord. Principal Secretary has written to all the departments to comply the directives. Not to kindly see the first letter.
But what is the status of compliance? And AG has submitted the Additional Chief Secretary, Revenue Department has written letters to all the concerned for compliance. And on that basis, she submitted that compliance would be made. She is directed to file an affidavit of the concerned person by next date, indicating the compliance is made, released on 30th July.
Serial number 3.
Lords, in serial number 3, Lords, R2 was ordered to be present, Lords. It seems, Lords, she is present.
Really, where is she? Here.
Yes.
Yes, madam. And what is the compliance?
Directions are given to Principal Secretary, Law Department, and from Home Department. Lordships are directed the concerned person from Home Department to be present.
So who is to comply? Who will do that?
Law Department. Secretary, Law Department.
Respond number 2 is who here? home. So you say it has to be complied by the law department. So so and so respond number 2 is present before this court in person. And AGA submits that it is the law department which is required to comply, initially comply, and thereafter it is for the home department to comply. Hence, law department is not a party to these proceedings.
Yes, Your Lordship.
Hence, the state of Karnataka, represented by the Principal Secretary, Law Department, is brought on record as respond number 5, and AGA accepts notice for respond number 5. She is directed to file an affidavit of the concerned officer of respond number 5, indicating the compliance is made by next date, released on 30th July.
Please, as per direction number 12.33, minutes, Principal Secretary, Law Department.
Law Department. They should have brought them on record. Yes.
Please.
Serial number 4, Venkatesh M. Karvi.
Minutes, in respect of serial number 4, minutes, yesterday, minutes, I received a letter from the Additional Chief Secretary to Revenue Department. That minutes, they need minutes, still 2 months time for reporting the compliance.
2 months?
Yes, ma'am. I have filed a memo also, minutes, but it may not be made available to Honorable Court, minutes, because yesterday only I have filed.
Yes. I mean, our court is very efficient. Don't worry, it comes to us.
Grateful, minutes.
And AGA has filed a letter addressed by the Additional Chief Secretary of Government, Revenue Department, to the Additional Advocate General, indicating that the Government of Karnataka, after taking into consideration the directions and deliberating upon the matter, has undertaken the exercise to frame the appropriate rules regarding appointment and service conditions of Grama Sahayaks after consulting all the stakeholders and taking into consideration similar rules in other states. On that basis, he seeks for 2 months' time to report further compliance. Released on 28th September.
Please, there's one more request.
Yes.
The daily orders, minutes, after minutes, disposal of the cases, minutes, in some of the cases were not uploaded, minutes. If they were made available, minutes, we will be
Submits
efficient.
that some of the orders in disposed matters are not visible on the website. Registrar, judicial and registrar computers are requested to look into the matter and ensure that all the orders are made available, are made visible on the website. Yes.
Please.
Kalburgi bench matters. Serial number 1, R.V. Nadagowda.
Yes, madam.
In persons of the direction of the Honorable Court, my lords, affidavit of Secretary E-Governance has been filed. Today it was filed. If it is made available.
Today, Andre Barala, yesterday would have come. And submit that an affidavit has been filed. Registry is directed to place the same on record. Relist on 21st at 2:30 p.m.
Serial number 2.
Report received from registrar computers. Idar. Yes, Mr. Abraham.
There were 3 points that your lordship raised. One was uploading of the document that were not in a proper
Transport Department.
Yes, my lord, Transport Department, as per the proper format, my lord. Now, my lord, as per Annexure A, if your lordship to kindly see, NIC Chennai has reintroduced the reject and return functionality.
Has introduced.
That's been introduced. So what happens if the document is not clear, either they can reject or return it, so that the departments can reload it in a proper format. The data could be in any scanned format or in a proper format which is readable and visible, my lord. That is one aspect of it, my lord.
Yes.
The other aspect is, my lord, the lordship had directed the development of detailed dashboard for monitoring. That is in process, my lord. The annexure C, if lordship could kindly see, serial number 2, my lord. Serial number 2, my lord, development of a detailed dashboard for monitoring the EDAR application. There, my lord, the national NIC has informed this office that certain modifications have already been carried out. Now, my lord, what has happened is the modifications that are there with regard to the insurance company, the DR form status, and district-wise percentage of the DR form submitted, all this will be collected, and finally, my lord, will be uploaded. Now, my lord, they will require some more time
For that dashboard.
for that dashboard.
How much time would be required?
Maybe around 4 weeks time, my lord. But then we can place what has happened in the 4 weeks.
Abraham, you have anything to say? On mute. Your voice is not clear. It's very garbled. We can't hear you well. Anything else?
That's it.
There's some problem in his connection.
The 4 weeks time may be granted, but then we can.
And AGA has filed a memo enclosing the
Am I
letter.
audible, sir?
Yes, you are audible now.
Sir, one more direction was there regarding e-signature on the documents which are uploaded by the concerned authorities. So NIC Chennai has also done that, and we have communicated to all the concerned in this regard also, sir. So that direction is also followed. Now only one thing is pending is regarding dashboard that is under development.
So then we are ready for implementation. Completing.
Annexure B is, my lord, the notice issued by the PCW to all the stakeholders to implement it as soon as possible with all this.
Please follow it so that this will save a lot of time for a lot of people.
Yes, ma'am.
That AGA has placed the letter dated 14/7/2026 addressed by the Inspector General of Police, Police Computer Wing to the Additional Advocate General, which reads as under. Both the learned AGA as also Sri Laburam, learned IGP, who appears to video conferencing, submit that the NIC has provided the e-signature facility for all forms in the EDAR application. And this has been rolled out to all the concerned stakeholders. Going forward, all uploaded documents will bear the e-signature of the person who has uploaded the said document. They also submit that a functionality of reject return of the documents uploaded has also been added. Who will have the right to reject and return?
No, the reject and the thing, not regarding the authenticity.
IU will have that.
IO will have it.
Yes.
But apart from that, my lordship, if you recall last date of hearing, my lord, some pictures were produced before the lord.
Who will have that right to reject?
That I see.
Investigating officer.
Each one rejecting the other.
Yes.
Right to introduce a feature of rejecting stroke return of documents, which will be exercised by the investigating officer on verification of the documents. Since the fulcrum of implementation of the EDAR platform is the investigating officer. And the event of rejection or return by the investigating officer, intimation would be received by the concerned who had uploaded the document which has been either returned or rejected to enable them to re-upload the proper document. As regards the implementation of dashboard, it is stated that though several modifications have been done by the NIC and many of the requirements are covered, there are certain other minor modifications which are required, namely insurance company-wise report, DAR form status, district-wise percentage of DAR forms submitted, and a Excel download facility. In this regard, communications have been addressed to the NIC. It is stated that the implementation is under progress, would take around 4 weeks' time. A compliance report of the registrar computers has also been placed on record, which indicates that a meeting of all stakeholders was convened and the issues have been taken up, pending issues have been taken up, which would be completed at the earliest. Pre-list on 24th August for reporting further progress.
The Lordship may just.
Thank you, Mr. Laburam.
Thank you, sir.
Well, I've just given the place the document, not a memo, my lord. Lordship said memo, just the document, sir.
Memo is filed a letter dated 14/7.
List number 2, 230 matters, serial number 1, Sunil Kumar Patel.
Number 3, Lordship.
Who is respond number 2?
Up to array. I'm for respond number 3, Lordship.
Who is respond number 2? Notice not ordered and.
Works minutes. Work board. Karnataka State Work Board is respondent number 2.
(2013) matter, why is it before us?
Special orders minutes. It's come by. Last occasion also the matter came up. Your Lordship said asked. It's come by means of a special order minutes.
Yes. Respond number 2 is the Karnataka State Board of Waqf, Darul. You will accept notice. The P.S. Malipatil, who has appeared for respond number 1, accepts notice for respond number 2 also.
They're already notified minutes. They have
registry. When it comes up, we realize a lot of these issues. Registry is direct print his name as such. Mr. Rashid Khan.
Respond 3, Lordship.
3. Notice, AGA accepts notice for 4 and 6. State of Karnataka, Commissioner of Police. Pawan, Joint Commissioner Elanka. Pawan Kumar, Wakalat.
Pawan Kumar.
Where is Pawan?
Pawan's name is shown.
Anybody for the BBMP? GBA.
BL Sanjeev.
Respond number 5 is the Joint Commissioner Elanka Zone. BBMP.
Bangalore North. Like now Bangalore North.
You are the GBA North. You'll take notice. Shri Karthikeyan accepts notice for respond number 5. Registry is directed to print his name as such. Anything that he has to say is a formal party or what is GBA?
GBA is a formal party
The
minutes.
khata persons who are holding the khata.
Only a formal party minutes.
To issue circular and issue in respect to lands owned to declare that there is no manner of right to not serve investment. Right? To issue appropriately. Here C and D L.
Yes, an amended writ petition minutes which is filed.
When was it filed?
It's amended writ petition is filed.
Should carry out the amendment in the petition, otherwise.
Because the court directed to file an amended petition minutes.
To also file an
I
amended
understand
petition,
minutes. The
but
proper procedure is to carry out the amendment and then.
Otherwise, they will miss out on the amendment. In all these papers, when they type it out, it won't be searched. And 2 of your prayers or 3 of your prayers will not be addressed.
That's 2 minutes.
On the amended petition.
I think 29th of October 2024 amended writ petition was filed minutes.
There are 2 amendments. There's one filed on 12/7/24.
One was an amendment relating to the cost title. The other one was the amendment minutes where some pleadings were inserted, including the prayers.
29?
This appears to be filed on 29/10/24.
24.
amended cost title was filed and also the, I'm sorry, my lords, sorry. Seeking amendment of petition is filed. Lords, it is filed on 12th July 24. I stand corrected. 12/7. Lordship's right. It's 12/7.
So what is the amended prayer?
The side note, my lords, the reference is made, what is inserted by means of these amendments. At para 8A to 8B. And then, lords, in the prayer, in the grounds para 9 and 10. And the prayer.
So the notification is the Waqf notification you challenge.
Yes. My lords, the, just a prelude to what this writ petition is all about, my lords. The notification is issued saying that survey number 55/1 of Jarak Bande Kaval, measuring 1 acre, is a Sunni burial ground. No difficulty about it. But then what happens? This Jarak Bande Kaval is adjoining one more village.
Before you get these, all the pleadings, everything complete.
The pleadings are complete.
Anything about this matter? It's coming up for the first time. So
the pleadings are complete, my lords.
Maybe directed, because in the petition that he has given on the date, what he mentions, do not see GBA being a party here. So
GBA is not a party. BBMP is.
BBMP also
The
not featured.
transition provision says that they are deemed to be parties. My lords.
That's
For me
I
to-
will take at my own cost the entire set from him. And
Yeah.
because that is not there now. For the first time, I'm saying BBMP for what?
Both of you should
That's
not
one.
be speaking of that.
Two.
See, in the amended petition that you have filed on 12/7,
please, my lords,
the additional parties who were added are not found mention of.
Lords, then there is this amended cost title came about on 29th of October 2024.
That's what 2024.
29th October 24.
Yes.
So that was subsequent.
That's a
Could have
subsequent.
been there.
In the 29th.
There, the
October
court directed to file the amended cost title, which was accordingly filed. But as your lordships indicated, my lords, it is not appropriate for us also. I will file a consolidated writ petition amended so that I fully understand.
Since there are so many filing, what we would request you to do is, both of you.
Lords, I have filed a compilation, my lords.
Convenience set.
I have already filed a convenience compilation along with the synopsis.
Filed it.
Yes, already filed.
What is the
This was filed, my lords. Could file agida later.
Synopsis along with.
And we have served this copy, my lords, on all the respondents. I have the acknowledgement for having served all the respondents.
325.
Yes.
Filed some time ago.
And this is served on all the respondents.
This is the only document that you are going to rely upon, nothing else.
Nothing else.
But the last of the corrigendum which is questioned is issued by the state government, not by the board. I had made this submission on the two. I had made two submissions. One is very on the maintainability itself, because these are all corrigendums. We have decisions, division bench decision, direct decision, that because both of us, it's an issue of identity of property. Which is his property, which is our property, it's identity. Minute we come to identity, it is my humble submission that there is a specific tribunal with powers to conduct evidence and everything, and then by mere summary proceedings probably cannot decide whether jurisdiction is there, notice was given, opportunity was
Do you
given.
think Mr. Ravi Shankar will
I'm
agree
only
to?
saying my submissions. The last and the final submission is the last of the corrigendum is now virtue of the amendment to the Waqf Act has to be issued by the government. They have issued, so they may also have to say. I requested my learners in the last.
Can I say this, my lords?
Objections. Maybe if your lordship would consider the.
Have you filed your?
We have filed our objection.
Can I, lords, can I say this?
One nimsham. Respond before you get into your match.
No,
Respond
I
number
wish
three.
that the Waqf board and the state was as fair as the submissions of my learned senior friend.
Mr. Rashid, have you filed your?
I
will make a even much fairer submission to the.
I'll
court if my
indicate,
learned
my lords,
is agreeable.
I'll indicate, my lords, what kind of.
Can you just hold your horses for 5 minutes?
Quiet for some time.
Mr. Rashid,
Please, sir.
you
I've
have filed your.
filed my objection.
You want to file, you don't want to file?
They have filed objections.
You have filed.
Yes. Earliest point of time.
We have not filed one. We will file.
You want to file, you don't want to file?
We'll file it, madam. Now that.
Will you file?
2 weeks.
Lords, I have.
2013 matter. By special order, it has come. It can't be.
A week's time, my lord.
Anybody else to file, all done, alva? So convenience set, you have only.
I will file my objections. Gold set is not there in this. He has served on the AOR.
Then do one thing. Both the AORs can look at this synopsis and whatever.
Whatever needs to-
Synopsis you can keep separately for each of you. But the documents, you make a consolidated set, continuously numbered, refer to the same set, not volume 1.
All the
volume 2.
documents which they have produced along with their statement of objections have made it as a part of this compilation.
Let
Very well,
both
Manoj.
of them sort it out. Karthikeyan?
BBMP is a formal party, my lords. On the basis of this notification, since the Khata is entered as burial ground, we said that the Khata
They're
as
a
recorded
party.
by
If
them.
they want to file something, let them file. You can't say don't file. Learned Counsel for Respond number 1 and 2 has filed a statement of objections. Learned Counsel for Respond number 1 and 2, as also Counsel for Respond number 3 has filed a statement of objections. Insofar as the learned AGA for appearing for Respond number 4 and 6, he seeks for and is granted a week's time finally to file a statement of objections. The Karthikeyan, who has today accepted notice for Respond number 5, also seeks for 10 days time to file a statement of objections. Objections, if any, to be filed on or before 24th July 2026. Considering that the matter is of the year 2013, no further adjournment would be granted. If objections are not filed by that date, it will be taken as not filed and matter proceeded with. Shri D.R. Ravishankar and Senior Counsel submit that the synopsis along with supporting documents has been filed on 14/3/25. Considering that there are numerous filings over the last decade or so, it would be required that a convenience set of all the parties be consolidated into one and filed. The respective advocates on record are directed to coordinate with each other and compile a common convenience set and file the same, which shall be filed on or before 30th July 2026. Relist on 6th August. After you file, you give your copy, both of you.
Yes, please.
So they'll get 1 week to compile it.
At 2:30 minutes, if I can request. 6th August at 2:30 minutes.
So the 6th is a Thursday.
Yes.
Thursdays I give pro bono for mediation. 5th you know,
7th August.
Fine.
ಅದು 7th Friday ಆದ್ರೆ ಒಂಚೂರು ಆ ಕಡೆ. ಅಲ್ಲ,
ಮಾಡ್ತೀವಿ.
5ನೇ ತಾರೀಕು 2:30 ಇಟ್ಕೊಂಡ್ರೆ
5th August.
ಪ್ಲೀಸ್ ವಿನೋದ್. 7th
Anyway,
ಅಕಸ್ಮಾತ್ ಏನಾದ್ರು
2013 matter will come at top of the
please
list.
Vinod, it will come. If it could be taken up at 2:30 minutes so that.
It will be the top of the list. There is no older matter than 2013 before.
Not if it is in the hearing matters, Vinod, the difficulty is that the matter was earlier listed on multiple occasions because it was in the hearing list,
The
the matter
respective
never
councils
reached.
are also directed to file the respective synopsis of dates and events, list of authorities along with authorities.
also.
After serving an advance copy on or before 30th July 26.
Please.
There are some practical difficulties. My learned friend said I'm fair. I would like to be even more fair. Not in color, but in my submission. But there are, he fairly submitted it's a kabristan. So there are cupboards there. We've got enlarged photographs to say.
Is there any survey required to be made?
That's it. So now these are all actual photos of as late as 2-3 months before. Last time it was this time, I've asked for it. We can see real tombstones and there are. If they can survey and leave, this is what I have without yet instructions. I feel this would be the fair thing. Wherever there are burial bodies, leave that. Remaining, if there is anything which comes in that survey number. Why I say so? There is one sale deed of 55/1. So initially they purchased the same property which was notified. Then they,
What is the survey that you want?
Can I just,
I'm only-
Vinod, I just indicate, Vinod.
One nimission, let us hear.
Why
Very
am
well.
I saying this? Either neither easy. Both our documents, because he also keeps changing his document, get on amendments
all.
to his survey.
Don't make allegations
all.
right now.
No,
During the course of
it's all
argument,
in
you
the-
can do that.
It's all
Not
in
at all.
the-
For a survey, what is the survey that you want?
Now I feel, now factually these are. I will not convince. This is a matter for trial.
That's a proposal.
That's a, this is a matter for trial, and I'm only going to argue. If you Lordship will see, my initial submissions from 2013 matter was filed. It took up for the first time only after 10 years, after 12 years. It never came up before the board. From then till now, I'm only saying petition is not maintainable. But after having spent so many years in court, I
This
feel.
is your proposal. You can get instructions from your client.
Because they can't take the land and remove all the cupboards from there.
No,
Otherwise we will be fighting only.
as a matter of fact, one of the judgments, the coordinate bench is actually seized of one of the matters of the kind.
Yes.
That is not regarding the works. What it said is, the Panchayat said that this is going to be the Kabristan or the burial ground. So then the particular community, they started burying the bodies in that. Then ultimately the matter went up in the civil court up to this honorable court, said no, the property belongs to so and so. Next question is what should happen to this? Then we laid upon a judgment of a Kerala High Court and Tamil Nadu High Court, the Madras High Court, to say that the moment this exercise is undertaken, it's the responsibility of the local authority to exhume it and then place it in the place where. So that's a question which we were arguing, Milords, before a coordinate bench. The coordinate bench said that you cannot do it. Law doesn't permit you to permit the. Now the whole difficulty for us is that we had about 1 acre, 12 guntas of property in survey number 56 per year. Title I have no difficulty, I demonstrate, Milords. Now what they did, they notified survey number 55/1 1 acre.
Argument ಬೇಡ.
ಅಲ್ಲ ಈಗ ಅವ್ರು ಏನಂದ್ರೆ ಅವ್ರು 55/1 1 acre ಏನಿದೆ ಅದು ಕಬ್ರಸ್ತಾನು. ಅದ್ರೊಳಗೆ ಜಾಗ ಇದ್ದಿದ್ರೆ ಅದನ್ನಾದ್ರೂ ತಗೊಳಕ್ ಹೋಗ್ತಿದ್ದೆ. 56/1A ನನ್ನ ಪ್ರೈವೇಟ್ ಪ್ರಾಪರ್ಟಿ ಏನಿದೆ ಅದನ್ನ ಕೊರಿಜೆಂಡಮ್ ಅಂತ ಇಶ್ಯೂ ಮಾಡ್ಬಿಟ್ಟು 55/1 ನ ಕಬ್ರಸ್ತಾನ್ ಎಕ್ಸಾಸ್ಟ್ ಎಷ್ಟು ಜಾಗ ಇದೆ ಅಂತ ಅವ್ರು ಒಂದು ಹೇಳಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ ಅಂತ.
ಸರ್ವೆ ಮಾಡಿಸ್ಬೇಕಾ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ. If you are without prejudice to your rights, then you will know what is the extent, and then you can make it.
Now, the one thing which they have to overcome is whether they have a right of hearing or not will have to be considered in the light of the submission made. And Prestige Lights case,
Let us simplify the matter. 55 is how many acres?
1 acre.
1 acre, 12 guntas.
Plus 55/1 is 1 acre, 12 guntas.
12 guntas. 56 is?
56/1A is 1 acre, 12 guntas.
That is also 1 acre. So totally is 2 acres, 24 guntas.
Plus 55/1 is only 1 acre.
1 acre.
So
2 acre, 24 guntas totally.
Sorry. 55/1 is 1 acre. 56/1A is 1 acre, 12 guntas.
Yes.
They had earlier notified 1 acre of 55/1 as the.
Not required now.
Please. Now 55/1 is their property. We have no claims over it, and that's already a Kabristan.
ಅದನ್ನ ಕಾರ್ಪೊರೇಷನ್ ಮತ್ತೆ ಗವರ್ಮೆಂಟ್ ಹೇಳ್ತಾರೆ that only 56 is what they are saying. That's why I'm saying identity of the property.
What madam is saying is, if a survey is done identifying the boundaries of 55/1 and 56/1A,
yes,
as also the places where the tombstones are available,
that can be placed before the court. Not it will aid the. It will certainly aid not the.
Aid the court is one. It will probably also aid you if there's 20.
If any substantial property left, probably I can make use of it.
You can,
substantial property.
You can take your decision.
Certainly, that can be directed.
Instead of going back and forth.
Yes, yes.
If madam can convince her client and you can, both of you can arrive at, when it solves the problem which is pending for last 13 years.
Lots.
Learned senior counsel for the Sri D.R. Ravishankar, learned senior counsel for the petitioner, as also Ms. S.R. Anuradha, learned senior counsel for respondent 1 and 2. Submit that without prejudice to their rights and contentions, a survey of the subject land, namely survey number 55/1 and 56/1A of
Jarak-Bande Kaval village.
Jarak-Bande Kaval village.
Jarak-Bande Kaval village.
Yelanka ಬರುತ್ತೆ.
ಅಲ್ಲ ಬೆಂಗಳೂರು ನಾರ್ತ್ ತಾಲೂಕು.
Jarak-Bande Kaval, Yelanka Hobbli, Bangalore North ತಾಲೂಕು.
ಈಗ ಯಲಹಂಕ ತಾಲೂಕು ಮತ್ತೆ ಅದು.
ಈಗ ಪ್ರೆಸೆಂಟ್ಲಿ ಯಲಹಂಕ ತಾಲೂಕು.
Presently Yelahanka taluk.
Now Yelanka taluk.
Yes.
If carried out, would assist this court. In that view of the matter, the jurisdictional ADLR is directed to carry out a survey of the property covered under survey number 55 and 56 with all sub-numbers. Demarcate the boundaries of the primary survey number as also the sub-numbers. Demarcate the location, draw up a survey sketch, detailed survey sketch, and mark the location of each of the tombstones in any of the above survey numbers. Calculate the area covered by the
Graveyards.
by the tombstones, stroke Kabristan, stroke graveyard, as also demarcate and calculate the area over which there is no tombstone or graveyard or Kabristan. Since the order is passed in the presence of all the councils, the respective parties can participate during the course of the survey work. Non-participation will not entitle them to claim any equities. The survey is directed to be carried out commencing from 10:30 a.m. on 19th July, Sunday.
Please, Millards.
19 July or 18 July, Saturday. Saturday and Sunday.
Please, Millards.
We will get it done, my lord, whichever day the court directs. Maybe on 19th.
19th is Sunday. So if they complete it on Saturday, they don't need to work on Sunday. They also have a holiday.
Well, very well.
10:30 a.m. on 18th July and continue until completion thereof. The ADLR is also directed to photograph and videograph the
Entire
entire process and present the same along with the report. Anything else?
That's it.
So a copy of the order may be supplied to me, my lord.
Any other instructions to be given?
That's sufficient.
My lord, your lordship has said that it is optional. I think it's better both the parties are present, my lord. Let there be a direction, because if one of them say if an option is given, if they don't come, and then again, my lord, the entire exercise.
Your lordship was directing photograph, videograph. So
Will be present.
Very well,
Will be present.
it's an option only, because ADLR will do his job.
If they are interested, they will be there.
Yes,
I know.
that is what.
Government
Well, now-
notifications are there.
Now,
So
my
that
lord, what
could
has
be
happened
guidance.
is
Not by us. It's a government issued the notification. Sketches are made by them. That
We'll come to those later. This is only the revenue maps of
Now,
the
my lord,
survey
this
number.
survey is to just identify with the existing tombstones and substantially what is vacant. If it is vacant and my learned friend gets benefited out of it and the senior counsel has done submission. Now, this is not to show, absolutely there will be no difficulty for a survey to go and survey what is 51/1 and 56/1A. Now, my lord, the dispute is what is the tombstones that are there, if at all there is anything existing, and what the learned senior counsel is arguing, and for his client, we'll have to just identify what substantially vacant place is available for them to accept.
If it is substantial,
And it's up to them.
Mr. Ravi Shankar's client may
Of course,
accept
Millards,
it.
I'll push them because
very well.
If it is not substantial, obviously you won't
Obviously,
accept
nobody
it.
will.
So
Then
it's
we'll
only
have
to
to-
ascertain that. The jurisdictional police is also directed to provide such assistance as may be required by the ADLR. Tahsildar ಯಾರಾದ್ರು ಬೇಕಾ?
ADLR can do it. Millards,
ADLR
because
is
it's
right.
purely based on the survey sketch.
The representative of the GBA as also jurisdiction Tahsildar are directed to be present during the course of the survey work.
Please.
So it should not be that that person was not
Correct.
there.
Understand, Millards. So I should place on record, I appreciate the progress which was made because of the learned senior councils.
Coffee.
Certainly, Millards.
but we are conscious. So many years of sale deed is there. There is a notification on one side. This will be a lifetime litigation if that be so. So I felt, let us see what is it we want to protect. But my only anxiety is there are so many survey numbers, and there's a masjid, and there was survey number 6, which was a portion was acquired by. Lot of things are there. Let the survey come.
You
We
could
will get
also,
an idea.
subject to what you are
That
going
will
to
be a
argue,
starting point. Is all I'm saying.
you could also look at the clustering of the tombstones. If the tombstones are clustered in different places, you can make it into one cluster in one location, giving up more space. That's an option.
Subject to the
I only thought from this angle that we both have registered documents. So this will be a litigation for ever to come. So let's try so they enjoy their property, and these tombstones are also saved ultimately. But I don't know how the board is going to look, because now under section, the amendment to section is there is no power to even alienate any portion. We'll have to, or they may have to acquire it and give it to them. The government has given this. I was only wondering, let's understand whether there is land. If there is land, then it's worth to fight. If there is no land only of his, then he thinks there is his land, but I feel that's not that.
Dignity of the dead is as important as the dignity of the living.
Because
So we'll have to see how to do that.
Lordship may also add survey number 57.
Okay,
The
57.
reason is, I think,
Can I know latest notification corrigendum which they have questioned is made by the government subsequent.
right, let it be purely based on the
Don't
survey
want the
maps.
ADLR to interpret any of the this one. You tell us the survey numbers, we'll include the survey.
Only
number.
57 because it was included in the corrigendum.
Include 56, 57, I will tell you.
55,
5 was one, was there.
55 ಆಯ್ತು, 56 ಆಯ್ತು.
ಹೌದು, ಒಂದು
56 bar A.
Last 57 bar 1 ಅದೂನು ಅವ್ರು ಕ್ವೆಶ್ಚನ್ ಮಾಡಿದ್ದಾರೆ. All the cluster.
We have not challenged it. That's what they did. That's the reason, Milords, one sentence. 55 bar 1 measuring 1 acre was the original notified Waqf. Subsequently, they issued a corrigendum saying that it is 56 bar 56, 57 and survey number 6 of another village. Then they issued one more errata clarification saying that it is 57 and 56 bar 1A. So 57 is also notified in the corrigendum. I only said that let 57 also may be included so that
55, 56,
55,
57.
56 and 57.
57, that's it.
Yes.
Let
55, 56.
May request for copies.
I'll
To be
immediately get it.
uploaded
I'll immediately get it sorted.
today. Which copies? The petition copies.
Serial number 2, Vinay N, on connected matters.
This matter, Milord, pertaining to Milord, interesting Milord, the tanks and lakes to the minor department.
Lift irrigation and fisheries.
Lift irrigation, fishing, right?
Yes, ma'am.
Last occasion, you last directed Milord to file a
Your
counter.
Lordships may kindly permit me to submit from serial number 2, my lord. My lord is ready, my lord, but this can be disposed of.
No. We will look into Milord.
I'll mention.
Hear their submission. It may be in your favor. Who knows?
My lord, this, my lord, tender for fishing rights was called for.
In case of
Yes.
This matter, my lord, tender for fishing rights was called for 7 minor irrigation tanks, my lord. Out of which, my lord, 2 tanks are rain fed and 5 tanks pertains to lift irrigation.
Yes.
If my lords may kindly see statement of objections, page number 13.
14,
13, my lord.
13.
Please, my lord.
Hmm.
My lord, this honorable court in WP number 7194 of 26, my lord,
Yes.
may read the relevant portion, my lord.
Yes.
Accordingly, my lord.
Hmm.
Accordingly, it is directed that the authority shall ensure that any process of auction of water tanks shall be strictly confined only to those tanks which are demonstrably supported by lift irrigation and shall not include 99 rain fed tanks until further orders of this court. This was the direction issued, my lord.
Yes.
Now, my lord, since it was only restricted to lift irrigation, my lord, we had to exclude rain fed tanks, my lord.
Yes.
As such, my lord, this tender notification was cancelled
Hmm.
and an endorsement is issued for excluding the rain fed tanks. That
And
is,
continuing with 5.
Please, ma'am.
2 of them.
please, my lord. Annexure K is the endorsement which is in challenge. We have only complied the directions of this honorable court, my lord.
But that 7194 is also a part of the connected.
Please, my lord, I will make my submissions to
You'll look
that
into
also,
it.
my lord.
Uh-huh.
That 2.1 and 2.2, my lord, basically they have challenged circular dated 7/2/2026. These two has to be linked, my lord, de-linked, my lord. I'll make my submissions for that, my lord. Because in these two, my lord, it pertains to, they have challenged the tender with respect to minor irrigation tanks, my lord. Only they have challenged the circular. As such, these two has to be delinked, my lord. That I'll make submission, my lord.
Let's, can I request, let's have it tomorrow? Make submission on all the matters and we can hear you on all the matters. And
No, my lord. Now
each
this
one will have a
repetition, no, my
impact
lord.
on the other.
This writ petition, basically, my lord, we have only complied the directions of this court, my lord. As such, we have cancelled the tender.
Correct. But
They have
if
only challenged the cancel.
7194, we don't know what is going to happen, whether the interim order was granted to protect and maintain status.
Please, my lord.
So after hearing whether you, if your circular goes,
Please, my
then 18949 would have to be allowed.
Please, my lord.
So they are intrinsically linked.
Please, my lord.
Cannot be, if you dispose it off,
Please,
then
my
their benefit, if at all.
Please, my lord.
If you succeed in 7194, then they won't get any benefit, it will get dismissed.
Understood, my lord.
So separating may not be advisable. You file your objection in all the matters.
Please, my lord. My lord,
And
this
first we will
matter,
take up 7194.
7194, my lord, my objections are ready, my lord. I'll file it, my lord.
File it, give them a copy.
I'll give, my lord. I'll file it, my lord.
And when will you get ready? 2 weeks later, we'll have it. So you argue the matter, all of them. We'll take
Please,
first
ma'am.
7194,
Please,
because that
ma'am.
is where the circular is challenged.
Please, my lord.
All the matters that we challenge this.
Depending on the outcome of it, rest will follow.
Please. The other 2.3 and 2.4, I have already filed objections.
And AGA submit that she has filed
2. I
objection
beg your pardon, my lord. 2.4, I have filed objections.
in 2.4.
Please, my lord. In so far as 2.3 is,
Sandesh, copy bandidia. Copy kodi.
I'll.
It's 2.3.
2.3, my lord, there was a dispute between two departments, fisheries and minor irrigation. My lord, the contention of the petitioner was that, my lord, the fishing rights are extended, lease is extended for
fisheries
another 2 years, my lord. That is withdrawn, my lord.
That
My lord, that dispute will
extension
not-
is withdrawn.
Please, my lord, existing, I'll.
File it.
Please, my lord.
So 2.2.
2.2, we have not received a copy.
2.2 is the submission which I made.
You have to
That
file
dispute,
objection.
yes, my lord. No,
That AG has filed a statement of objection to 18949 of 26. The same is taken on record. Copy thereof has been furnished to the council for the petitioner. He submits that in 2.4 objections have been filed.
please, my lord.
Copy thereof would be furnished to the council for the petitioner in 2 days' time. In respect of 2.1, 2.2 and 2.3,
Please, my lord.
she seeks for and is granted.
2.3, my lord, may I produce this, where they have withdrawn the
2.3,
extension.
a memo has been filed. The same is taken on record. You don't want to file objections in that.
No, my lord, in that.
She submits that the state does not wish to file any particular objections in 2.3, but would only rely
Please,
on the
sir.
memo file. 2.1 and 2.2, she
Please,
seeks
sir.
for and is granted.
2 weeks time. A week's time.
10
Since
days
it is
time.
ready, my lord,
Anyway,
I'll.
we can't take it up. 10 days time to file a statement of objections. Objections, if any, by 29th July, relist on 5th August. The respective councils are directed to file the respective synopsis of dates and events, list of authorities along with authorities, as also synopsis of arguments before the next date of hearing, after serving the other side in advance.
The interim order may be
Interim order earlier granted is extended until next date.
Please.
Serial number 3, Gajendra, yes.
They need to be. Joint development. It's already 2013 it transferred.
Where the document?
Madam. Copy. Copy.
16 to 2013 transfer agide, Mr. Gajendra.
My lord, it was reserved for the both the parties as per the
Now, your submission was that it was transferred in the year 24, therefore it is to be reviewed.
my humble
because
submission, my
limitation.
lord, my humble submission. It may be transferred, just now I am looking at that. It has not communicated to the, even the petitioner.
It is constructive knowledge. This
My humble submission, my lord, my humble submission, my lord. It has been, the site number 99 is reserved for both the parties for future development or future sharing of both the parties. Now, in case if he is transferred fraudulently, it has at least communicated to the petitioner. It has not communicated whichever date which have been transferred. As per section 17 of the Limitation Act, from the date of the knowledge of the petitioner, it comes to the cause of action, my lord. Here, the joint development has been entered in the year 2013, 2012. Subsequently, 2013, it has a sharing agreement is also entered. Immediately, if he is transferred, at least he would have communicated. It has not communicated. Only when the third party has informed the petitioner saying that it has been acquired by him personally and he is having a capacity, individual capacity, then only I came to know that. Immediately I approached, immediately notice have been issued. At least he would have communicated saying that it has been 2013, it has been transferred. Nowhere it has been taken a contention saying that 2013. For a fraudulent act of the respondent, it should not be appreciated, my lord. It has the, at least he would have communicated. He has not communicated. Section 17 very clearly says that the person has committed a fraud and concealed the facts from the other party. The period of limitation starts only from the date of which the fraud comes to the knowledge of the affected party, my lord.
When you transferred it in your name, did you get his signature?
My lord, if your lordship kindly see my statement of objections for the main, for CMP file.
Yes. And did you get a signature when the transfer was made?
No. It is as on the date of the panchayat, with his consent.
You get the petitioner's signature. We are asking
That
you
I am
third
not,
time. Obviously, if you are not answering, you have not got a signature.
No, my lord, I am not aware. I am not aware of that.
Then find out and produce the document if that signature is there.
No, I just make one submission. Kindly see at statement of objections filed on for the same file. Page 28, my lord. On the top.
Statement of objections is also not given.
Yes, page 20.
28, my lord, from top.
28. Page 2 is it?
28, 28, my lord.
28.
My reply to the is notice.
Yes.
Suppress the true and material facts from you and you got issued this false and frivolous note to make after lapse of 12 years from the date of allocation of the sites, and the claim made by your client is totally stale and barred by law of limitation, and your client is totally trying to blackmail my client in order to enrich himself unlawfully. My client represents that he has put into the vacant clear physical position and enjoyment of the aforesaid site number 99 way back in the year 2013. This is my reply, my lord.
Your reply may be that.
One minute,
Any document
one more submission in the next paragraph, paragraph number 7. Sixth line from the below, my lord. Your client came to know during January 2025 the kata of the site number which was supposed to be held by both of them was standing in the name of my client or all denied as Abdul Froz. The kata of the said site is standing in the name of my client ever since 2015, that is 2013, and is paying the taxes regularly concerned revenue authority. So, my lord, why it was supposed to be happen like this? Well, there was a distribution, unequal distribution of the sites. There was a difference in the extent of land. Therefore, the site was allocated.
That will be decided in arbitration, Mr. Kaur.
Yes, my lord. Yes, my lord.
The question that we are only deciding now is the limitation. When the transfer of site number 99 happened in your name, did he sign it?
It happens upon the sharing agreement.
You did it unilaterally.
I will check it out and let you know, my lord. And also, my lord, this review petition is not maintainable because under section, under the act, there is no provision for review of the order passed under 11.6, my lord.
That is also there. 11.
Therefore, this review petition is not maintainable of the judgments, my lord. Can I pass the judgment?
You have to file an appeal. 11.6, review illa.
Right.
You can produce your additional documents there, not on additional documents here. Yes.
Second judgment, my lord.
Page number?
The second judgment, page number 53, my lord. Ink page 53, my lord.
53.
Yes.
Yes.
Conclusion, my lord. In view of the observation made by the Supreme Court aforesaid, according to the learned counsel, since the Supreme Court is of the view that amnesia passed by the Chief Justice or designated judge, the party will not have further remedy in respect of the orders covered, and he will have to participate in the arbitration. Both the tribunal, before
Where
the
does it say
tribunal-
review petition is not?
Yes, my lord.
Is not made out of content of the petition for the. Not maintainable. Paragraph. Yes.
See, for 1 week time to go through the records and I'll just submit my report.
There is a judgment
You know,
saying.
I have
review
not gone
petition
through
is
the
not-
judgment which have been passed by the court.
Both the councils seek for and are granted a week's time. Released on 27th.
Much of
Much of it.
Further arguments, serial number 4. Vivek Holla, connected matters.
Yes. Lord, I was reading that list of dates I had given to your lordships. ಸುಮ್ಮನೆ ಇದೆಯಾ ಮಿಸ್ ಆಗಿದೆ page 31. Can I give? Yeah. Yes, please. Lord, page 16, if your lords has come. Yes. Para 8B, my lord, 6, sorry, at the top. Cabinet note, lands were granted on lease for cultivation of plantation crops and the government, under the Government Grants Act 1995 applies and is therefore outside the operation of the Transfer of Property Act. Correct position is, entire basis on which such statement has been made is on certain judgments which have absolutely no application on to leases on hand, which are given under the Transfer of Property Act itself. Those are, my lord, leases granted under the Transfer of Property Act. 13. Provisions of section 23 and 82 of the Karnataka Forest Act 1963 permit limiting of the period of leases to 99 years. 23, my lord, we have culled out. Please look at, my lord, 23. Yes, it is here only. Yes. Any forest which has been notified as a state forest under the Karnataka Forest Act 1900 and as a reserve forest under the Indian Forest Act 1927, Madras Forest. Records prepared in connection with the constitution of such forest as a state forest or reserved forest
shall be deemed to have been decided, issued, prepared under this Act. Provisions of this Act relating to reserve forests shall apply to forests to which the provisions of subsection 1 are applicable. A perusal of the said section indicates that the forests which have been notified as state forest under the enactment mentioned therein alone shall be reserved forest. Forests declared as such under the Forest Act 1878 have not been specified to be reserved forest under section 23 because, my lord, these are all under 1878 Forest Act. In view of the same, respondents have no power to limit the term of lease to 99 years. Sorry.
Yes.
Then, my lord, further, section 82 of the Forest Act in 1963 reads as under forfeiture of lease. When the holder of any lease, license, or contract whatsoever granted or continued by or on behalf of the state government for any purpose of this Act, where and or when such offence is committed by any agent, servant, holder of any such lease, license, contract, and the state government is satisfied that the commission of the offence was consequence of the instigation of such holder or of any willful neglect, default on his part, state government or the forest officer duly empowered in the state by the state government in this behalf may by order in writing declare the lease, license, contract to be forfeited in whole or in part to the effect, with effect on and from the date specified. A perusal of the same bears out when an offence is committed. My lord, that, my lord, may not apply. My lord, I leave it at that. Leases in question, my lord, please come to my lord 8. Leases in question have been granted pursuant to the power vested in the government under section 22 of the Forest Act of 1878. When once the reserve forest is given under the contract by the government, the land ceases to be a reserve forest. Under these circumstances, contention that the lands in question is reserve forest is wholly untenable. That apart, when once there is a lease pursuant to a contract between the government and the petitioners, pursuant to the power vested in the government under section 22 of the Forest Act of 1878, such a contract binds the government and cannot be cancelled. Then, my lord, on 7/5, the cabinet note came to be approved by the cabinet. They, my lord, were, my lord, misled, my lord, in this note. Petitioners have not been furnished with a copy of the same. Accordingly, the state has unilaterally reduced the lease from 999 years to 99 years on the ground that the government had reserved unto itself the right to withdraw or alter the rules made under these leases, which the leases have been granted to the petitioners. And, my lord, under the regulation that was given, my lord, there is no such power at all.
The format was for
Correct,
999.
correct.
Now, the cabinet note was prepared by which department? The forest department.
Obviously, my lord. No, but then there is a cabinet, my lord, secretariat that prepares it. But then, my lord, inputs are all given, my lord, by the forest department.
No verification of it.
My lord, I can only say this, knowing what had happened during my tenure. It's more than that, I don't know.
The legal notes like this, which are advising on the applicability subject.
In fact, they'll have to take the, my lord, input from the law department, all that.
Should it not go through?
Nothing is done, unfortunately. In fact, page 263 tav bandre.
Subject to what Mr. Rohn submits, these glaring discrepancies that you are pointing out, 263,
my lord,
of the petition.
Volume 2.
Volume 2.
Nodi.
Volume 2 illilla.
Ilva. Idu
no, idu
4706.
706. Second item.
Cabinet notice prepared by Undersecretary. In fact, cabinet note is prepared by the Undersecretary to Government, Forest and Ecology and Environment Department. How are they? 263 nalle ide. Innondralli ide idu yathos. Yav sahib kodi adu.
Yes.
263.
Undersecretary.
That is a cabinet note. That, my lord, goes up to 272. Each page, your lordships will see the seal and the signature.
Each page is by the Under Secretary, finally signed by the Additional Chief Secretary. At page 270.
Additional Secretary, my lord, Under Secretary signs, and the last page, your lord, is the
Additional
third
Chief
page.
Secretary is signed.
Additional Chief Secretary signs it.
But at the end of the day, it's prepared by the Forest Department only. Yes.
That's why I said, my own experience was, there's not, actually they must ask the law department, because these are all issues.
Legal issues. And you're interpreting the laws.
Correct. In fact, sometimes, my lord, they ask the Advocate General, but not many times when they want.
In every cabinet decision,
Additional Advocate General.
the Advocate General is part of the cabinet meeting.
Not necessary.
No,
Advocate
but
General
he
is not.
has a right to participate.
That's
in
all
the
right. He may
cabinet
have
meeting.
right, but only.
We don't know in this.
Let me tell him. My learned friend doesn't know.
I don't know, but
Only, my lord, when they want, they call the Advocate General, my lord, to come to the cabinet meeting. Otherwise, they don't. That way, my lord, my lord, Advocate General also can go to the Legislative Assembly. But they don't call. They don't.
You have better work to do here in court.
No, I agree. I agree, my lord. I agree. But they can ask for, my lord, the opinion.
I'll find out, my lord, if the.
Don't put the bar so high to make the AG responsible.
No, note is one aspect. No? The other is what discussion transpires in the cabinet meeting also.
The discussion.
We cannot
you
probably
can,
just rely upon.
You can obviously make your submissions, but this is not inspiring confidence. Everything is, there are wrong statements made in the cabinet note. Wrong interpretation which has been made. There's still more that Mr. Holla is pointing out. It's only halfway through that he has reached in that. But till now, it is not inspiring confidence. Anyway, you can look into it and make your submission.
All right.
Yes, Mr. Holla.
Then, my lord, para 38 at, my lord, page 18. Said reasonings are untenable because none of the lease deeds, my lord, indicate the land in question are reserved forest. My lord, all of them say that, my lord, they are abandoned coffee lands. The revenue records, including Jamabandi extract as well as RTC, clearly showed that the lands in question are not reserved forests. The said entries have been in existence right from 1913 till 2007. Entries in the RTC were unilaterally changed during the year 2007. That too during the pendency of the writ petition. My lord, we had filed earlier writ petitions. So they changed it to reserve forest. Same is wholly illegal. Then, my lord, para 39. Cabinet was totally and thoroughly misled by the cabinet note, was authored by the Under Secretary to Government and Additional Chief Secretary to Government, Forest and Environment Ecology Department, and which contained factually and legally incorrect propositions and statements. There was also suppression of material facts. It is therefore apparent that the decision of the cabinet has been obtained by misrepresentation and suppression of material facts. And even on this score, the decision of the cabinet is wholly vitiated. Then, my lord, we applied for copy of the order of the cabinet approving the cabinet note under the RTI Act. Application, my lord, we produced that application 277, if your lordship sees.
Yes.
Not furnished to us.
$277.
Howdo? Second volume, Allah?
Yes, Annexure R.
Yes, my lord. Under the Right to Information Act, my lord, details of the document required, cabinet approval.
Yes.
That was not furnished to us.
Not furnished to you. And we are looking for the approval.
Yes.
It's only the application.
Correct. Approval illa, kottilla namage. My lord, cabinet approval.
You have placed it on record, Mr. Brown?
Avaru hakilla.
Cabinet approval?
But we have, what is
If not, please place the cabinet approval.
cabinet approval itself?
Yes.
That would be the cabinet decision which they have challenged here.
They had applied for it under RTI. You did not give them. They are not able to produce it. We'll have to look at
The cabinet decision itself. That's part of the order which has been challenged now.
You can make whatever submission on that.
Then, my lord, para 41. Petition, my lord, we filed the writ petition. This honorable court passed an interim order to maintain status quo. Then para 42. In the said petition, preliminary objection regarding the maintenance petition was raised by the government that no government order has been issued in furtherance of the cabinet decision, that no writ petition lies against the cabinet note, that even if the government order is issued in the name of the governor, they would follow the procedure to take possession and issue as 15 days notice before taking possession. In view of the said undertaking, said writ petition was not pressed by the petitioner with liberty to take appropriate proceedings as and when the government order is passed, served on the petitioners. Accordingly, my lord, that writ petition was disposed of because, my lord, they said, we'll give you 15 days time, all that. Then, my lord, look at the government order, 2012. Thereafter, respondents passed a government order, that is, my lord, there at page 307, restricting the period of the lease from 99 to 99 years. And the order directs to treat the said lands as reserve forest soon after the completion of the lease period. My lord, this is very significant. And to please look at, my lord, that 307. Last soon after ಅಂತಿರುತ್ತೆ ನೋಡಿ ಅಲ್ಲಿ ಯಾವ ಪೇಜ್ ಅಂತ ಹಾಕ್ಬೇಕಲ್ಲಿ. Can I persuade you? 327 ಬನ್ನಿ. It starts at 307. 326, my lord, is the government order, that operative portion of the government order.
To treat this land as reserved forest soon after the completion of the lease
period. So 99 years ಮಾಡಬಿಟ್ಟು then you treat it as reserve forest.
Which continues to be a rubber plantation.
The said GO, my lord, was served on the petitioner, para 44.
Yes.
Said the GO was served upon the petitioner only on 21/1/2013 and 22/1/2013, along with the notice dated 18/1/2013, written by the fourth respondent, asking the petitioner to vacate the lands within 15 days, failing which coercive steps would be taken. Impugned GO is common to all petitioners. Notice along with the GOs, my lord, we have placed it before your lordships. Impugned GO clearly indicates there has been a change in the very stand of the government in the GO from that found in the cabinet note, again showing thereby that the impugned GO is not only illegal but contrary to law, but also vitiated by mala fides. The GO is not sustainable, my lord, because para 4 of the GO, my lord, gives an impression lands of the petitioners fall within Patti Ghat, Kadambal Ghat, Kirti Reserve Forest, and the Chief Commissioner has declared Patti Ghat as Reserve Forest with effect from 36 to 19/4. Correct position is lands of the petitioners do not fall within Patti Ghat, Kadambal Ghat, Kirti Reserve Forest. Portion of the Patti Ghat Reserve Forest, which had been leased in favor of Nilambur Rubber Company Limited and Thompson Plantation, were de-reserved as per the notification dated 29/4/1907 and 5/5/1947, Annexure AA and AB, pages 420 and 427, which were in fact produced in the earlier writ petition and which the government is fully aware of. Part of Kirti Reserve Forest and Urti Reserve Forest were de-reserved as per notification dated, my lord, 28/8/1906, page 443. These lands which were de-reserved have been leased in favor of Portland Rubber, 7th petitioner herein. The areas which form part of Patti Ghat Reserve were notified by notification number so-and-so dated 3/4/35/1904. Later, wide notification dated 29/4/1907, out of the areas that were declared as reserve under the notification dated 3/5/1904, extent of 730.54 acres were notified as ceasing to be reserve forest with effect from 15/6/1907. From the specification of the land disforested and the boundaries mentioned of in the notification dated 15/6/1907, read along with the boundaries stated in the indenture of 35 to 1910, it becomes clear that the area of 730.54 acres notified as ceasing to be reserve forest are the same parcels of land demised to the petitioners of predecessors of petitioner number 5. Petition number 5 is my lord Thompson. Then this is detailed in para 9 of the rejoinder. A true copy of the map of Patti Ghat Reserve, which with the areas that were subsequently notified as ceasing to be reserve and disforested, is at page 55 of the rejoinder. As per notification dated 5/5/1904, Chief Commissioner of Coorg notified and declared certain lands to be reserve forest, gave the name Kadamkal Ghat to the said area. Page 449, my lord, is that notification. The schedule to the said notification only sets out boundaries, and the exact area of the reserve with their survey numbers was not mentioned. Lands leased to the petitioner do not fall within the area declared as reserve forest as per the above notification. This is detailed in para 10, my lord. Para 10, my lord, we have set out, my lord, how, my lord, it does not fall within that area.
Has a survey been carried out?
Survey, my lord,
As per the
no, I don't think
notification?
so. No, my lord. I don't think so, unless, my lord, my learned friend has. He'll have to check
Make
it
a
out.
note and get back.
Yeah.
If a survey has been carried out, please place that
Yes,
also.
very well.
Because that's a problem with this notification. They don't give the
Correct.
only going north up to 20 chains,
Correct.
then west. Yes.
Then, my lord, 4. State government has suppressed the aforementioned notifications and has proceeded as if reserve forest lands have been leased in favor of the petitioners. The entire government order is vitiated by the fact that the relevant facts and materials have been deliberately not taken into account and consideration, and not even referred to in the order. And relevant material and facts are mentioned in the order. Irrelevant materials and facts are mentioned in the order. Principles of Wensbury reasonableness and unreasonableness squarely apply to the impugned order. Then, my lord, para 4, next page. Para 4 of the impugned order, GO, that the reserve forest reserved under the Indian Forest Act 1878 automatically become reserve forest under section 23 of the Forest Act are not true. Correct position, my lord, we did mention this. Perusal section 23 will indicate reserve forest under the Indian Forest Act 1878 do not automatically become reserve forest under the 1963.
So this is an alternative argument.
Correct. Order also says the same thing. Para 5 of the impugned GO states that Paisari forest are forests which have not been notified as reserve forest. Correct position is lands which have been leased to the first petitioner are Paisari lands. It has been so stated in the very lease deeds. The maps which are appended to the said lease deeds also bear out that these lands were Paisari lands and not reserve forest lands as alleged. The lands which are granted to the first petitioner are situated in Galibidu village and Kaluru villages of Markara. Mutation register pertaining to the lands of Markara Rubbers Limited for the year 1915 also states that the lands are Paisari lands. Mutation of the fifth petitioner land also show that the lands were Paisari lands at the time of grant. Mutation registers are, my lord, at page 456 and 457. All the lands which have been leased in favor of the petitioners are either Paisari lands or lands which have been de-reserved or lands which are, my lord, abandoned coffee lands. None of them are reserve forest lands. At the time of the lease, government, my lord, at the time of lease, government had collected value of the standing timber. Therefore, the petitioners have planted rubber trees on the entire land. As per notification dated 3/11/1891, Chief Commissioner of Coorg declared certain area to be a reserve forest and gave the name Kirti to the said area. Annexure AG, my lord, page 459. None of the area which have been leased in favor of the petitioners fall within that Kirti reserved forest. Lands which have been leased in favor of 7th petitioner are, my lord, in Heggala village. 9. As per the notification dated 28/8/1906, villages of Heggala and Rudraguppe, measuring 13,884.48 acres of land, which have been notified as reserve forest earlier, was de-reserved. As per notification of the Chief Commissioner of Coorg, published in the Coorg Gazette, dated 1/9/1906. Later, during the year 1908, as per the above notification dated 24/6/1908, some other lands outside Heggala village and skirting the Heggala village were notified as reserve forest. A perusal of the said notification bears out lands in Heggala village were not notified as reserve forest.
Why was this de-reservation made?
My lord, they don't give any reasons. They, my lord, make it, de-reserve it again, my lord. If I can take your lordships through that, de-reservation.
443.
443 thing. Pleased to declare that the provisions of so-and-so, that the area so-and-so, shall cease to be reserve forest. They don't give any reasons, my lord. In fact, in none of the notifications, my lord, when they de-reserve, they give reasons. Ishte.
There are no reasons, notings available for this.
Nothing, my lord. All are like this only.
Mr. Ron, as to what are the reasons for this 28th August 1906?
Annexure.
It can't be such a simple cease to be one word it's actually only one word here.
That is how it is done, unless, my lord, they have some noting in their file, I don't know. All are,
Page 443.
443, no.
There are two de-reservations which have happened.
Yes.
One in 1906 and the other one in 1943 or 46.
One is at annexure AB, my lord, 427 page. That is only to the extent of 50
1907 and 1947 A and AB.
Correct. One is 427 and
I'll make a note, my lord, and I'll
420, 427 and then AC at 443.
Correct.
A, AB and AC.
Yes.
What are the reasons for this?
I've made a note. I'll come back.
Yes, please.
In fact, that my lord, 427 Allah. 427, that 56 acres which we had, my lord, given it back. Adan de-reserve madadru. Now kottiddanna re-reserve madadru. Idanna de-reserve.
That was the exchange program.
Aದೇನೋ madadru. Anyway, my lord, in none, my lord, I have seen any number of this kind of de-reservations. They don't give any reasons. Simply, my lord, one notification is issued. Unless, my lord, they have it in their file. They may have it in their
something
file.
in the
Of
file.
course, they may have. My lord, I
Chief
agree with your
cannot
lordship.
just pass something.
Naturally, I agree. It can't be, because there will be, my lord, one procedure.
Yes.
They'll, my lord, go through the forester. Probably forester will tell this is what has happened. Then, my lord, it will go to the higher officials and ultimately.
Reasons must be available.
Naturally.
Why we are asking you that is because the tree cost has been collected is what you made.
Correct.
Your submission. And then you are allowed to plant rubber plantations. Therefore, the de-reservation, because tree cost has been collected, the trees are not there at that time. That time, nobody cared much about forests. It was only the money that they cared about of the timber.
Plus, my lord, also.
Today we are more particular about the forest being preserved.
No, that is one. Secondly, my lord, rubber. Those years, my lord, rubber was a very essential commodity.
Rubber was more important than the forest those days.
Industry, British were competing with the Indonesia.
Correct. Malaysia, Indonesia, all that.
Because if that was the decision which has been taken, all these ought to have been examined when the cabinet note was prepared.
No, there is a notification that's finding by the CCR court. After the division bench remands the matter back, the learned single judge gives a finding with regard to the legal status that these are reserved forest lands. And then when the matter is carried to the division bench.
All these arguments were not advanced during that stage. All these arguments were not advanced at that time.
No, it was advanced. It's a finding given. I'll point out.
Pointed out.
Then, my lord, division bench has, I'll point out.
Only
Division.
in favor of Nilambar, with the petitioner here, it's not a reserve forest. Rest of 4 petitioners' lands are situated within the reserve.
You sought liberty to issue a government order. Liberty was granted after the dismissal, after allowing the writ petition. Finally, you must have got up and said, grant us liberty. Normally, we give liberty.
A division bench is
that liberty gets dangerous.
The challenge
All
was,
questions were kept open.
Yes, challenge was
Division bench.
whether the DCF could restrict it.
Could not.
In that regard, Honorable Justice Bokuna, as
The best person who could have passed that order.
Yes.
Who knows
And
about it.
holding that it is a reserve forest. That finding has not been disturbed by the division bench. Nonetheless, because the state also said this matter can be decided by the CCR. So the matter was heard by the CCR pursuant to the direction by the petitioner.
You can make your,
Those are in challenge.
you can make your submission later, but produce these.
I'll produce all of it.
Yes, Mr. Olu.
In fact, the division bench order, ಅದ್ರಲ್ಲಿ ಹಾಕಿರ್ಬೇಕಲ್ಲ ಇದರಲ್ಲಿ paper book ಅಲ್ಲಿ ಇರಬೇಕು ನೋಡಿ. My lord, division bench order, your lords may just have a look at it.
Yes.
This is against that Justice Bopanna's order. Legality, correctness of the order passed by the learned single judge in WP number so and so is called in question in this appeal. Heard so and so. It is not in dispute that the learned single judge has granted relief to the petitioner. However, the appellant agreed by the portion of the order holding that the land involved in the present writ appeal is a forest land has preferred this appeal. In all other matters, matter has been remanded to the concerned authorities to consider the matter in detail. Therefore, whether the land in question is a forest land or lost its character or has been considered as a non-reserve forest can be determined by the authorities concerned by considering the material that may be placed by the appellants and the counsel for the appellant, as well as the government advocate, as well as appellant as well as the government advocate is no objection to refer the matter to the competent authority to consider this point. In view of their submissions, this appeal is disposed of, granting liberty to the conservator of forest to hold an inquiry in regard to the nature of the land in respect to the land in question in this appeal. Therefore, that question was kept open. Anyway.
Yes, please.
Then, my lord, coming to the note at page 2410, paragraph 10. Petitioners have paid upset price at the time of execution of the lease deed, as is apparent from a perusal of the lease deed themselves. Further, lease rent is paid by way of assessment, and this has been so held by the learned single judge of this court, this honorable court in WP number 24363 of 2000 and connected petitions. The said order has not been challenged by the state government. That is, my lord, the said order has not been challenged by the state government, is therefore binding on the state. In view of the same, state government is not entitled to contend. Lease rents are in addition to the assessment, and the lease rentals and assessments are different. Petitioners have been paying the assessment to the state government, which is the lease rental. In paragraph 8.2 of the impugned GO government order, it is alleged that the lease rent have been increased to 250 with effect from July 1974. And there has been an increase in the annual rent to 5,000 per hectare with effect from 1/4/1997, and the same are applicable to the petitioner. Correct position is, learned single judge of this honorable court in WP 24363 of 2000 and connected writ petitions has held that the said increase in the lease rental applies only to Eksali lease and not to that of the petitioners. Lease rentals and assessment is payable to the revenue department, not to the forest department as per the very terms of the lease deeds. Petitioners have paid the timber value at the time of the lease. Before planting rubber trees on the land, standing trees were cut. At that time, value of the tree growth, that's the timber value, was paid to the government. Petitioners are not liable to pay value of the rubber trees which they have planted. In fact, mutation extract clearly indicates timber value have been recovered from the lessees or the petitioners. Page 493, my lord, sets this out. As far as the existing trees are concerned, they are rubber trees, which have been planted by the petitioners themselves. Under the provisions of the Karnataka Trees Preservation Act of 1976, rubber is exempted, and therefore the said act has no application to the lands of the petitioners being rubber plantations. In para number 11 of the impugned GO, it is stated that the original leases came to be altered as per the 1940 lease rules by the Chief Commissioner of Kur. That's, my lord, the contention, my lord, what is raised, my lord, in the GO, what is stated in the GO. Correct position. 1940 rules specifically stipulate that the said rules shall not be deemed to invalidate any order passed under the rules in force immediately before the commencement of the 1940 rules. I read to your lordship on the last occasion. Meaning thereby that the 1940 rules do not affect the existing leases. In writ petition number 24363 of 2000 and connected petitions, this honorable court has held 1940 rules do not affect the leases of the petitioners. Principal Chief Conservator of Forests has written a letter dated 7/7/2004 to the Principal Secretary to the Government, Department of Forest, Ecology and Environment, clearly stating that the earlier orders will not stand invalidated by the 1940 rules because of the saving clause. My lord, 504, they only, my lord, have stated that. In paragraph 11 1 of the GO, it is stated the leases are grants and that as per the rules of 1909 and 1912, government reserves unto itself the right to withdraw or alter the rules, and that such withdrawal or alteration will apply to leases existing on the date of withdrawal or alteration. Correct position. Lease deeds are contracts between the parties. Perusal of the 1940 rules also indicate government has not reserved unto itself the right to withdraw or alter the rules. Forum provided under the 1940 rules show that the rule is prospective in nature and does not apply to leases executed prior to rule of 1940 rule. Press note dated 5/6/1940, which is not produced along with the rejoinder, referred to in paragraph 11(2) of the impugned GO, has no application of the leases to the petitioners. It has been so held by this Honorable Court in WP 24363 of 2000 in connected petition. The 1940 rules do not specify that the existing leases get altered. In paragraph 11(5), impugned GO is stated, it is stated that the Karnataka Supply of Forest Produce by Government Revision Agreements Act of 1987 is applicable to the leases of the petitioners. Correct position is, said act applies to agreements whereunder government agrees to sell or supply forest produce to purchasers or permits any forest produce to be collected or removed by the purchaser. Said act has no application to leases like the ones which have been executed in favor of the petitioners. In paragraph 11(7) of the impugned GO, it is stated that every land on which there is tree growth will be and ought to be treated as a forest. That's my Lord Godavarman's case. As per the orders of the Honorable Supreme Court in Godavarman's case. That, of course, my Lord, in that Uttar Pradesh, my Lord, matter, they have distinguished that Lafarge. Supreme Court in judgment reported in 2011, 1 SCC 744, distinguished the judgment in Godavarman's case and specifically and categorically held in Godavarman's case. The Honorable Supreme Court did not hold that any tree growth ought to be construed as forest land. Next, allegation in paragraph 11(7), 11(8) and 9 have no application to the facts of the present case. Correct position is, it has been scientifically proved rate at which the rubber trees accumulate biomass is higher than that of any forest ecosystem and can even be more than twice that of a humid, tropical and evergreen forest, showing thereby rubber trees are extremely beneficial and to ecology, and the growth of rubber is environmentally friendly and is more beneficial to ecology and environment than even than evergreen forest itself. Paragraph 11(10), I'll point out rubber board also, those the reports similar we have placed before your lordship. 11(10) refers to the forest working plan. Correct position. Forest working plan has no application to the leases of the petitioners, the rubber plantation existing thereon. In fact, forest working plan prepared by Madikeri Forest Division by the central government under the Forest Conservation Act excludes rubber plantations of the petitioners, again showing thereby that the lands in question are not forest lands. Forest working plan of the Ghat Forest of Coorg 1954-55 to 1973-74 in chapter 12 clearly shows the villages of Galibeed and Kalur villages as bordering the reserve forest and not within the reserve forest. We have placed that, my lord, annexure, my lord, along with the rejoinder. The allegations in paragraph 11(13) to 15, it must be, of the impugned GO pertaining to the public trust doctrine has no application or absolutely no relevance to the facts of the case or the leases of the petitioners. Public trust doctrine, intergenerational equity, precautionary principle, and the polluter pays principles have no application or relevance to the facts of the case or the leases of the petitioners. As already stated, leases of the petitioners are eco and environmental friendly. In paragraph 11(16) of the impugned GO, it is stated that as per Coorg Forest Manual 1957, leases have to be only for a period of 99 years. And after the period of 99 years, the lands will, with all the improvements, revert to the lesser. Correct position. Said rules of 1957 has no applicability to the leases of the petitioners and hence it cannot be made applicable. The impugned GO has gone far beyond the cabinet note, based on which the cabinet took a decision to revise the term of the leases from 1999 years to 99 years. Under Secretary to Government, who has prepared the impugned GO, cannot supplement and supplant the reasoning given in the cabinet note, based on which the cabinet took the decision to reduce the term of the lease from 999 years to 99 years. In fact, there are more other tree, page 30. There are other tea and coffee plantations situated on the forest lands, which have been leased by the government, state government, for 999 years. Terms of the leases those leases have not been reduced by the state government, showing thereby petitioners are sought to be treated with hostile discrimination. Majority of the shareholders of the petitioner companies belong to minority.
Have you produced that there is a discrimination? Which lease is still in currency?
Please, my lord.
What document have you produced? There is no reference to this.
This, my lord, no. This, my lord, we did not produce, my lord. I must frankly tell your lordships, I have not produced it. I must tell your lordships candidly. But next page, my lord, your lordships will get. I'll point out. There is a, my lord, grant in favor of, my lord, Forest Development Corporation. Since you asked me, my lord, next page, 49.
Yes.
Serial number 49, page 31. Karnataka Forest Development Corporation, which is the wholly owned government of Karnataka enterprise, has been granted lease of 11,000 acres of land for rubber plantation near the lands leases in favor of the petitioners. Lease expired on 30/6/2001. Notwithstanding the same, Karnataka Forest Development Corporation continues to run the rubber plantation. Principal Chief Secretary of Forest and Secretary of Forest Ecology and Environment Department and other government officials are the directors of KFDCL. Relevant pages of the annual report of KFDCL are at annexure AK page 509, pages 1 to 5 of the memo with additional documents dated 23/7/2025. Annual report clearly states that the evergreen forests were cleared by the Forest Department between the period 1970 to 1980. Rubber plantations are raised thereon, which were handed over to KFDC for a period of 20 years. This, my lord, please have a look at it, my lord. 509, if my lord stay. My lord, reply to the affidavit and tell you 3rd of June hakidivi. Separate hakidivi.
Which year?
3rd June 2026, my lord. Reply by the petitioners to the affidavit of CCF dated 10/11.
Yes, 3rd.
Otherly, yes. Otherly, please come to my lord. 3rd of June 2026.
You received it on 3rd June.
Copy serve ಮಾಡಿದಲ್ಲಿ ಅವರು ವಾಪಸ್ ಹಾಕ್ಬಿಡ್ತಾರೆ ಅಲ್ಲಿ.
You received on 3rd June.
ಅಲ್ಲೇ ಇದೆ.
ಇನ್ನೊಂದು ಕಾಪಿ
ಕೊಡ್ತೀನಿ ಖಂಡಿತ my lord. That my lord, we will have to my lord whenever they want.
Page number?
My lord, it starts at 98. Why not 9 of ಮಾಡಿದಿರಲ್ರಿ? ಮತ್ತೆ ಅದನ್ನು ತೆಗಿರಿ. My lord, please come to page 102. ಅಲ್ಲ ಅದು ಫಾರೆಸ್ಟ್ ಕ್ಲಿಯರ್ ಮಾಡಿದ್ರು ಅಂತ ಬೇಕಲ್ಲ, ಅದೆಲ್ಲೋಯ್ತು. Material 503 ತೆಗಿರಿ, ಅದರಲ್ಲಿ ಹಾಕಿದ್ದೀವಿ.
Page 100 bottom.
Yes.
4,443 hectares of rubber estate. Is that what you are referring to?
ಅದಲ್ಲ, ಎವರ್ಗ್ರೀನ್ ಫಾರೆಸ್ಟ್ ಕ್ಲಿಯರ್ ಮಾಡಿಕೊಟ್ಟಿದ್ದೀವಿ ಅಂತಾರೆ ನೋಡಿ, ಎಲ್ಲ ನಾನೆಲ್ಲ ಹಾಕಿದ್ದೆ.
You appear to be a major planter. You have pulpwood, you have rubber, you have tea, eucalyptus, bamboo, rubber, cashew nut, cocoa, tea, coffee. They're all commercial crops.
Yeah.
And other suitable species, not spices, in the state of Kerala.
Everything pertains to the duration here.
Allah, it expired in 2001. They continue.
But the petitioners will expire only after 900 years.
That's all right, my lord. What happens is they collected
The
the,
crux here.
no, I understand. But heartburn, I can understand. What happens is they, my lord, collected the upset price. In fact, my lord, it was like a sale only. But what the government, my lord, at that time wanted was, well, somewhere around, my lord, it should be stated as a government land, and they'll, my lord, keep on getting that assessment and all that. That's, my lord. Now, my lord, in this, sorry.
Yes, please.
Though, my lord, it expired in 2001.
Yes.
It is continued, as your lords get that at page 102. Anyway,
101. Yes.
then, my lord, please come to, my lord, page 30 of, my lord, my note, para 47. Rubber plantation is environmental friendly and is beneficial to environment as well as to the people. Many plantations in India are under the third cycle of rubber cultivation. In spite of the continuous cultivation productivity, soil has not deteriorated. Heavier, that is, my lord, rubber cultivation, does not deteriorate the environment but improves and preserves the ecosystem. Logging in rubber plantation is done only during replanting when the trees have ceased to be economically viable in terms of latex yield. Immediately replanting the area helps to conserve the environment effectively. Thick foliage of the rubber plantation helps in retention of moisture in the soil, improves the soil condition. A rubber plantation is a man-made forest representing a reasonably stable and self-sustaining ecosystem. Part of the report of the Rubber Research Institute reflecting the said facts, my lord, are at annexure L, page 154. 154. Correct. Page 157 at the top, my lord, eco-friendliness of the rubber plantation. What I have culled out is from there. 157, internal page 600. Left side ali barutte. Eco-friendliness of rubber plantations. Rubber plantations have a green image and are inherently environmental friendly. The carbon dioxide scavenging and oxygen recharging effects of the plantations on the atmosphere are too well known. Rubber plantations are capable of producing a fairly high volume of wood as per unit per unit land area in a comparatively short span. These plantations aid soil and water conservation and indirectly help flood control. Rubber plantations are self-sustaining ecosystem and could maintain a fair degree of biodiversity if properly managed.
This is published by the Rubber Research Institute of India.
Yes, Manoj.
Obviously, they will say good about rubber.
No, only thing is, it's a research paper. That's all, my lord, I can say.
By the Rubber Research Institute.
I can only, my lord, rely upon this because otherwise, my lord, I'll have to get into the Google. I'll, my lord, try and get
They
paste
have
that
to
also.
promote rubbers. Yes.
No, my lord. What happens is there are, my lord, reports, my lord, on the Google also. I'll try and get
Independent
that.
reports are different. This is
I'll
Rubber
give you a lot. I'll give that.
Then we don't think respondent would also have any objections on that 14,000 hectares. They are also cultivating rubber as per their report.
Once it's forest, the idea is that it should have as many number of different species of trees.
The issue finally is simple. 1900 there was a notification. 1907 there is a disforestation.
No, that we seriously.
That is what is there on record. Then there's a 1947 disforestation. Whether that disforestation is of this land or is of a different land. That if you have a survey done, you can place it on record. It is already disforested. The question of including them under 1964 Act would not arise. It is already gone. So by implication, you cannot do that.
But there are two issues. One is I need to show my lords that it's a reserve forest. The second is the power of the government to reduce the tenure itself. Assuming for a moment that it's not a reserve forest. Assuming for a moment, because rules are framed under the Food Land Revenue Regulations. These were special rules only for the purpose of leasing of forest land.
You can argue later, not now. Anything else, Mr. Ola?
Yes, madam. There are. Shuru madla? Eshtottare madbeku heli.
Now 4:45 we have to get up because 5 o'clock.
Alla, ಬೇರೆದೆಲ್ಲ ಇದೆಯಲ್ಲ ಅದಕ್ಕೆ ಕಾಯ್ಬೇಕು ಅಂತ
ಎಷ್ಟೊತ್ತಾಗುತ್ತೆ?
ಇನ್ನೊಂದು 1 hour ಆಗ್ಬೋದು ಯಾಕಂದ್ರೆ
No, 1
judgments ಎಲ್ಲ
hour, and
ಕೊಡ್ಬೇಕಲ್ಲ.
then another day, because we, another.
No, I
half an hour
understand
only.
because there are others.
Now
my
you
lord.
are
In fact,
coming to the
governance matter also is
legal aspects.
legal aspects and my lord, there are certain my lord contentions which my learned friend had raised, saying that Grant Act or the land and the act itself, my lord, I'll have to show all that.
24th, Friday.
24th. Very.
Heard further arguments of Shri Udayavala, learned senior counsel for the petitioner, released on 24th at 2:30 p.m.
Batch of matters.
Hmm?
Matters are pertaining even to the imposition of rent.
Hmm.
So
That has to be
my request was
separate, is it?
that can be treated separately.
You argue everything are connected.
I said
These are all
that
old
that
matters.
cannot be decided at present because
These are old matters, it has to be decided. After hearing, why should it go to another bench and again you?
ಅಲ್ಲ ಮತ್ತೆ ಅಲ್ಲಿ ಹೋದ್ರೆ ಆಮೇಲೆ ತಿರ್ಗಾ ಇನ್ನೊಂದು 10 ವರ್ಷ 8 ವರ್ಷ ಆಯ್ತು ಪಾಪ ಅವ್ರಿಗೂ ಫುಲ್ ಬಿಸಿ
You heard you, let's close.
I know since your lords have heard whatever.
And is that your request that we are taking?
I just thought easier to deal with.
Yes, please. No, nothing. There's nothing easy about it. So don't worry about easy.
No, that's why I always say, that's why we put the best of them there, my lord, and we are here, my lord. We'll go and
Not at all.
have coffee and have chat now.
Not
We'll
at all.
and we'll have
It is all your argument which makes the best come out of us. Otherwise, nothing will come out of us.
Serial number 6, K.R. Hingaraju.
There was a direction to government to get the record to verify whether what amount has been deposited in respect of
The state had to produce it.
state. Madam,
State had to produce the deposit. Pass over.
Serial number 7,
Sheenaith Ramesh.
In this, they are ready to accept the memo filed by the respondent.
You're verified.
Yes.
Where's Kiran? You are ready. You will argue the matter. If they are ready to argue on further merits, are you ready for argument?
Yes. No. The memo was filed by them, my lord. At that point of time, my lord, on 31/3/2014, they calculated. This is the amount which was 1 crore 89 lakhs total together, my lord. With all total interest is concerned, my lord, 2 crore 53 lakhs 31,954 rupees. What they have learned, my learner friend has before last occasion, he has given this. This is ready, my lord. They are ready to accept this. They are ready to accept this amount.
You are ready to accept. Nothing in argument. When was it?
My lord, sir, that is different, my lord.
One nimsha. When was it filed?
Let's see, this was filed on 22/6/2026.
For 36 people, it comes to 1 crore 28 lakhs.
No, my lord. That is 2.95% as per their calculation. In the first earlier, my lord, in the earlier memo, first memo attached with the calculation is concerned, my lord, that is entire state is 33 district, my lord. Next memo, next calculation, my lord.
Yes.
In this, my lord, interest at agreed rate interest amount. That's 63 lakhs 76,899. Next, my lord, next column, rate of interest as on 31/3/2014, interest amount rupees 1 crore 89,55.00. Next, total interest, my lord, 2 crore 53 lakhs 31,954 rupees.
That is column A plus B.
Yes.
Yes.
Other now.
Your lordship, kindly see the statement which you have submitted on 22/6. After that,
No,
you submitted a statement.
First, you make your submission as to whether this you are agreeable to pay 2 crore 53 lakhs.
This is as per calculation of lordship, but the purpose available to the bank As per that, we have submitted a memo telling it is 1 crore 28 lakhs. It is 1 crore 28 lakhs.
You have that, you have the money to pay. This 2 crore 53 is the calculation.
Because the bank is under liquidation.
2 crore 53 is what you owe them, but you don't have the money and you are ready to pay 1 crore 28 lakhs. That is your submission. Correct? You're not ready to pay 253.
The bank does not have.
They are understanding differently. That's why we are. They are not ready to pay 253.
Plus, they have agreed for that, my lord. That is because last occasion, my lord, in this 2 point, my lord, as per the 2.9%, 9%, my lord.
Ramesh, they are agreeable to pay 128.
Yes,
That is why the third stab is given.
Other.
Then we'll have to hear you.
Yes.
We tried to see if it
Yes.
could settle to do all this calculation and we can do it. They have the money of 1 crore 20, whether they have more or not, that is all subject to your argument. Their offer now is 1 crore 28 lakhs.
Before that also, my lord, it has to be looked into that in previous one, my lord, previous calculation. Last, but first one is then as on rate of interest on 31/3/2014. They themselves has calculated.
Correct.
Yes.
They're not disputing that. If actually as per it, if you have to go, you are due to this amount.
Yes.
But they have only this money that they are willing to pay is what they're saying. If you are agreeable for settlement, that they'll pay that money. If you're not agreeable, you argue on the merits and then we'll have to decide the matter.
Yes.
Because now, finally, after all the calculation, this is what has come. It's up to your client whether they want to accept or not.
No, for this, my lord, they are ready to accept it. This one, first, middle one.
They are not ready to give.
Second one, my lord, this one is, plus this was an order, they commonly have calculated of 2.9%. Why? Because
Why
they
we
are
asked
getting,
them to do that was to find out the difference. So that actually what it is and what they are willing to offer, both are available. Because matte, it should not be that it's
ಅವರು amount ಅನ್ನ ಡೆಪಾಸಿಟ್ ಮಾಡಿ, they are receiving the amount of rupees 7.5% from the various banks, my lord. They have deposited. The FD was deposited before the Karnataka.
Now you will have to argue the matter. A memo of calculation has been filed on 22/6/26. The submission of the Learned Counsel for respond number 3 is that as per the actual contractual rate of interest, the total interest liable to be paid in respect of the petitioners is rupees 2,53,31,954. But however, since the respondent bank is under liquidation, the amounts available are for payment is only rupees 1,28,10,835 to the petitioner after taking into account the payments required to be made to others. And as said, the counsel for respond number 3 has submitted that if the petitioners are agreeable to receive a sum of rupees 1,28,10,835, the respondent would be willing to make payment of the said amounts. The counsel for the petitioner, on instructions of the petitioner, some of whom are personally present before this court in person, submit that they are not acceptable for the sum of rupees 1,28,10,834, but would insist on payment of a sum of rupees 2,53,31,954. In that view of the matter, the settlement sought to be achieved could not be so achieved. The matter would have to be heard on merits. So we should not be hearing this matter after trying to settle this one. Let it go before another bench and let that bench hear the matter.
Because
Since
this court has
should not keep that in our mind, Alva.
No, it's
We
not
tried
that.
to settle, got them to do all these things, but it's not working out. The difference is double, we understand. So, but it should not, it should be taken up independently. This court, having tried to settle the matter between the parties and having been involved in the various submissions which were made toward that settlement, it would not be proper for this court to hear the matter on merits, hence released from Bartlett. Registry direct pays the matter before the
Take one
appropriate bench.
submission. The 3 persons have left out from that.
3 persons are left. Give them, anyway, you're not acceptable. So 3 persons names you give them, they'll give that
ಅದು
calculation.
connected ಇದರಲ್ಲಿ that has been. No, that's what has happened. Representation along with these petitioners, my lord, they are also included. But we have filed in the other dismissal, dismissed. They have filed a writ petition. In that writ petition is already disposed of. Therefore, my lord, they are also entitled.
Then you implead them by,
Please, my lord.
we can't tell.
Serial number 8. Manu Kulkarni, connected matters.
Released on 17th August.
Interim order may
Interim
be
order
extended.
earlier granted is extended. Yes.
My lords, the counsel for respondent number 3, 7 and 8 has retired.
Respond number 3.
In petition number 19352, that is serial number 8.1, the counsel for respondent number 3, 7 and 8 has retired, my lords. I have filed my memo of appearance. My name may be shown in the cause list.
We have heard Ms. Sarojini Muttanna. There is no point in showing your name now. We have recorded that we have heard that she has already addressed arguments. After
Lord,
addressing
ASG
arguments, you can't change like this. It remains as is.
Please,
Yes.
interim order may be extended, my lords.
Extended.
Much obliged, my lords.
Serial number 9.
Apologies. The other day, there was another FSSA matter was served on me.
We are trying to look out
Yes,
for
my
you.
lord. I was appearing virtually. Somehow it was not.
Anyway, they withdrew them.
Yes, obliged.
ನೀವು ಒಬ್ಬರೇ ಅಲ್ಲ ಅಪಿಯರ್ ಆಗದೆ FSSI ಗೆ 9. You have given them copies?
Lords, I'm in the process of scanning it and they are not numbered, page numbered.
When will you file it?
Lords, now they are all on the SIR duty, my lords. This is with respect to the east alone that have further got another 2,500 close to reports, my lords. So I'm numbering them, paginating them, indexing it.
When will you
2
give
weeks,
it?
my lords.
Sri B.S. Karthikeyan submit that the compilation of the inspection reports is getting ready. He seeks for and is granted 3 weeks time to file the same after serving a copy thereof on the counsels for the petitioner. Released on 7th August. By that time, you will be able to do it?
Should be. I'll make my effort. I'll put my effort. My lords, it's voluminous, my lords. If I can keep it in my office library, they could come inspect and take whatever they want. If
The relevant persons can
yes,
take their.
because what happens is there are more than now around 5,000 PGs, so they may not be interested in that, my lords.
Mr. Patil, you are appearing for whom?
ಅದರಲ್ಲಿ ಒಂದು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಂತ ಹೇಳಿ ತೋರಿಸಿದ್ದಾರೆ. ದಟ್ಸ್ ಆಕ್ಚುಲಿ ನಾಟ್ ಪರ್ಟೇನ್ ಟು ಗೈಡ್ಲೈನ್ಸ್ ಆರ್ ಎನಿಥಿಂಗ್. ಆಫ್ ಕೋರ್ಸ್ ದೇ ಮೇಕ್ ಅನ್ ಎಲಿಗೇಷನ್ ದಟ್ ದೇರ್ ಇಸ್
9.2.
ಹೌದು.
What is this 9.2, Kodi?
9.2. It could be heard separately. No problem.
This is also paying guest only.
ಪೇಯಿಂಗ್ ಗೆಸ್ಟ್ PG ಹೌದು. ನಮ್ಗೆ ಅವರಿಗೆ ಸಿವಿಲ್ ವ್ಯಾಜ್ಯ ನಡೆದು ಇಲ್ಲಿ ಒಂದು ಕೇಸ್ ಹಾಕಿದ್ದಾರೆ. ಒಂದು 2-3 MFA ಎಲ್ಲ ಆದ ನಂತರ.
And this is a different matter. This is 9.2, D-link and post before the appropriate bench.
Serial number 10. Kumar Shetty.
Yes, madam, what happened?
My lords, we suggested similar in the Municipalities Act. My lords, now they've given a communication. May I just pass this on? Second page, my lords. Therefore, the Law Department is of the opinion that it would be appropriate to amend the Karnataka Gram Swaraj and Panchayat Raj Act 93 by incorporating a provision substantially analogous with Section 394(5) of the Karnataka Municipal Corporation Act 1976, empowering the judicial executive magistrate upon a complaint by Gram Panchayat or otherwise to direct exhumation of corpse buried in a place not registered, licensed or otherwise under the Act. If such an amendment is brought to this so-and-so, Section 394(5) of the Karnataka Municipal Code, it would remove the vacuum in the existing legislation. and would provide an effective statutory mechanism for enforcement of prohibition against the unauthorized burials by ensuring that exhumation is undertaken only under the magisterial supervision and in accordance with due process. In the August, we are having the Vidhan Sabha session is.
Now that you are doing it, insofar as the petitioner, we can on this basis dispose the matter directing.
If my lords directs, we will do it because this is the vacuum. In view of the vacuum, my lords may direct us to take action in accordance with law. We may have to await this amendment.
Because until then, why should Mr. Shetty's client wait? He's waited enough.
We'll follow my lord's directions because there is a vacuum. This is what is the efforts made by the state to.
And
It
we'll
will
have
take
it
its.
in, we'll reserve the matter because we don't have time to dictate. We'll pass that order and we'll have it in
Comply
August
with my lord's orders.
for you to place it on record so that in future at least there's no issue on that. Now, the direction to exhume would have to be to the
Jurisdictional assistant commissioner and the police department.
assistant commissioner and superintendent of police.
Please.
So we will direct the deputy commissioner so that he can depute somebody.
Jurisdictional executive magistrate, my lord. So it will be the
In police manual says that it's magistrate, my lord, and volume 2, my lord.
executive magistrate.
Executive magistrate. That magistrate means executive magistrate.
Tahsildar.
Tahsildar, DC or AC, anyone.
What is the provision? You have given us the provision.
Yeah, I have given my lord.
Notes for you.
Lords may kindly also say in view of the peculiarities of this case, my lord.
Written submission.
1396,
1396,
29.
There is a manual of my lord, executive magistrate also there, my lord. In that also, my lord, with regard to exhumation, there is a reference also, my lord.
Then do one thing, you make a note and give it to us.
I already made a submission, only this one is not
One
there.
judgment you have given.
Judgment also I have given in written submission, I made a reference. of this one. Made a reference, my lord. And this one I not made a reference, my lord, with regard to. It is a manual with regard to executive magistrate, my lord. There is also mention about the.
This is manual of executive magistrate.
8.7, my lord.
This is government of Karnataka.
Out. 8.7, my lord.
Yes.
The following points should be borne in the mind regarding the formalities proceedings to exhumation and postmortem examination. The magistrate shall examine the witness to prove the identity of the disintegrated body before commencing the investigation. The dead body should not be exhumed after sunset. The corpse must be exhumed in the presence of 2 or more respectable inhabitants of the locality. The corpse must be exhumed in the presence of the doctor. Wherever practicable, the relative of the deceased, whose names and address are known, shall be informed about the exhumation and examination of the dead body, and they shall be allowed to remain present at the examination. Crowding around the body should be avoided. The body may be handed over to the relatives of the deceased after postmortem examination, depending upon the facts and circumstances of the case. This is the procedure to be adopted.
This is for, what is the procedure for
After
reburying?
exhuming.
This is exhuming. What about reburying? But reburial lily.
Burial, my lord, there is no.
You will be happy with only that, but we are concerned with the entire thing.
There is.
So you have done only this work. The other work?
I have searched, my lord. There is no other.
What about for reburial? What is the process to be followed?
But in one case, my lord, Supreme Court, my lord, the burial, my lord, after the, but it's not about the exhumation, my lord. The Honorable Apex Court has made an observation, my lord.
The first portion is exhumation. Second portion is the examination. Third portion is the reburial. What you have argued so far is as regard the exhumation. That we have noted. Now, next part of it, Madam has also spoken of what is to be done. Now, what is the procedure to be followed for the reburial?
There is one direction, my lord, but not direct to the point, my lord, the Honorable Apex Court, my lord. The applicant shall conduct the funeral rites and bury his deceased father at the burial ground of the village Karakapal. The respondent state and its local authority shall ensure that the applicant and his family members are provided with all logistical support for the purpose of transferring the body of the deceased from the mortuary. Means it is from the mortuary, my lord.
That was a different issue.
Different issue, my lord. But there is some direction what need to do after the taking of.
Because they were not permitted there to bury somewhere else, and then it came up. That was the application filed by the relatives of the deceased.
Yes, my lord.
This is different.
This is different, my lord. But no such direction was given in any of the cases, my lord.
What is the procedure to be adopted for reburial?
My lords, what was read out by my learned friend regarding exhumation also said it should be handed over to the family members.
After the
The respondent state is directed to ensure that the burial of the remains of the deceased take place at the earliest. The appellant and his family members are directed to cooperate with authorities, and respondent state shall handle with the situation with sensitivity it deserves ಅಂತ ಇದ್ರಲ್ಲಿ ಹೇಳಿದೆ.
That was an application filed by the family members wanting to
You
bury.
read out that.
Allah, that is with regard to that
procedure
manual. In manual,
ಮಾನ್ಯುವಲ್ ಕೊಡಿ.
the body may be handed over to the
Ashte.
relatives ಅಂತಿದೆ.
of the deceased after post-mortem examination, depending upon the fact. But post-mortem ಇದರಲ್ಲಿ ಆಗಿದೆ, ಮುಂಚೆನೇ ಆಗಿದೆ.
ಆಗಿದೆ. This is when
Family members will have to
family
take
members-
over after that.
again that is
There is again a vacuum. my lords.
There is a
That
vacuum,
is
my
a
lord.
vacuum. That is the reason,
only
my lords.
this
we are-
lordship has to give direction with regard to that, my lord.
That's the reason I request, maybe my lords,
we'll have to
wait for at least.
We can't be giving any, because we may be wrong in whatever we may say. They'll have to examine it and they'll have to lay down the procedure.
My lord, in unnatural death, my lord, the magistrate is having the power, my lord, to exhume, my lord. After that, my lord, they'll hand over.
Post-mortem, everything is over. Now what unnatural death?
No. Even if in unnatural death, my lord, in police, what they will do, my lord, they will exhume the dead body. Then, as per the manual, my lord, they will do the process.
These are
my
all
lord.
different situations. This is a peculiar situation.
But I agree, my lord.
That situation cannot be juxtaposed here. That won't help. What is the executive magistrate? Once then if he is directionless, then what will he follow?
The entire proceeding has to be videographed, my lord. Then after that, my lord, it has to be.
Where is that procedure to be given? That
I will find out from the executive magistrate, my lords.
See,
What-
one is this only speaks of exhumation, not
Please.
the reburial.
In the
So after exhumation, my lord, they have to
8.7,
rebury
my
again,
lords,
my lord.
8.7, which was read out to my lords by the manual of executive magistrates, 8.7 Roman 7 says that the body may be handed over to the relatives of the deceased after the post-mortem
Now,
examination,
if the
depending
relatives
upon
don't
the
want to
fact.
take it, what happens?
That is also.
He is on record, my lord. Already they are responding.
He doesn't want to take that responsibility. He is very clear.
I will get back to my lords on this.
He is very clear on that.
They are opposing the exhumation.
So you'll have to give us this one. The Additional Advocate General has filed a memo enclosing a letter of the letter dated 15/7/26 of the Principal Secretary Panchayat Raj Department addressed to
To us only.
the Additional Advocate General. On the basis of the said submissions, he submits that a proposal is taken up with the Law Department to amend the Karnataka Gram Swaraj and Panchayat Raj Act 1993. When will this be completed?
My lords, August, we are starting the new session, my lords. Be 30 days, I request.
And in the meanwhile, you give us this.
I'll get this
He
instruction.
seeks for 30 days time. Relist on 17th
Requesting
August.
for 2 months time. Department. Okay, we'll again request.
We'll have it on 17th, see if it can finish it.
Please. Let me.
Bill number 11. AP Bhuvan, connected matter.
Respond number 1 and 2, process fee.
They have
Yes,
to
ma'am,
pay
I have to file.
deficit.
Nimda adu.
None per. Tomorrow I'll do that.
Counsel for the petitioner in 11 seeks for and is granted 2 days time to make payment of the deficit process fee. Deficit process fee is paid. Registry is directed to issue notice to respond number 1 and 2 returnable by 24th August if deficit processing is not paid by end of day 17th July, relist on 22nd July for
Yes,
dismissal.
first matter. Interim order may be extended.
Interim order earlier granted.
And regarding second matter, my lord, 11.1, that is not connected to this one because of that is a first matter. Surface Act, my lord, they are not complied with the order. They are not paid the EMI. They put paper action. So I filed a writ petition and obtained interim order. I paid the amount. So let them address arguments on regarding 11.
Take it up on that day. There's an interim order now.
Yes.
Interim order granted is extended till next date of hearing.
Well, in 11.1 also there is an interim order.
Both of them, common order.
A short date that is not connected with my lord. Because 11.1 is my son is not paying the EMI. He has filed affidavit before this.
De-linked and I will.
I'm a senior citizen. This one.
Senior citizen matter.
Yes,
Well, it may be.
Then why the DRT matter connected?
my
with
lord, because of they are not they have obtained the loan.
EMIs.
They are not paid the EMI. So action ಬಂತು ನಾನು I am reciting that. So ನಾನೇ ದುಡ್ಡು ಕಟ್ಟಿ gold ಇದನ್ನ ಮಾರಿ ನಾನೇ amount ಕಟ್ಟಿದ್ದೀನಿ.
Lords, one submission, my lords, when he. when
11
petitioner
kodi adu, who are the parties?
is ready to receive the same, my lords. Here the petitioner, my lords, he is ready to pay, but the bank is not ready to receive the loan amount, my lords. May kindly be directed the bank to receive the amount by the petitioner itself, my lords.
No, my lord, because I
What
paid.
they have stated, my lords.
Because he has
Party
paid,
is
why will they
present, my
receive it from you?
I paid 2.5 lakh.
We are ready to pay back to mother, my lords.
My
Then
lord,
pay to your father,
Mother.
Mother, my lords.
mother.
Please, my lords, we are ready.
my lord, they
Authorized officer, Induja Housing Finance.
Yes,
Induja
my
Housing ಯಾರಮ್ಮ?
Hinduja, they have to await notice.
ಯಾರು ಇಲ್ವಾ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್?
ಅದು private finance, my lord.
ಯಾರು ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಇಲ್ವಾ? ಯಾವ್ದು
ಯಾರು
ಮ್ಯಾಟರ್ಸ್
ಇದು
ಇಲ್ವಾ?
standing counsel. I'll serve the copy personally taken up next week.
Permitted to take out hand summons on respond number 1 and 2.
Yes, my lord.
Relist on
Next week.
3rd August.
Serial number
Serial number 14, my lord.
There was a direction by your
serial
lordship,
numbers.
either to serve a copy to me or to pay proceeds. Neither of them is done, my lord.
92.
92.
We can't take up all those.
But
things.
but-
Serial number 70.
End of the list ಇದೆಯಾ ಇನ್ನು?
But interim
Serial
order
number
may not be-
14, my lord, the second list, 230 madam.
We don't have the file in front of us for to pass any order, madam. 87. ಏನ್ ಮಂಜುನಾಥ್?
ಅಕ್ಕಿ ಮಂಜುನಾಥ್ ಗೌಡ.
Mr. Manjunath Gowda. We list tomorrow.
Serial number 14, list 2, my lord. Yesterday's matter, my lord, the KPSC matter.
Tomorrow.
Some championship, my lord, if they.
Preliminary hearing
my lord,
matter.
at least
ಇದೊಂದು
for some
ಕೆಲ್ಸ ಮಾಡಿ.
interim protection.
Second list ಏನೇನಿದೆಯೋ ಎಲ್ಲ tomorrow. Repeat.
Serial number 70 in the
Some
first
interim
list.
protection may be given, my lord. Otherwise, my lord, now the.
To hear
That's
you
clear
and
opposition.
pass order.
There's no question.
Heard you yesterday.
Lordship, my lord, located interim order so far as other matter is concerned, my lord. There, my lord, now if they proceed to ratify in my absence,
That matter is not
my
there before
right
the court.
will be defeated, my lord. That is the reason why.
That matter is not listed today.
We are
Not listed, but if.
We are
interim
only
order is not
concerned
granted,
with-
I will not be able to participate.
3171 and 3172 is what we are concerned with. We need to look at those judgments. It will require some application of mind. We
Even,
can't
my lord, aid and
say
assistance
take
of
an
the-
interim order like that. We'll take it tomorrow.
Serial number 70 in list 1. It was posted for being spoken yesterday. Now the matter was for admission. Kindly have it tomorrow. Your Lordship. Serial number 70 in list 1.
ಏನಕ್ಕೆ ಅದು? Hmm? 70. 70 on next week.
First list,
Serial number.
serial number 57.
Asian championship.
First list, serial number 57, preliminary hearing, my lord, the SIR matter. Some consideration, my lord, at the earliest.
It will come up. How do we take it up, Mr.
Well, any date, you lodge may fix at a half.
Date will be given by.
There are no precedents on this issue. So that is the reason that.
Please top of the list, my lord.
230 list ಬರತ್ತಪ್ಪ.
Your lordship, Asian championship matter. Serial number 130, your lordship. Asian championship issue.
ನಾವು ಬಿಡ್ಲಿಲ್ಲ ಮೇಡಮ್. ನಮಗೆ ಬಿಡಿಸಿದ್ದಾರೆ ಅಂದ್ರೆ ಇಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ.
ಸರ್ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಎಲ್ಲ ನಾಳೆ ಫಾಸ್ಟ್ ಅವರ್ಸ್ ನಾಳೆ ಇದೆಲ್ಲ 10th August.
Madam, interim order election.
102.
47 no?
First list.
10th August.
Madam, serial number 47.
ಅದನ್ನೇ ಅಲ್ಲಿ ಹೇಳಿದ್ದು.
Madam,
Madam.
10th August.
Madam.
ಬಂತು.
Madam, serial
ಒಂದೇ ಅಲ್ವೇನಮ್ಮ 233 ಇದ್ದಿದ್ದು?
Madam, serial number 47 no?
230 ಇದೆ ಹೇಳಿ.
Madam,
ನಾಳೆ ಮೆಮೊ ಬುಕ್ ತಗೊಂಡು.
Madam, serial number 47 no?
ಎಲ್ಲ 10th August.
ಎಲ್ಲ 10th
ಅಲ್ಲ 92
ಎಲ್ಲ
ಎಲ್ಲ 10th.
ಎಲ್ಲ 10th ಇಂಟಿಮ
ಮೇಡಮ್ 110 ನಾಳೆಗೆ ಹಾಕಿ.
ನಾಳೆ ಇಲ್ಲ.
ಹಾ
10th August.
ಹಾ
ಹೇಳಿದ್ರೆ
ನಾನು ಮಧ್ಯಾಹ್ನ ಮೆನ್ಷನ್ ಮಾಡಿದ್ನಲ್ಲ ರೀಚ್ ಆಗುತ್ತೆ ಅಂತ. ಹಾ ಡೇಟ್ ಅಲ್ಲ, ಮಧ್ಯಾಹ್ನ ಇವಾಗಲೇ ತಗೊಳ್ಳಿ ಅಂದಿದ್ದಕ್ಕೆ ಅವ್ರೆ. ಅಲ್ಲ ಮೇಡಮ್ ಆಯ್ತು 110 ನಾನು ಮೆನ್ಷನ್ ಇವಾಗ ಯಾವ್ದು ಕೊಟ್ಟಿದ್ದೀರಾ? ಇಲ್ಲಮ್ಮ ಅದು ಬಹಳ ಅರ್ಜೆನ್ಸಿ ಇದೆ. ಅದು 110 ಬೇಕಾದ್ರೆ ನಾನು ಚೇಂಬರ್ಗೆ ಹೋಗಿ ಹೇಳ್ತೀನಿ. ಹಂಗಾದ್ರೆ ತುಂಬಾ ಪ್ರಾಬ್ಲಮ್ ಇದೆ ಅದು.
ಹೇಳಿದ್ರೆ ಮಾಡಿ. ನನಗೆ ಹೇಳಿರೋದು 10th August.
ಎಲ್ಲ 10th ಆಗಸ್ಟ್ ಇಂಟ್ರಿ ಮಾಡಿಸ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಲ್ಲ.
ಈಗ
ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಮ್ಯಾಟರ್
ನಾಳೆ ಫಾಸ್ಟ್ ಅವರ್ಸ್ ನಾಳೆ.
ಅಲ್ಲ ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಮ್ಯಾಟರ್ ಮೇಡಮ್ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ 3 ಮ್ಯಾಟರ್ ಅಷ್ಟೇ ಇರೋದು.
ಇಷ್ಟು ನಾಳೆ ಯಾವ್ದಿದ್ರು ನಾಳೆ ಇಷ್ಟು ಇದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ. ಇಲ್ಲ ನಾನು ಹೇಳಿರೋ 10th August. ಇಷ್ಟು ಒಂದು 10th August. 10th August.
ಮೇಡಮ್ ಮೇಡಮ್
ನಾಳೆ ಬಂದು ಮೆಮೊ ಕೊಡಿ ಮತ್ತೆ ಯಾವತ್ತಿಗೆ ಬೇಕು ಅವತ್ತಿಗೆ.
ಮೇಡಮ್ ಲಿಸ್ಟ್ ಒನ್ ಅಲ್ಲಿ ಆರ್ಡರ್ಸ್ ಕರೆದಿದ್ದಾರೆ ಮೇಡಮ್.
ಇಲ್ಲ 10th August.
ಶಾರ್ಟ್ ಡೇಟ್ ಇಲ್ವಾ ಮೇಡಮ್ ಆರ್ಡರ್ಸ್ಗೆ?
ಇದ್ರೆ
ಓಕೆ
10th August. 10th August. ರೀಚ್ ಆಗಲ್ಲ. ನಿನ್ನೆ 7 ಕೊಟ್ಟಿದ್ದು ಡೇಟು. ಆಮೇಲೆ ಸ್ಯಾಟರ್ಡೆ ಸಂಡೇ ಬರುತ್ತೆ 10th. ಇವತ್ತು ಎಲ್ಲ ಅದೇ. ಯಾರಾದ್ರೂ ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಿ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ನಿಮ್ಗೆ ಯಾವಾಗ ಬೇಕು.
I'll just check, madam. Yes, madam, it is there. Thankful, yes.
ಏನು ಅಪ್ಲೋಡ್ ಆಗಬೇಕಾ ಅದು?
Allah, back also save us sometimes. Thank you. Sometimes.
ಆವಾಗಲೇ ನನಗೆ ಹೇಳಿದ್ರೆ ನನಗೆ ಹೇಳ್ಬೇಕು. ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್ ಇನ್ಯಾರಿದ್ದೀರಾ? ಆಗತ್ತೆ 61 ಯಾವತ್ತು ಬರ್ತೀರಾ ನೀವು? ಡೇಟ್ ಹೇಳಿ. ನೀವೇ ಕಾಯ್ಬೇಕಲ್ವಾ, ಅದಕ್ಕೆ ನೀವೇ ಡೇಟ್ ತಗೊಳ್ಳಿ. ಅಲ್ಲಿ ಆಗುತ್ತಲ್ಲ ಗೊತ್ತಿಲ್ಲ. ರೀಚ್ ಆಗೋದು ಗೊತ್ತಿಲ್ಲ ನನಗೆ. ಅದೇ 24 ಅಲ್ವಾ ರೀಚ್ ಆಗ್ಬೇಕಿತ್ತು. ಇವತ್ತು ತುಂಬಾ ಮ್ಯಾಟರ್ಸ್ ಇರೋದ್ರಿಂದ ಆಗಿಲ್ಲ ಅಷ್ಟೇ. ನೀವ್ ಹೇಳೋ ಡೇಟ್ ಹೇಳಿ ಅವತ್ತು. 22nd. ಇನ್ಯಾರು ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್ ಯಾರು ಇಲ್ವಾ? ನಿಮ್ದೊಂದಿದ್ಯಾ? ಅಲ್ಲ ಅವೈಟಿಂಗ್ ಸರ್ವಿಸ್ ಇರೋದ್ರಿಂದ ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ಬರುತ್ತೆ. ಎಲ್ಲ ಗೊತ್ತಿಲ್ಲ. ನಮ್ಮ ಆಫೀಸ್ನವ್ರು ಏನೋ ಆರ್ಡರ್ ಫಾಲೋ ಮಾಡಿಲ್ಲ ಅಂತ ಅನ್ಸುತ್ತೆ. ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಇತ್ತು ಅವೈಟಿಂಗ್ ಇತ್ತಲ್ವಾ. 10th August. ಒಂದ್ ಕೆಲ್ಸ ಮಾಡಿ, ಇವಾಗ 10th August ಕೊಡ್ತೀನಿ. ನಾಳೆ ಬಂದ್ ಮೆಮೊ ಹಾಕೊಂಡು ಯಾವಾಗ ಬೇಕು ಅವಾಗ ಹಾಕಿಸ್ಕೊಡಿ.
ಮೇಡಮ್ ಜಿ 92 ಅದು TI ಎಕ್ಸ್ಟೆಂಡ್ ಆಗ್ಬೇಕು. ಮತ್ತೆ 21ನೇ ತಾರೀಕು
21 ಎಲ್ಲ ಇಲ್ಲ 10th August.
ಮೇಡಮ್ ನಾ ಬೆಳಗ್ಗೆ ಆಗಸ್ಟ್ ಬೇಡ ಅಂತ ಹೇಳಿನಿ. ಇವತ್ತು ಸಾಯಂಕಾಲದವರೆಗೂ
ಆಗಸ್ಟೇ ಕೊಡೋದು. ಬೇಡ ಅಂತ ಹೇಳಿದ್ ಯಾಕೆ ಅಂದ್ರೆ ಇದೆ
ಮಂತ್ ಎಂಡ್ ಅಲ್ಲಾದ್ರೂ ಕೊಡಿ ಮೇಡಮ್ ಪ್ಲೀಸ್.
10th August.
ಡೇಟ್ ಕೊಟ್ರಾ ಮೇಡಮ್ ನೀವೀಗ?
ಸೀರಿಯಲ್ ನಂಬರ್ 1 ಯಾವ್ದು ರೀಚ್ ಆಗಿಲ್ವೋ ಎಲ್ಲ 10th August
ಡೇಟ್ ಕೊಡಿ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ನಿನ್ನೆ 7th ಕೊಟ್ಟಿದ್ದೀನಿ. ಇವತ್ತು 10th ಕೊಡ್ತೀನಿ.
ಮೇಡಮ್ TI ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತಲ್ವಾ? 10th August ಕೊಟ್ಟಿದ್ದೀರಾ?
ನಂಗೆ ಗೊತ್ತಿಲ್ಲಪ್ಪ. ನಾನು ಬರ್ಕೊಂಡೆ. ನಾನು ಯಾವಾಗ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡ್ಲಿ? ನನಗೆ ಈ ಫೈಲ್ಸ್ ಎಲ್ಲ ಮುಗಿಸೋದಕ್ಕೆ ರಾತ್ರಿ 8 ಗಂಟೆ ಆಗುತ್ತೆ. ಎಂಟ್ರಿ ಮಾಡ್ರಿದ್ಯಾ ಇಲ್ವಾ ಎಲ್ಲ ನೋಡಕ್ಕೆ. ಒಂದ್ ಫೈಲ್ 1 ನಿಮಿಷ ಅಂದ್ರು 50 ಫೈಲ್ಗೆ 1 hour ಆಯ್ತು. ನನಗೆ ಗೊತ್ತಿಲ್ಲ, ನಾಳೆ ಬೆಳಗ್ಗೆ 10:30 ಮೆಮೊ ಹಾಕು. ಯಾವಾಗ ಬೇಕು ನಾಳೆ
Madam, 127, 127,
127 10th August.
10th August, August.
75 ಮೇಡಮ್.
ಇಲ್ಲ ಬರೀ ವಿಡ್ರಾಲ್ ಮಾಡಕ್ಕೆ ಬರೀ ವಿಡ್ರಾಲ್ ಮಾಡಕ್ಕೆ ಫೈಲ್ ಮಾಡಿ. ರಿಟ್ ಪಿಟಿಷನ್ ಸ್ಕ್ರೂಟಿನಿ ಬೆಂಚ್ ಸ್ಟಕ್ ಆಗಿದೆ.
130
127.
127 ಬೆಳಗ್ಗೆನೆ ವಿಡ್ರಾ ಆಯ್ತಲ್ವಾ? ಬೆಳಗ್ಗೆನೆ ವಿಡ್ರಾ ಆಯ್ತು.
ಇಲ್ಲ ಮೇಡಮ್, ಬೆಳಿಗ್ಗೆ
ಆಯ್ತು, ನಾನೇ ಹೇಳಿದ್ದೀನಿ.
ಹೌದು, ನಾವು 14% ವಿಡ್ರಾ ಆಯ್ತಾ?
ವಿಡ್ರಾ ಆಗೋಯ್ತು ಅದು.
ಆಗೋಯ್ತು.
ಬೆಳಗ್ಗೆನೆ ಆಗೋಯ್ತು. 75 ನೋಡಿ ಗೊತ್ತಾಗುತ್ತೆ.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
Madam, 90.
10th August. 75 ಮೇಡಮ್. ಹೌದು. 10th August. 70 ಅಂತ
Madam, 90.
ಇಲ್ಲ, ಏನು ಹೇಳಿಲ್ಲಪ್ಪ. 70 ಅವ್ರು ಯಾರೋ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರು, ನನಗೆ ಡೇಟ್ ಕೂಡ ಕೇಳಿ 10th August. 75 ಮೇಡಮ್. 75 10th August. ಇದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ 70. ನಾಳೆಗೆಲ್ಲ ರೀಚ್ ಆಗೋ ಚಾನ್ಸ್ ಇಲ್ಲ. 10th August ಹಾಕ್ತೀನಿ, ನೀವು ಮೆಮೊ ಮೂವ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಷ್ಟೇ. ಯಾವತ್ತಿಗೆ ಬೇಕು ಹಾಕೊಳ್ಳಿ ಮೆಮೊ. ಬೆಳಗ್ಗೆ ಬನ್ನಿ ನಾಳೆ 10:30. 80 10th August ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ. ಅದು ಅಷ್ಟೇ 10th. ಅದಕ್ಕೆ ಮುಂಚೆ ರೀಚ್ ಆಗಲ್ಲ. 10th August. 68 10th August. 10th August. BC 64 ಕೂಡ 10th August. ಏನಮ್ಮ?